10 days time, Lordship.
The request of counsel for respond number 1 to 4 released on 11th February.
Grateful, Lordship. Great.
Serial number 78, Lords. I appear for respond number 3. Lords, recently I filed wakalat in this matter. I need to file objections.
Informed.
Other side petitioner is here.
78, learned counsel for respond number 3 seeks for and is granted 10 days time.
2 weeks, Lords.
2 weeks time to file a statement of objection. Objections, if any, by 13th, relist on 18th.
Please. Interim order has to be extended.
Interim order earlier granted is extended till next day.
Please.
List 2, na? Counsel for the petitioner seeks for and is granted 10 days time to make payment of necessary process fee and furnish copies in respect of unserved respondents. If needful is done by 7th, registry is directed to issue notice to the unserved respondent returned by 16th April. If needful is not done by 7th, relist on 13th for dismissal.
Interim order. Oh, petitioner, serial number. Interim order.
Interim order. ಯಾವ್ದಾದ್ರಲ್ಲಿ ಇದೆಯಾ extend ಆಗುತ್ತೆ.
Serial number 11, my lord.
One ನಿಮಿಷ 2. Counsel for the petitioner seeks for and is granted 10 days time to 2 weeks time to make payment of necessary process fee and file necessary application to bring the legal representative of deceased respond number 4 on record. If needful is not done by 13th, relist on 19th for dismissal.
Lord, I appeal the petitioner. My lord, I pray for 2 weeks time, my lord. The settlement is going on between the parties.
Counsel for the petitioner submit that settlement talks are in progress.
Yes.
Are advanced stage.
No, advanced stage.
Are in advanced stage. Given 2 weeks time, settlement would be endeavored to be reported. Relist on 20th February at
Please.
2:30 PM.
Please.
4 to 20. ಯಾವತ್ತು ಹಾಕ್ಬೇಕು?
Lords.
4 to 13, 17th.
Your Lordship,
Lord,
15th.
item 8, your Lordship may recall yesterday I mentioned.
ಯಾವ್ದು? List 2 ನಾ?
List 2 ದಲ್ಲಿ.
ಒಂದು ನಿಮಿಷ. 4 to 13, 17th. 14 to 20th, 18th.
7, Your Lordship, after 18th, Your Lordship.
ಯಾವುದು?
7, Your Lordship.
7 ಮಾತ್ರ 5th March. ಯಾರು ಅಪೇರ್ ಆಗ್ಬೇಕಾ?
But Your Lordship, first week I am having inconvenience. Up to 15.
ಯಾವ್ದು? 18th ಹಾಕಿರೋದು. 18th, no problem. Yes, what is the?
Item 8 in list 2, Lord, it's a B group matter. Yesterday, your Lordship may recall, I mentioned over the phone.
8 pass over.
Virtual.
My lord,
Yes.
I'm filing the memo of retirement, my lord, and for respondent number 1. Respondent number 1 is present, my lord. Your lordships had directed me to secure his signatures on the retirement memo. I've got his signatures in
Yes.
filing this.
Who is going to appear for you? Hmm? We are not going to give any adjournment and ನೆನ್ನೆನೇ ಹೇಳಿದ್ದೀವಿ. Bad luck. ಇವ್ರು ಬರ್ತೀನಿ ಅಂತ ಹೇಳಿ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿದ್ದಕ್ಕೆ ನೀವು ಇವತ್ತು ಅಡ್ವೊಕೇಟ್ ರಿಟೈರ್ ಆಗಿ ಹೊಸ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಅಂದ್ರೆ ಏನು? ಇಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
It's a very short issue, Lord.
But lawyer
ಅವರಿಗೂ ಏನು, I don't think, your Lord, I would be insisting on passing any order which will prejudice him.
if he is asking for, is there an interim order?
Sorry, my Lord.
Is there interim order in the matter?
There is no interim order. There is no interim order.
Grant the interim order
There is
until
no
he
interim
appears and gets ready. We'll take it up later. First.
My lords, on submission.
ಇಲ್ಲ ಇವಾಗಲೇ ಕೊಟ್ಬಿಡಿ, ಅದು ಫೈಲ್ ಇದೆಯಾ? ಕೊಡಿ. ಆ ಲಿಸ್ಟ್ ಮುಗಿದೋಗುತ್ತೆ.
My lords, on submission. 230, my lords.
ಏನು?
The TC order, my lords, it was a land acquired, my lords, LAC, and there is a court decree, my lords. Setting aside, my lords, the civil court judgment, my lords, the DC has ordered to refund the amount, my lords, which has been awarded. Now notice is issued to me, my lords, to refund. Yes, my lords.
Good.
Please.
Yes, Mr. Agne. Ms. So-and-so has filed a memo of retirement. Illama? A memo dated 29/1/25 signed by the counsel for the petitioner and the respondent number 1 in person. accepting the said memo, the Shri A.P. Murari is permitted to retire from the matter, is discharged from the matter. Respondent number 1, who is present in person, seeks for and is granted a week's time to engage another counsel. However, since the counsel for the petitioner submits that no reliefs are sought for against respondent number 1, and
No, Lord, my submission is there will not be any prejudicial order that will.
that we can't say, that you
Lord,
can't
it's
say.
only reconstruction of a document which is lost in the court safe custody.
To wait for a week, Mr. Hegde, when the advocate is changing. If you are not seeking for any relief against respondent number 1, we'll take it up.
I'm only seeking a direction to the court, Lord, to trial court to dispose of the suit, Lord. That direction I would insist. Because I will not be insisting on the order which I challenged before the honorable court. A original document which was in the safe custody of the trial court is lost, Lord, and there is an order to reconstruct the document. My initial reaction to that order was, Lord, it's a
Now
suit
you have no
document.
objection for reconstruction.
Suit for specific performance based on that document. It can't. Other document.
ಕ್ಲಾರಿಫಿಕೇಶನ್ ಇವತ್ತಿಗೂ ನನಗೆ ಸಿಗ್ತಾ ಇಲ್ಲ ಸರ್.
We'll allow it directly
ಅದು
trial
ಕೊಡ್ತಾರೆ,
court to
ಯಾರು
dispose the matter
ಕೊಡ್ಲಿಲ್ಲ.
at the earliest 2014 suit.
ಅದು ನಾನ್ ದುಡ್ಡು ತುಂಬ್ಲಿಕ್ಕೆ ಅಂತ ಹೋದವನು ಇವರು ಇಲ್ಲ ಅಂತ ಮಾಡ್ಬಿಟ್ರು. ಇವತ್ತಿಗೂ ನನಗೆ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಕೊಡ್ತಾ ಇಲ್ಲ ಯಾರು.
Having heard the learned counsel for the petitioner,
ಅದನ್ನ ಸ್ವಲ್ಪ ಕಾಲಾವಕಾಶ.
I have the considered opinion that no prejudice would be caused to the respondent if the matter is taken up today and orders passed in view of the proposed orders to be passed. Petitioner is before this court seeking for the following reliefs. Suit in voice number 156 of 2014 had been filed by respondent number 1 wherein the petitioner has been arrayed as defendant number 4 seeking for specific performance of contract dated 1/5/2012 and other consequential relief. In the said suit, an application in IN number
Lord, it's an order by the court, Lord, on the
page,
your lordship will get that order on page number, annexure A, Lord, on page number 19, Lord. Turn to 19. It's not on any application file.
in the said case, the original agreement of sale dated 3/8/2010 and 1/5/2014 were directed to be kept in safe custody of the court. However, subsequently, the said documents were not traced. As such, the court, by its order dated 25/2/2022, so moto directed the office to reconstruct the said documents by following a circular issued by this court dated 16/10/2022. Shri Ganapati Hegde, learned senior counsel appearing for the petitioner, would today submit that he would have no objection for the said reconstruction of the document in terms of the aforesaid circular. However, considering that the suit is of the year 2014, he submits that the said reconstruction to be effected expeditiously and the matter proceeded with. I do not find any, I find favor in the said submission. In that view of the matter, the above petition is disposed with a direction to the trial court to get the document reconstructed at the earliest and proceed with the matter and dispose of the suit as expeditiously as possible.
Your lordship may fix a time limit,
Can't
not
fix
otherwise.
time, there are so many matters pending.
Lord, if I may persuade your lordships to.
The Supreme Court has clearly said now that time should not
Lord,
be
the
fixed.
very.
We
very-
won't fix times, Mr. Hegde.
ಇಲ್ಲ ಇಲ್ಲಿ ಬಂದಿದ್ದೆ ಅದಕ್ಕೆ reconstruction ಮಾಡಿ ಅಂದ್ರು there were no steps taken. It was just going on because I am the sufferer. My property is stuck in the litigation, Lord. My property, absolute property based on a forged document.
Stage ಏನಿದೆ suit?
It is plaintiff's evidence.
ಇನ್ನ plaintiff evidence ಆಗಿಲ್ವಾ?
I think it commenced and at that time when the document had to be marked,
ಸ್ಟಾಂಪ್ ಡ್ಯೂಟಿ
it got stuck.
ಸ್ಟಾಂಪ್ ಡ್ಯೂಟಿ ಇದಕ್ಕೆ ನನಗೆ ದುಡ್ಡು ತುಂಬಿ ಅಂತೇಳಿ ಆಫೀಸಿಗೆ ಕಳ್ಸಿಕೊಟ್ಟಾಗ ಜಾಗ ಇಲ್ಲ, ಇದು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ದು. ಸ್ಟಾಂಪ್ ಡ್ಯೂಟಿ
ನಿಮ್ ಮಾರ್ಕಿಂಗ್ ಆಫ್ ಎವಿಡೆನ್ಸ್ 11 ವರ್ಷ ನೀವು ಎವಿಡೆನ್ಸ್ ಮಾಡಕ್ ತಗೊಂಡಿದ್ದೀರಾ.
ಅಲ್ಲ ಸರ್, ಇವ್ರು ಸ್ಟಾಂಪ್ ಡ್ಯೂಟಿ ಅಬ್ಜೆಕ್ಷನ್ ತೆಗೆದ್ರು.
ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ತಗೊಂತಾರೆ. 11 ವರ್ಷ ನೀವ್ ಯಾಕೆ
ಅಂತ
ತಗೊಂಡಿದ್ದೀರಾ?
ಹೇಳಿ ಹೋದಾಗ
Within a period of 1 year from the date of receipt of a copy of this order. Yes.
Obliged.
Notice issued to respond number 7 is returned with the endorsement refused, and service in respect of respond number 7 is held sufficient. Registry is direct print the name of respond number 7 with the endorsement refused.
Your Lordships, NOC has been given, my Lordships. And also you have filed a memo for retirement.
You are for whom?
A petitioner.
Shivraj Baldali has been permitted to retire. ಯಾಕೆ ಅವ್ರ ಹೆಸರು ಯಾಕೆ ಇನ್ನ ಕಂಟಿನ್ಯೂ ಆಗಿ?
Name may be deleted, Your Lordships.
By way of order dated 7/1/2025, Shri Shivraj Baldali was permitted to retire. Hence registry is directed delete his name as that appearing for the petitioner. And who appears for the petitioner? Despite the order dated 7/1/25, there is no appearance made by the petitioner today. It appears that the petitioner is not interested in prosecuting the matter. Petition is dismissed for non-prosecution.
Please.
No appearance made, no process fee has been paid.
My lord, or the petition, last time, my lord, on the last date of occasion, my lords passed an order that if none represents, my lord, the petitioner, the petition would be dismissed.
Yes.
I have filed, my lord, application recalling the order. I am respond number 3. Without my, my lord, knowledge, they have filed, my lord, compromise application in the petition and got it remanded, my lord, to the tribunal. And my lord, on that application, notices were issued on me. I filed objection stating that I am not aware of that compromise, because that compromise, my lord, was entered by the petitioner with the GP holder.
Where is your application, IA number?
IA number 1 of 2019.
IA number? One of 18 and 17.
Please.
What is your IA number for recall?
IA number 1 of 2018, my lord. My lord, immediately after passing of the order, when I got, my lord, notice, I filed this application. I was not aware, my lord, of the compromise.
ಆಯ್ತಪ್ಪ 18 ಇಂದ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಅಲ್ಲ, ಅವ್ರು ಅಪಿಯರಿಂಗ್ ಆಗ್ತಾ ಇಲ್ಲ. Petitioners are not at all appearing.
ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಅಂತ ಹೇಳೋದು ಬೇಡವಾ?
ಅಲ್ಲ,
ನೀವು ಅಪೇರ್ ಆಗಿಲ್ಲ ಲಾಸ್ಟ್.
ನಾವು ಅಪಿಯರ್ ಆಗಿದ್ದೀವಿ ಸ್ವಾಮಿ. ಅವರು ಫಸ್ಟ್ ನೋಟಿಸ್ ಕೊಟ್ಟ ಅವರು.
ಏನಲ್ಲಪ್ಪ?
And tribunal passed the order, my lord, that I have not filed any objection. In fact, my lord, I filed objections before the tribunal.
1 of 20.
Though they appeared before the tribunal, my lord, they are avoiding, my lord, before this honorable court.
24/9/2008.
Please, my lord. I came to know regarding this order only when I am issued with the notice by the tribunal on the compromise petition. I, my lord, approached the court and filed my objections, which I produced, my lord, at page number 17 to 18 to the application as annexure R6.
Where is that compromise petition?
It is in the,
Compromise petition.
sir.
ಇಲ್ಲಿದೆ.
My lord, I produced it, my lord, in connected date petition as Annex D.
One 13669 al ನೀವು your respond number.
My lord, respond number 3. Lord, Lord, since she was, my lord, aged, she was represented by, my lord, GPA holder. That GPA holder, my lord, has taken, my lord, misused, my lord, the GPA. And, my lord, in collusion with petitioner, they compromised. They have not informed me, my lord, regarding that. It's a tenanted land, my lord. Tenancy has been granted to me. Landlord is in, my lord, petition, questioning, my lord, the grant of occupancy rights. And compromise.
What has happened after, before the tribunal, after this?
My lord, I appeared, my lord, and I filed my objections, stating, my lord, that I have not given any authority to the GPA holder to compromise. Though the objection is taken on record, the trial court, the tribunal, my lord, in the connected writ petition, my lord, I challenged the order. At page number 71 of the order portion, my lord, ಇದಕ್ಕೆ ಯಾರದೇ ತಕರಾರು ಇರುವುದಿಲ್ಲ, ಕಾರಣ ಮಾನ್ಯ ಉಚ್ಚ ಪೀಠದ ಆದೇಶ ಸಂಖ್ಯೆ ಪ್ರಕಾರ ಕಾಂಪ್ರಮೈಸ್ ಪ್ರಕಾರ ಅವರು ಆರ್ಡರ್ ಮಾಡ್ಬಿಟ್ರು. 33 ಗಂಟೆ 2 ಎಕರೆ 5 ಗುಂಟೆಯಲ್ಲಿ 33 ಗುಂಟೆ ನನಗೆ ಕೊಟ್ಟು ಉಳಿದಿದ್ದು 1 ಎಕರೆ 10 ಗುಂಟೆ ಓನರ್ ಕೊಟ್ಬಿಟ್ರು. Though I taken an objection before the tribunal. I filed the objection, my lord, on 9/11/2017. The order came to be passed, my lord, by the tribunal on 7/3/2018.
You authorized him to compromise in the power of attorney which you have issued on 9/8/2008.
Please,
Clearly authorized him to compromise.
my lord, my lord, regarding, my lord, but he has, my lord, he has given 1 acre 10 guntas, my lord, to the owner.
Why did you give, if you don't, if
My lord, my lord, she is an
power of attorney to a person?
my lord, I disputed, my lord, she is an illiterate. It was in English. She was not read over. She put, my lord, put her thumb impression, and taking, my lord, that they came before the court and filed wakalat, and, my lord, got it compromised.
How do you say she is illiterate? She has signed it.
No, thumb impression, my lord. It's a thumb impression.
Power of attorney,
Thumb impression. LTM of,
Kamlakar, petitioner.
ಹೌದು, ಇದು LTM of Gange, wife of Buddu Gowda ಅಂತ.
ಇದು Narayan, son of Janu Naik. You cannot be allowed to take this contention after such a long lapse of
My lord,
time.
I came to, I came regarding this compromise. He would have informed me, my lord, that regarding compromise. He has not informed me. Immediately, my lord, when I gained knowledge after receipt, my lord, of the application.
If we accept your submission, then we can't accept any GPA before this court.
My lord,
What is the point in issuing a
Lord,
GPA if you say your
my
GPA?
lord, she,
Take action against your GPA, not against this
Lord,
order.
now I have also challenged, my lord, the order passed by the tribunal before this honorable
That
court.
we'll consider, but this recall will not happen.
My lord, if it is not recalled, it has got a
dismiss ಆಗತ್ತೆ ಆಮೇಲೆ.
it has got a bearing on my,
It will have a bearing, it will get
Lord,
dismissed also.
that's the reason, my lord, they are not at all appearing before this honorable court.
Permit you to do this, Mr. Nanda.
My lord, my lord, she is an illiterate. She's,
Then
my lord, she is not.
everybody will come and say I'm illiterate because every farmer is illiterate.
Lord, even
Then
there
ask
is,
the litigants before
my
this
lord,
court
even
will
there is
come and
nothing,
say,
my lord, on record to show that it
please
has
let
been.
the bar take a decision that no power of attorney will appear before this court. Then we won't permit any power of attorney. That kind of a submission cannot be
My lord,
acceptable.
my humble submission, is, my lord.
You humble or payment submission or yen submission, I don't know, we can't accept it.
My lord.
If we accept it, then there is no sanctity
My
to
lord,
any compromise.
My lord, I fought it, my lord, for 33 long years. My lord, they have taken, my lord.
Proceed against your power of attorney. Not in this court.
My lord,
Fraud, everything you proceed against him. Recover this one. Not before this court,
my
when
lord,
a compromise is entered.
my petition, my lord, challenging the order passed by the land tribunal. My lord, land tribunal says that I have not objected for the.
Obviously, when the compromise is there.
My lord, my lord, definitely I have objected by filing my objections before the land tribunal.
We'll consider that differently. This one we
My
can't
lord,
accept.
my lord, if my lords consider that petition, my lord, first. And
First, this has to go, then we'll come to that. On merits
my
of
lord,
that, we'll consider.
may I
But that won't be considered on the basis of this compromise being set aside. That cannot be done.
No, I'm not saying, my lord, that if my
Court.
lords, my lord,
Just a moment.
pass any orders on application.
This
let-
court-wide order dated 24 September 2008, accepting the compromise petition which had been filed, remitted the matter to the land tribunal for modification of the order passed by the land tribunal in terms of the compromise petition. On remittal, notice having been issued to respond number 3. Respond number 3 contending that she had not authorized the power of attorney order to compromise the matter as filed IA 1 of 18 and 1 of 17. IA 1 of 18 I mean filed.
my lord, one submission, may I make a, but one submission.
Yes.
You'll
yes.
also kindly see, my lord, there are two GPAs. my lord.
One by Kamlakar, the other
One by
you.
Kamlakar, my lord, and another is by me.
Yes.
Both are, my lord, verbatim same.
Yes.
My lord, that clearly shows, my lord, that, my lord, those are, my
So
lord.
affixed your thumb impression.
I affixed, my lord. I'm not read over, my lord, the contents.
IA number,
Both are verbatim same.
file a suit. IA number
1 of 2017.
1 of 17 has been filed for recalling the order dated 24/9/2008, aforesaid order dated 24/9/2008, and IA
But compromise between landlord
Two
and
of-
tenant is not permitted, my lord, as per law.
17. There's an order passed by this court to stay the order dated 24/9/2008. The submission of Shri T.N. Nadaf, learned counsel for the petitioner, is that she had not, the respond number 3 had not authorized the general power of attorney holder to compromise the matter. The power of attorney holder has compromised the matter and agreed to the terms which are never to the knowledge of respond number 3. The contents of the power of attorney had not been read over and explained to respond number 3, who is an illiterate person who does not know English, and the power of attorney being in the English language. Amele?
Both power of attorneys are verbatim same.
And the power of attorney issued to the petitioner, by the petitioner, and that issued by respond number 3 are verbatim the same. And heard none has been appearing for the petitioner, despite several adjournments having been granted. Having heard Shri T.M. Nadab, learned counsel for respond number 3, and having perused the documents, it is seen that the compromise, the power of attorney of the petitioner, Shri Kamlakar, has been issued in favor of one Shri Damodar, son of Santappa Aigal, and the power of attorney by respond number 3 has been issued in favor of Shri Narayan, son of Janu Nayak. Hence, the power of attorney is not in favor of the same person, but is in favor of different persons. The contents of the power of attorney being identical would not in any manner make any difference, inasmuch as the terms of the power of attorney is as regards compromise of the petition. And in fact, the power of both the power of attorneys have been specifically issued for the purpose of entering into a compromise in the pending writ petition, and there is no other purpose and for entering into a compromise. The power of attorney issued in favor of by Sri Kamlakar has been the power of attorney. Sri Kamlakar has been identified by one Mr. N.S. Nayak, advocate, and the power of attorney issued by respondent number 3 has been identified by Sri A.N. Talgeri, advocate. Both the advocates being different. The contention of Sri T.M. Nadab, Learned Counsel, for the respondent number 3 is that the contents were not read over and explained. The same cannot be accepted in a proceedings of this manner. The left term impression of respondent number 3 being admitted, the identification being made by an advocate, the said power of attorney being acted upon by this court immediately thereafter, inasmuch as the power of attorney has been executed on 9/8/2008 and the compromise petition has been filed on 14/8/2008, which has been accepted by this court on 24/9/2008, indicates that all the actions have happened contemporaneously. And it is only in the year 2017 that the present applications have been filed, allegedly on the ground that it came to the notice of respondent number 3 only in that year. It is not unusual for a party to be represented by a power of attorney holder before this court and compromises being filed and the said compromise being accepted by this court. In the present case, there is no dispute about respondent number 3 having executed the power of attorney, except to contend that the contents were not known to the power of attorney. And there is fraud played by the power of attorney on the respondent number 3. If that be so, it is for respondent number 3 to initiate such proceedings as are permissible under law against the said power of attorney, and in the event of success being achieved in those proceedings, to take up this matter. Until then, a mere allegation made against the power of attorney without any action being taken against the power of attorney, that the power of attorney has acted in a fraudulent manner, cannot be accepted by this court to set aside a validly accepted compromise by this court while it's order dated 24/9/2008. In that view of the matter, IA 17 and 18, IA 1 and 2 of 2017 are dismissed. Next, buddy.
My Lord, this dismissal, my Lord, may not be.
Until you succeed, you can't do and theory. It's only a formality. Here, if there is any ground.
My Lord, the reason is, my Lord, after, my Lord, the notice has been issued, I appeared, my Lord, and filed my objections, stating that, my Lord, there is no such thing has happened. I have not issued, and it was not without my knowledge. The tribunal, my Lord, though I have filed objections, my Lord, at page number 71, your Lordship may kindly see. That's the reason, my Lord, this order has been stayed by this honorable court. ಇದಕ್ಕೆ ಯಾರದೇ ತಕರಾರು ಇರುವುದಿಲ್ಲ. ಕಾರಣ ಮಾನ್ಯ ಉಚ್ಚ ಧಾರವಾಡ
page number
71.
71.
It starts from page number 70. ಈ ರೀತಿ 30/5/2007 ಅದಕ್ಕೆ ಆದೇಶದ ವಿರುದ್ಧ ಪುನಃ ಮೇಲ್ಬಾರಿದಾರ ಕಮಲಾಕರ್ ವೈಕುಂಠ ಶಿರೋಳ್ಕರ್ ಉಚ್ಚ ನ್ಯಾಯ ಧಾರವಾಡ ಪೀಠದಲ್ಲಿ ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸಿದ್ದು 13/669/2007 ದಿನಾಂಕ 24/9/2008 ಉಚ್ಚ ನ್ಯಾಯ ಧಾರವಾಡ ಪೀಠವು ಉಭಯ ಪಕ್ಷ ರಾಜಿ ಕುರಿತು ಪರಿಷ್ಕರಿಸಿ ಪುರಸ್ಕೃತ ಆದೇಶ ಮಾಡಲು ಪರತ ಅಂಕೋಲ್ ಭೂ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಕಳಿಸಿದ್ದಿರುತ್ತದೆ. ಈ ಪ್ರಕಾರ ಭೂ ಮರು ವಿಚಾರ ತಿಳುವಳಿಕೆ ನೀಡಿದ್ದು ವಿಚಾರಣೆ ಕಾಲಕ್ಕೆ ಉಭಯ ಅರ್ಜಿ ಸಲ್ಲಿಸಿ ಬಾಳೆಗುಳಿ ಸೋ ಅಂದ್ರೆ ಈ ಪ್ರಕರಣದ 1ನೇ ತಾರೀಕು ಅಭಿಗುದಾದಂತೆ ತೀರ್ಮಾನಿಸು ಮತ್ತು ಉಳಿದ ಕ್ಷೇತ್ರ 1 ಎಕರೆ 10 ಪೂರ್ವದ ಭೂಮಾಲೀಕರ ಲೀಲವತಿ ಕೋಮ್ ಇವರಿಗೆ ಎದುರಾಗಿ ಜಂಟಿಯಾಗಿ ದಾಖಲಿಡಲು ಲಿಖಿತವಾಗಿ ತಿಳಿಸಿದ್ದು ಇರುತ್ತದೆ. ಇದಕ್ಕೆ ಯಾರದೇ ತಕರಾರು ಇರುವುದಿಲ್ಲ. Though I have filed my objections, bringing to the knowledge, my lord, of the tribunal, stating that I have not given any authority to compromise. ಕಾರಣ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಧಾರವಾಡ ಪೀಠ ಆದೇಶ ಸಂಖ್ಯೆ ಇದ್ರ ಪ್ರಕಾರವಾಗಿ ನಾವು ಕೊಟ್ಬಿಡ್ತಾ ಇದ್ದಂತೆ ಅವರು ಆರ್ಡರ್ ಮಾಡ್ಬಿಟ್ರು. I filed my objections to the before, my lord. ಈಗ ಕಾಂಪ್ರಮೈಸ್ ಆದ್ರೂ that has been sent, my lord, to the tribunal. At that time, my lord,
objection have not been.
Please.
The reason is that when the Your Lordship, this honorable court accepted the compromise, he lost his right, Your Lordship.
Court has to deal with their contention.
Your Lordship may kindly see,
ತಕರಾರು ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಹೆಂಗೆ?
when Your Lordship, the compromise petition, Your Lordship, was accepted by this honorable court and disposed of the matter. And the matter was only for confirmation of the, as per the compromise. So Your Lordship, in that, Your Lordship, you cannot raise the objections.
The reason ಈ ಆರ್ಡರ್ ಅಲ್ಲಿ ಇರಬೇಕಾಗಿತ್ತು.
ಇರ್ಬೇಕಾಯ್ತು, but the Your Lordship, in that, Your Lordship,
Instead of saying ಇದಕ್ಕೆ ಯಾವುದೇ ತಕರಾರು ಇರೋದಿಲ್ಲ.
But Your Lordship, kindly see, in that, Your Lordship, the tribunal, Your Lordship, has given a finding that, Your Lordship, it is accepted the order passed by this honorable court. It is proper, Your Lordship. If it is a matter remanded, Your Lordship, I can understand. It was not, matter was not remanded.
Dealt with these applications.
Yes.
We could have just said one ಹಿಂಗೆ ಹೇಳಿದ್ರೆ it's been accepted on 24/8. We don't need to deal with IA.
What my submission that, Your Lordship, if Your Lordship, in earlier petition, the matter was remanded to the tribunal, I can understand everybody can file objections, even and the tribunal has to look into the objections. But the compromise petition was accepted by this honorable court. And the tribunal also only extract the compromise.
Once they have filed objections to that after service, that has to be dealt with in their favor or against.
Yes.
ತಕರಾರು ಇಲ್ಲ ಅನ್ನೋದು is a wrong statement.
No, that is a wrong submission, wrong
Goes to the
finding.
root of the matter.
But Your Lordship, my submission, it is only thing.
Remit it back. Petitioner is before this court. ಏನಪ್ಪ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 4 and 9 ಡೆಡ್ ಅಂತಿದೆಯಲ್ಲಪ್ಪ.
ನಾ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀನಿ.
2.1 counsel for the petitioner seeks for and is granted.
Please.
Service Act, we can't deal with it.
Please.
Is granted.
2 weeks time.
2 weeks time to file necessary application to bring the legality of deceased respond number 4 and 9 on record, as also to carry out amendment to the cause title.
Please.
Relist on 12th February.
Interim order is there, my lord. Maybe can.
Interim order earlier granted is extended till next date.
Lord, may I request, my lord, one submission. In the order, my lord, passed in the first matter, let there be an observation, my lord, that this order has no bearing on the. Otherwise,
order passed, the order passed today in the above matter will not have a bearing on WP 110250 of 2019, and the same would have to be considered on its own merits. More so, since the tribunal has held that there is no objection to the compromise petition when the petitioner, when respond number 3 had filed objections.
Please.
To the compromise petition.
Please. Oblige.
Today itself, I'll carry out the amendment of.
DNP ಆಗಿದೆ 665 DNP. Counsel for the petitioner seeks for and is granted 2 days time to carry out necessary amendment. If needful is not done by 3rd, relist on 12th for dismissal. Say records ಬಂದಿದ್ಯಾ? ಕಣ್ಣೂರ್?
Not received, Your Lordship.
ಇನ್ನ ಬಂದಿಲ್ವಾ?
ಇನ್ನ ಬಂದಿಲ್ಲ.
ಯಾರು ಕೊಡ್ಬೇಕು? Respond number. When AGS submits the records are yet to be secured. If records are not secured by.
I can respond to yours.
18th.
Deputy Commissioner first respond.
R1 and R2.
ಯಾರ ಹತ್ರ ಇದೆ records?
ಅದನ್ನ ನೋಡೋದಕ್ಕೆ.
Respond number 1 and 2.
Yes.
Shall be present before this court through video conferencing.
Lord, amended writ petition, my lord, I have filed it in the counter, my lord.
Carry out the amendment fast.
I'll carry out, right.
Fast. Order sheet. Despite the order date 7/1/25, none appears for the petition today also. Applications to bring the legal representative deceased petition number 1 has also not been filed. It appears that the petitioner is not interested in prosecuting the matter. Petition is dismissed for non-prosecution.
Your lordship,
So death certificate ಏನಕ್ಕೆ ಬೇಕು?
Respondent was supposed to furnish my lord, ಅವ್ರು ಕೊಟ್ಟಿಲ್ಲ. Will
2 weeks time.
Or furnish the details of legal representative.
Don't have their contact matter. Last time petitioners are directed to,
Nobody is in contact. Lord Counsel for respond number 4
don't have,
submits that the legal representative sees respond number 4 have not in contact with him. As such, he is unable to furnish the details of legal representatives. Counsel for the petition seeks for and is granted 3 weeks' time to ascertain the legal representatives of deceased respond number 4 and file necessary application. Relist on 21st February.
Please.
application is ready.
Ready?
Filing.
Pass over.
Lord, ready, sir.
ಅಲ್ಲಿಂದ ಹೋಗಿ ಬರುತ್ತೆ
Please,
ನಂಬರ್
please.
ಪಾಸ್.
Please.
ನೀವು ನಿನ್ನೆ ಫೈಲ್ ಆಗಿದ್ರೆ ಬರೋದು.
Sorry, Lord.
In trial court, matter has been settled and disposed, my lords.
Petitioner is before this court seeking for the following will be a memo dated 28/1/25 has been filed signed by the counsel for the petitioner which reads as in accepting said memo and submission of counsel for the petitioner, petition is dismissed as settled out of court, settled before the trial court.
Please, my lords.
Kindly 2 days time to comply the observation.
10 days time is granted to the counsel for the petitioner to make payment of necessary process fee and furnish copies in respect to unserved respondents and to comply with the office objection.
But may I make a submission? Respond number 2 and 3 are not necessary parties. Respond number 1, we are the contesting, we are the plaintiffs. May I request for a date?
Interim order ಇದೆಯಾ?
Please.
ಅದಕ್ಕೆ ಕೊಡಿ ಅದು. Are co-defendants.
Please.
Notice to respond number 2 and 3 is dispensed with in view of their being co-defendants of the petitioner. 3 days time is granted to the petitioner to comply with the office objection.
Please.
If not complied by 4th, the petition would be liable to be dismissed for non-prosecution. In the objection, interim order earlier granted is extended till next date.
May I request for a date?
4th.
Please, date.
A week's time to do the needful, my lord.
Counsel for the petitioner seeks for and is granted a week's time to make payment of necessary process fee in respect to unserved respond number 9 and to file a condemnation of delay application.
Please.
If needful is not done by 7th, relist on 12th for dismissal. Yes.
Yes, my lord.
Ready?
Yes.
Okay.
Please. The petitioner is the branch office of the State Government Employees Association of Ramdurg Taluka. In the year 1986, a portion of the land has been granted in their favor to construct their office. And in the year 23, on the basis of application filed by some encroachers, the deputy commissioner has cancelled the grant after 37 years.
Suits have been filed.
Suits have been filed by the encroachers.
For seeking for, relief.
Possession, my lord.
Seeking possession.
Possession, the
OS 9.
order 6 of specific relief act.
OS 9 is for?
Suit for possession.
For possession.
My lord, the land was granted, my lord. They have not fulfilled a single condition, my lord. Honorable court tells the annexure B.
ಏನಾಯ್ತು OS9?
That is
Lord,
pending.
there the stay has been granted, my lord, in the year 1995, the building was constructed in that particular land, my lord.
Suit ಏನಾಯ್ತು?
That is pending, my lord. Pending, and the stay has been granted, and miscellaneous appeal was also dismissed, my lord. And the present, another writ petition is pending before this honorable court. That
Not to disturb. ನಿಮ್ಮ suit ಅಲ್ಲಿ you are asking for possession.
Possession, my lord, possession.
Injunction restraining interference with possession ಕೇಳ್ತೀರಾ? Suit possession ಕೊಡಿ ಅಂತೀರಾ? ಅಲ್ಲಿ restrain them from interfering with my possession ಅಂತೀರಾ?
Yes.
Not to make any construction over the property, my lord.
Where is the
Page number.
prayer?
At 72,
possession
my
and-
lord. Page number 72.
43. 43. Where's number? 79.
Page number 72 is the interim order granted by the trial court.
Plaint ಅಲ್ಲಿ. Plaint is 39 ಅಲ್ವಾ?
Page 39 is.
Prayer is at page
There at
43.
page number 43.
43.
43. Directing the
Direct
defendant
reference to construct the house
the
building
house building in the suit open and to restore the possession of the plant.
and his family, restore the possession. So you are not in possession.
My lord, this case is, in this particular case, that case, the writ petition is separate writ petition, my lord. That has been pending before this honorable court. That has not been connected with this suit. But in this case, my lord, the land was granted in the year 1986. Subject to some condition, as per annexure B, my lord. if the honorable court
Shekarappa
reads
is the
annexure B,
plaintiff. ಇಲ್ಲಿ respond number 4 is Yankappa Koravar. ಅದು ಬೇರೆ suit.
Annexure B, my lord, at page
ಇನ್ನು ಒಂದು
number
ಯಾವ್ದು writ petition number ಏನು?
10111.
Connect the above matter with so and so and relist on 12th February.
Please.
My lord, I complied the office objections.
What are those applications?
That process fee is paid.
ಏನ್ IA1 and 2?
I1 is, the petitioner is expired. Petitioner has expired. And I filed application for bringing the LRs of the petitioner, I number 1. And I number 2 is for transposition of respondent. His LRs are already on record.
During the pendency of the above matter, the sole petitioner expired on 19/8/2024. Hence IA1 and 2 of 2024 have been filed.
And respondent number 12 and 16 are the legal heirs of the deceased
ಒಂದು
petitioner.
ನಿಮಿಷ ಫಸ್ಟ್ ಒಂದು IA ಆರ್ಡರ್ ಮಾಡಕ್ ಬಿಡಿ. ಯಾಕೆ 2 IA ಏನಕ್ಕೆ ಹಾಕಿದ್ರಿ? ಇನ್ ಟೈಮ್ ಇದೆ, ಯಾಕೆ 2
Yes,
IA ಹಾಕಿದ್ರಿ?
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ.
IA1 of 24 has been filed to bring the legal representative of deceased petition number 1 on record, accepting the reasons stated in support of the said application. The right to sue surviving IA1 of 24 is allowed. The person named therein are brought on record as petition number 1A and 1B. Counsel for the petitioner to carry out necessary amendment and file amended cause title. IA2 ಏನಿದು?
Transposition. The LR of the petitioner is already on.
Already on. ಸರಿಯಾಗಿ reading ಇಲ್ಲ.
Yes.
Memo ಹಾಕಿ.
I will not press it.
Now they can't be both petitioner and respondents.
My lord, what has happened? He was the party in the trial court. Therefore, he was implicated. And I filed a memo stating that he is already on record as a respondent number 12.
ಎಲ್ಲ ಹೊಡೆದಾಕಿದನು.
Yes, my lord.
During the pendency of the above matter, The sole petitioner expired on 19/8/2024. Hence, IA 1 and 2 of 2024 have been filed.
Please.
IA 1 has been filed to bring the legal representatives of deceased petition number 1 on record as petition number 1A and 1B. IA 2 of 24 has been filed to transpose respondent number 12 and 16 as petition number 1A and 1B, since they are the very same legal representatives who are sought to be brought on record in IA 1 of 24. In that view of the matter, it would not be required to allow both the IA 1 of 2024 is dismissed as not necessary. IA 2 of 24 is allowed. Respondent number 12 and 16 are transposed as petition number 1A and 1B, they being the only legal heirs of deceased petition number 1. Counsel for the petitioner to make necessary endorsement and amendment and file amended cause title. Respondent number 11.
11, I have paid the process.
Counsel for the petitioner submit that process fee in respect of unserved respondent number 11 has been paid. Registry to verify and issue notice to respondent number 11 returnable by 9th April.
Please.
I appear for respondent. I request for 2 days time to secure some records.
Compliance.
It's compliance, my lords, one submission, my lords, in the prayer, my lords, I have made the correction. Only in 2 office objections, my lords, I have to comply. Within 2 days, I'll comply that office objection.
And is granted 3 days time to comply with the office objection. Counsel for respondent number 7 also seeks for 3 days time to get ready and address his argument. Relist on 5th.
He has undertaken to file wakalat on all.
Yes, I have already filed, my lord.
You already filed.
Yes, my lord.
Counsel for the respondents
Yes.
seeks for it. ಅವರು ಮತ್ತೆ ಆಮೇಲೆ ಬೇರೆಯವ್ರು ಬಿಟ್ಬಿಟ್ರಿ ಅಂತಾರೆ.
Last time, my lords, said.
Please.
Register to verify and print the name of Sri Mahesh and Kulkarni as that
Yesterday
appearing
only
for
I
the
filed.
respondents if wakalatnama has been filed.
Yes, ma'am.
For the petitions. The office raised objection regarding page 54, your lordship. They are not necessary. It's a part of the award, your lordship. It is not pertains to the petitioners also.
ಮತ್ತೆ ಏನಕ್ಕೆ ಬಿಡಿ?
Part of the award, your lordship, because along with the award I have produced it, your lordship.
54. A perusal of annexure, page 54 to 57 of annexure B indicate that the same is legible. So also is page number 59 of annexure C. Hence office objection scale number 16 is overruled. Yes.
Your lordship, that the land of the petitioners were submerged under the UKP project. During the James, your lordship, the cattle shed and the house property was not shown. When we have made an application, a further James has been.
ಕೇಳಿದ್ದೀರಾ?
Yes, sir.
Learned AG accepts notice for respondent number 1 and 2. He seeks for and is granted a week's time to
Page
obtain.
number 40 and 41 may kindly see, your lordship.
Ready na? ಮತ್ತೇನೇನು week's time ಬೇಡ.
Page number, his submission that, your lordship, he wants a compensation for building. But your lordship, in ink page 40 and 41, there is no reference regarding the building. And so, your lordship, by considering that, your lordship, the endorsement to issued annexure K.
You have constructed the building subsequent to the JMC.
At their contention, may I read your annexure D may kindly be seen, your lordship. Annexure D, this was in the year 2015, it was notified under the UKP project, annexure D, in page 60. ಹೊನ್ನರಳ್ಳಿ ಗ್ರಾಮದ ಶ್ರೀ ಸಿದ್ದರಾಮಪ್ಪ ಗೌಡ ಇವರು ಹೊನ್ನರಳ್ಳಿ ಗ್ರಾಮದವರಾಗಿದ್ದು ಸದರಿ ಅವರು 2013-14ನೇ ಸಾಲಿನ ಮಹಾತ್ಮ ಗಾಂಧಿ ರಾಷ್ಟ್ರೀಯ ಉದ್ಯೋಗ ಖಾತ್ರಿ ಯೋಜನೆ ಅಡಿ ತಮ್ಮ ಸ್ವಂತ ಜಮೀನು ದನದ ಕೊಟ್ಟಿಗೆ ನಿರ್ಮಿಸಲು ಫಲಾನುಭವಿಗೆ ಆಯ್ಕೆಯಾಗಿರುತ್ತಾರೆ ಈ ಮೂಲಕ ತಮಗೆ ತಿಳಿಸಲಾಗಿದೆ.
Where is that order?
That order, your lordship, that it has been issued, the certificate has been issued by the authority.
2024.
Yes, your lordship, because I have filed an application to get the copies.
So where is that?
May just one more annexure.
Given and where is that order?
That order I could not
Only-
get. Annexure G
only
may
lordship.
kindly be seen, your lordship.
Only in that, your
Hello,
lordship.
annexure G may kindly be seen in page 64.
Yes.
ಬಾಗಲ್ಕೋಟ್ ತಾಲೂಕಿನ, so your lordship that in page 64, so and so ಗಿಡಮರು ಕಟ್ಟಡ ಕೈಬಿಡ್ಡ ಬಗ್ಗೆ ವರದಿ ನೀಡುವ ಕುರಿತು, this has been submitted by the JMC. That's next page, your lordship, in page 65. Serial number 7 may kindly be seen. ಮನೆ ಒಂದು, ದನದ ಕೊಟ್ಟಿಗೆ ಒಂದು, before the assistant executive engineer and the surveyor.
ಅದಕ್ಕೆ JMC ಅಲ್ಲಿ ಇದೆ ಅಂತ ಇದೆಯಾ?
ಅಲ್ಲ, JMC ಅಲ್ಲಿ ಇರ್ಲಿಲ್ಲ ಅಂತ we have made an application. Number of petitioners, except this, your lordship, the other petitioners they could get it. Sorry, other land losers.
ಇದು ನಿಮ್ಮ representation.
Nim representation,
Year 2018.
not only us, your lordship, number of persons.
ಆಮೇಲೆ ಏನಾಯ್ತು?
ಆಮೇಲೆ we have made an application. ಅವರು ಅದರ ಮೇಲೆ ಲೆಟರ್ ಕೊಟ್ಟರು ಅವರಿಗೆ. Annexure H may kindly be seen, your lordship. ಮೋಜನೆಯಲ್ಲಿ ಕೈಬಿಟ್ಟ ಕಟ್ಟಡಗಳು, ಗಿಡಮರ ವಿವರದ ವರದಿಯನ್ನು ಸಹಾಯಕ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಭಿಯಂತರು ಕೃಷ್ಣ ಜಲಭಾಗ್ಯ ಮುದೋಳ್ ಹೆಸರೋಳಿ ತಮ್ಮ ಕಚೇರಿಗೆ ದಿನಾಂಕ 30/10/2018 ಸಲ್ಲಿಸಿದ್ದಾರೆ ಎಂದು ಉಲ್ಲೇಖದಲ್ಲಿ ತಿಳಿಸಿದ್ದಾರೆ. ಅವುಗಳ ಪ್ರತಿಯನ್ನು ಈ ಪ್ರತಿ ಲಗತ್ತಿಸಿ ತಮ್ಮ ದಯಾಪರ ಮಾಹಿತಿಗಾಗಿ ಮುಂದಿನ ಕ್ರಮಕ್ಕಾಗಿ ಸಲ್ಲಿಸಲಾಗಿದೆ. On that basis, I made a representation. Now this endorsement has been issued. That is in page 70.
30/10/2018 is
Yes.
your representation.
Yes, your lordship.
ಇದು ಯಾರಕ್ಕೆ ವಿಶೇಷ ಭೂಸ್ವಾಧೀನ?
ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ. Directly it has been submitted to the.
ಏನಾಯ್ತು?
ಅದ್ರ ಮೇಲೆ ಇವರು ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ರು ಈ ರೀತಿ.
ಯಾವತ್ತು?
In page 70, your lordship. This is the endorsement. Now I am challenging before this honorable court.
From 2019, no action was taken.
No action has been taken on this. Only because in the JMC it was not mentioned. That is the only their contention at the first instance.
What is the date of acquisition?
2015, your lordship. That is on 31/2015, 11/1 notification.
JMC was conducted on?
On 24/10/2016. Serial number 5, your lordship, in page 13.
They're asking for Danada Kottige.
Yes.
Agriculture land, it has to be there.
But yeah, my learned friend read that, your lordship, ಆಯ್ಕೆ ಆಗಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರು. Whether it was constructed, your lordship, he has not.
ಆಯ್ಕೆ ದನದ ಕೊಟ್ಟಿಗೆ ಇಲ್ಲದೆ ಇರಕ್ಕಾಗಲ್ಲ.
But your lordship, for a moment, your lordship.
ಮನೆ ಬಿಲ್ಡಿಂಗ್ ಅಂದ್ರೆ ಅದು we agree.
My learned friend that.
Land ಅಲ್ಲಿ ದನದ ಕೊಟ್ಟಿಗೆ ಇಲ್ಲದೆ.
ದನದ ಕೊಟ್ಟಿಗೆ ನಿರ್ಮಿಸಲು, it is stated in the annexure D.
ಆಯ್ತು. But if they are carrying out agriculture work and ದನಗಳು ಇದಾವೆ ಅಂದ್ರೆ.
And whether your lordship only by.
ಬಿಡಕ್ಕಾಗತ್ತಾ?
May I make one submission? When there is an award, your lordship, there was no reference regarding this aspect. But your lordship, whether your lordship in the present petition, this aspect can be considered. When the award is passed, your lordship, he can ask for setting aside and for modification of that award.
Bring justice, it can be done. If your officers.
Reconsider modest.
Petitioner is before this court seeking for the following reliefs. Petitioner claims the owner of the land in RS number 29/3 measuring 2 acres 20 guntas and 8 annas at Vanaralli village. The said land came to be acquired for the purpose of the Upper Krishna project. When the land was standing in the name of the father of the petitioner. Subsequently, they have succeeded to the property, to the said properties and have now become the owners. An award having been passed
(24/7/2019), your lordship.
Award ಆದ್ಮೇಲೆ representation ಕೊಟ್ಟಿದ್ದೀರಾ ನೀವು?
ಇಲ್ಲ, ಮೊದಲೇ ಇದು ಆಗಿದ್ದು 30/10/2018. Yes, your lordship. Sorry, sir. 15/10/2018. This JM once again, the assistant executive engineer surveyor.
Having been conducted on 24/10/2016 the cowshed not having been reflected in the said joint measurement, the petitioner along with others had submitted a representation on 30/10/2018 for inclusion of the cowshed insofar as the land of the petitioner is concerned. The other landowners had submitted other representation for inclusion of certain other missing trees, construction or otherwise, which have been considered. The beneficiary also having been furnished a copy of the said representation had forwarded same to the Special Land Acquisition Officer. No action having been taken thereon, an award came to be passed on 24/7/2019, excluding the cowshed on the ground that the joint measurement did not reflect the existence of the cowshed. The representation submitted by the petitioner on 30/10/2018 having been followed up with another representation on 13/9/2024. The impugned endorsement dated 21/9/24 came to be issued rejecting the said representation. It is charging the same, the petitioner is before this court. The submission of Shri Jagdish Patil, learned counsel for the petitioner, is that a cowshed having been in existence, the petitioner carrying out agricultural activities, has not been reflected in the JMC. And at an undisputed point of time, a representation having been submitted in the year 2018, without considering the same, award has been passed on the ground that the JMC does not reflect the existence of the cowshed, which is not proper. And as such, he submits that the representations having not been properly considered, the documents furnished by the petitioner not having been properly considered, the said endorsement is required to be quashed, and a direction issued to the respondents to make payment of compensation as regards the cowshed. Shri M. Kannur, learned AGA, would however submit that what has been reported in the JMC is the existent situation. There being no cowshed, it's not reflected in the JMC. That has been rightly considered by the SLAO passing the award. And as such, this court is not required to intercede in the matter. Heard so and so.
And also, Your Lordship, he can seek modification of the award, Your Lordship, by filing a necessary appeal.
He further submits that if at all any aspect has been left out, the petition can always seek for modification of the award by filing necessary appeal. Heard so and so various papers. The contention of the petitioner is that a cowshed has been left out in the JMC carried out on 24/10/2016, and immediately thereafter on 30/10/2018 a representation had been submitted. It is not in dispute that the petitioner carries on agriculture activities, was carrying on agriculture activities in the said land by making use of cows and buffaloes.
House also, Your Lordship. House
the problem illa alla.
ಅಲ್ಲಿ ಬಂದಿದೆ.
House the contention illa. Only cowshed ತಾನೆ ನಿಮ್ದು.
ಇಲ್ಲ ಮನೇನು ಅಂತಿದೆ. In page 65 may kindly be seen, Your Lordship. 65 ಮನೆ ಮತ್ತು ದನದ ಕೊಟ್ಟಿಗೆ. Serial number 7.
ಮನೆ ಹೇಳಕ್ಕಾಗಲ್ಲ.
ಅಲ್ಲ, let them reconsider. ಯಾಕಂದ್ರೆ ಅವ್ರದೇ ಜಾಯಿಂಟ್ ಮೇಜರ್ ನಾವು ಯಾರು ಇರ್ಲಿಲ್ಲ. ಅವ್ರ ಸರ್ವೇಯರು
ಸಬ್ಮರ್ಜ್ ಆಗಿದೆಯಾ ಇದೆಯಾ?
ಸಬ್ಮರ್ಜ್ ಆಗಿದೆ ಈಗ.
ಅದು ನೋಡಕ್ಕಾಗಲ್ಲ. You file an appeal ಆಗಲ್ಲ. You establish all those things.
Yes.
ದನದ ಕೊಟ್ಟಿಗೆ we would direct them, not money.
As per the JMC conducted by them only.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಮನೆ.
ಅಲ್ಲ ಅವರೇ ಮಾಡಿದ JMC ನಾನಲ್ಲ.
ಮನೆ ಇಲ್ಲ ಅದರಲ್ಲಿ.
ಮನೆ ಅಂತ ಬರ್ದಿದ್ದಾರೆ ಅದಕ್ಕೆ.
ಎಲ್ಲಿ ಬರ್ದಿದೆ? ಇದು ನೀವು ಕೊಟ್ಟಿರೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್.
ಯಾರದ್ರಲ್ಲಿ ಯಾವ್ದೋ ಇದರಲ್ಲಿ ಮನೆ ಬಗ್ಗೆ ಎಲ್ಲೂ ಇಲ್ಲ. ಯಾರ ಮ್ಯಾಟರಲ್ಲಿ 29 in page 41.
ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ ಎಲ್ಲಿ ಇರುತ್ತೆ ಮನೆ?
ಅಲ್ಲ page 41.
ಎರಡು ಮನೆ ಇಟ್ಟಿರ್ತಾರ. ಮತ್ತೆ ಒಂದು ವಿಲೇಜ್ ಅಲ್ಲಿ ಇರುತ್ತೆ, ಅಲ್ಲಿಂದ ಹೋಗಿ ವ್ಯವಸಾಯ ಮಾಡ್ತಾರೆ. ದಂಡಗಳನ್ನ ಅಲ್ಲೇ ಕಟ್ತಾರೆ, ಅಲ್ಲೂ ಕಟ್ಕೊಳಕ್ ಒಂದು ಇಟ್ಕೊಂಡಿರ್ತಾರೆ.
That liberty, your lordship. Next.
The house and cow shed has not been included in ಮೇಲೆ ಹಾಕ್ಕೊಂಡು. I find favor with the submission of the learned AGA, in as much as these aspects would have to be, these aspects being disputed questions of fact would have to be ascertained in appropriately instituted proceedings. The petitioner claiming that there was a house in existence, as also a cow shed. Both these aspects would have to be established by the petitioner, and as which can be so done in an appeal filed by the petitioner, reserving liberty to agitate all the issues in an appeal as and when filed. The petition stands disposed.
The office of objection is regarding, my lord, the legibility of manuscript.
Counsel for the petitioner submit that he would not rely on the manuscript portion of annexure A and F. Hence, office objection CL number 19 is overruled. What are these about parties? Different 1A, 1C, 1H not made parties.
Please, my lords.
ಯಾಕೆ ಮಾಡಿಲ್ಲ?
Because, my lord, all are the having same interest in the suit, my lords. Since I have made only one party as the petitioner.
You can't say they are having same interest. You want to challenge, yes, they should be big respondents, alva. That counsel for the petitioner submit that defendant number 1C to H are not aggrieved by the orders passed. And as said, the petitioner has filed the above petition. In that view of the matter, the note below the cause title is accepted. Yes, really?
Suit for bare injunction, my lords. The plaintiffs filed a suit for bare injunction against the original defendant, my lords. The original defendant died during the pendency of the suit, my lord. Thereafter, my lords, after the lapse of 2 years, an application came to be filed for bringing heirs of the deceased, the original defendant, my lords. That application came to be allowed, my lords. Since, my lord.
Delay antana?
Please, my lords.
Condemnation delay was allowed.
No, my lords. IA number 4 for bringing heirs of the original defendant.
Yeah, when did defendant number 1 expire?
15 June 2021, my lord.
When was the application filed?
Application came to be filed on 7/9/23.
7/9?
23.
Application ellide copy?
Annexure D, my lords.
Annexure D is for legal heirs of plaintiff. Pleased to accord permission to the following person to come on record of the above case as legal heirs of deceased plaintiff number 1. Proposed legal heirs of defendant.
Please, my lord. Sole defendant, my lord.
They did not know about your death anta. Who reported death? Yara report madidra death?
No, my lords.
Matte?
No, my lord.
Limitation in.
We were not being the party, my lords.
You are not a party, but your counsel reported death of, you report ಮಾಡ್ತಿರ respond number so and so expired.
Please, my lord.
And ಯಾರು report
No,
ಮಾಡಿದ್ರ?
no, my lords. No, my lord. It came to filed after 2 years, my lord. We were not about aware of the fraud, my lord.
Yes. A suit in OS number 452 of 2019 had been filed by respondent number 1 and 2, seeking for an order of injunction restraining the defendant, his agents or servants or anyone claiming through or under him, including legal heirs, from dispossessing plaintiff from suit's property. The pendency of the suit on 15/6/2021, the sole defendant is stated to have expired. And an application came to be filed on
7/9/23.
ಎಲ್ಲಪ್ಪ ಇದು ಡೇಟ್ ಎಲ್ಲ ಬೇರೆ ಬೇರೆ ಇದೆ ಇಲ್ಲಿ. ಕಾಪಿ ಪೇಸ್ಟ್ ಮಾಡಿದ್ರೆ ನೋಡಿ ಪೇಜ್ 48 ಅಲ್ಲಿ 6/3/2019 ಅಂತಿದೆ. ಪೇಜ್ 49 ಅಲ್ಲಿ 7/9/23 ಇದೆ. Came to be filed on 7/9/2023 to bring the legal representative of deceased defendant on record. Notice having been served, the said application, though objected to, came to be allowed by the impugned order dated 25/10/2024. It is challenging said order that the petitioner is before this court. Submission of counsel for the petitioner is that defendant having expired on 15/6/2021, application having been filed on 7/9/2023, there being a delay of 2 years, ought not to have been condoned by the trial court. Having perused the application and the impugned order, as also the order sheet, it is seen that death of defendant was not reported in the said proceeding. It is only subsequently that the plaintiff claims that he came to know about the death of defendant. And from the date of such knowledge, the application has been filed within time. There being no other document which has been placed on record indicating the knowledge of the plaintiff as regards the death of the defendant, it cannot be said that there's a delay of 2 years in filing the application. The delay would have to be calculated from the date of knowledge of the plaintiff about the death of the defendant. In that view of the matter, I do not find any infirmity in the order passed by the trial court.
One more condition, one more submission, my lords.
This was
Since
a state
in the suit for bare injunction, my lords, the original defendant died, my lords. The suit shall abate, my lord. The proceedings.
Illegally claiming under them,
Please, my lords.
it will be covered without judgments.
Obliged.
Please, I appear for petitioner. The office has raised objection, my lord, seeking FDP petition. This matter, my lord, so moto, the suit is continued. No FDP petition, fresh FDP petition is filed.
Yen so moto continue.
Lord, after disposal of the partition suit, FDP proceedings are initiated, my lord. There is no separate FDP petition as such. Fresh FDP petition file ಮಾಡಿ.
Illi order sheet ellide?
Yes. Order sheet is not produced, my lord. Idರಲ್ಲಿ
The order sheet.
Yes.
To see if it is so moto. Counsel for the petition seeks fund is granted.
2 days time.
2 days time to produce the order sheet.
But I have the order sheet from certified.
Kodi.
Separate FDP proceeding. Petition as such is not filed. Suit dispose ಆದ್ಮೇಲೆ it is continued.
Accepting submission of counsel for the petition office objection at serial number 23/2 is overruled.
Please. Yes. Lord, page 25 is the impugned order. In the FDP proceedings, my lord, the trial court has appointed a Taluka surveyor as the court commissioner for agricultural land and advocate as court commissioner for the house properties. Page 25.
25 is internal page 16 of the judgment in OS number 101.
Yes. Annexure, my lord, it is annexure C, last page. Page 8. Please.
Annexure C is objection to IA.
Lord, it is, yeah, I am referring to the impugned order at annexure C.
65 apart.
Yes.
25 alla.
Yes. Lord, this, the FDP court has appointed Taluka surveyor is, my lord, it is incompetent person.
ADLR Ukkeri.
Yes. He is incompetent.
How is the ADLR incompetent to carry
For
out?
section 54, my lord, as your lordships are aware, is
Ah.
amended, my lord. I'm relying upon this judgment.
Oh,
Para 16, your lordship. Para 13 and 14, your lordship. And for the house property, advocate is appointed. A city surveyor ought to have been appointed.
Ian, what do you want to rely on the amendment for?
My lord, for the ground that the taluka surveyor cannot be appointed as a court commissioner. And secondly, for the house properties.
Or such other person as the court may appoint as commissioner.
Yes, but not below the rank of tahsildar. That is the amendment. I'm relying upon that judgment. This
Revenue officer not below the rank of tahsildar.
Yes.
Or such other person as the court may appoint as commissioner in that behalf.
Yes. But talika be not below the rank of tahsildar. Any revenue officer.
Revenue officer idre not below the rank of tahsildar. Oh, ADLR is
Yes,
not.
ADLR. ADLR. And for house property, my lord, advocate is appointed. City surveyor ought to have been appointed. Both properties, my lord, it is incorrect.
Advocate, there is no problem.
Yes.
Other rank baralla.
Yes.
ADLR rank baralla.
Yes.
Issue. Notice to respondent.
Sole respondent.
Returnable by, emergent notice returnable by 25th February. Counsel for the petitioner to also cause service of notice on the counsel appearing for respondent before the FDB court and file the same with the registry on or before 3rd February. Considering that a taluka surveyor attached to the Tahsildar stroke ADLR Ukkeri has been appointed as a commissioner in respect of A schedule property, which is contrary to section 54 of the Karnataka amendment to the CPC, which mandates that a revenue officer not below the rank of Tahsildar could be appointed. The appointment insofar as the taluka surveyor is stayed, the appointment of an advocate as a court commissioner shall continue and he would be entitled to discharge the commissioner warrant. Process fee and copies to be furnished by end of day 31st January, failing which and failing the filing of the acknowledgement as aforesaid, the interim order would stand automatically vacated.
Please. Highly obliged.
Week's time to comply the office subject. Week's time, my lord.
Counsel for the petitioner seeks fund is granted a week's time to comply with officer. If not complied by 7th, released on 12th for dismissal.
Week's time to comply the officer.
Week's time, if not complied by 7th, 12th for dismissal.
Please.
19, my lord, I appear for the petitioner, my lord.
Yes.
There are office objections, my lord, that I need to produce type copy, my lord. I'll comply with that. However, for the moment, my lord, I'm not relying on the same.
You're not relying on 10, 54, 55 and 54 is the only one clear and 55. 57 is about respond number 4.
Yes, my lord. For the moment, my lord, I'm not relying on that, my lord. The office objection raised at seal number 54.
What about respond number 4? What is this issue about respond number 4?
Lord, what has happened, my lord, so far as the petition is concerned, petitioner, my lord, has been permitted to set up 175 megawatt solar plant, my lord, that's spreading across several villages in Bellary district. That, my lords, will find it at Annexure A. Pursuant to, my lords, got it, my lord, Annexure A at page number 20.
What is this to be corrected for respond number 4? President Gram Panchayat Kallapura.
Yes.
In
No, what-
correction I got. Office objection ಸರಿಯಾಗಿ ಬರೆಯಲ್ಲ. Respond number 4 to be corrected ಅಂದ್ರೆ ಏನರ್ಥ? Registry is directed to put up a note on office objection at number 57 as to what is sought to be conveyed by such an objection. Learned counsel for the petitioner submit that he does not rely on pages 132 to 142 and 172 to 183. As such, his submission is accepted. Office objection at CL number 54 is overruled. Each photocopy is to be marked separate.
I have produced, my lord, the Aadhaar cards of the landowners with whom, my lord, I have entered agreement for setting up this solar park.
We are unable to understand this person. Registry is also direct put up a note as to what is meant by office objection at CL number 55. Annexure D, page number?
Annexure D is at page number 41.
H,
my lord, is at page number 49.
J
is at 50.
K. The rules of the above petition would indicate that annexure D, H, J, K are legible. Hence, office objection CL number 27 is overruled. Yes.
My lord, the order impugned is annexure L, page number 54. This is, my lord, issued by the Panchayat Development Officer, Gram Panchayat, Kalapura. Now, what is this issue, my lord? Is the petitioner, my lords, may kindly annexure L, page 54. I'll just go through the contents at page number 54, my lord. ವಿಷಯ ಸೋಲಾರ್ ಪ್ಲಾಂಟ್ ಪರವಾನಗಿ ಪಡೆಯುವ ಅಕ್ರಮವಾಗಿ ನಡೆಸುತ್ತಿರುವ ಬಗ್ಗೆ ಈ ಮೇಲಿನ
54, yes.
This is dated 2/1/2025. Yes, ma'am. This, my lord, ಈ ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಕಾಳಾಪುರ ಗ್ರಾಮ ಪಂಚಾಯತಿ ವ್ಯಾಪ್ತಿಗೆ ಚೀನಹಳ್ಳಿ ಗ್ರಾಮದ 25 ಮೆಗಾವಾಟ್ ಸೋಲಾರ್ ವಿದ್ಯುತ್ ಘಟಕ ಸ್ಥಾಪನೆಗೆ ಪರವಾನಗಿ ಪಡೆದ ಅಕ್ರಮವಾಗಿ ನಡೆಸುತ್ತಿರುವೆಂದು ಕಂಡು ಬಂದಿದ್ದು ನಾನು, this is what the Panchayat Development Officer is saying, ನಾನು ಮೌಖಿಕವಾಗಿ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಅಧ್ಯಕ್ಷರು ಮತ್ತು ಪಂಚಾಯತಿ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿಗಳು ಮುಖಾಂತರ ಕಾಮಗಾರಿ ನಿಲ್ಲಿಸಿ ಎಂದು ಹೇಳಲಾಗಿದೆ. ಆದರೂ ನೀವು ಕಾಮಗಾರಿ ಪ್ರಾರಂಭ ಮಾಡಿದ್ದಾರೆ ಆದ ಕಾರಣ ತಾವುಗಳು ಸೋಲಾರ್ ವಿದ್ಯುತ್ ಘಟಕ ಕಾಮಗಾರಿಯನ್ನು ಈ ಕೂಡಲೇ ಸ್ಥಗಿತಗೊಳಿಸಬೇಕು ಎಂದು ಈ ಪತ್ರದ ಮೂಲಕ ಕೋರಲಾಗಿದೆ. First, my lord, the Panchayat Development Officer orally informs to stop work, under which provision, my lord, we don't know. Thereafter, my lord, he issues this notice to stop work in its entirety. The grievance is this: wide annexure A, my lord, I have been directed to set up a solar park of 175 megawatts. That is at annexure A, page number 20. The relevant portion, my lord, is at page number 21, bottom portion.
Yes.
This is on 8/7/2024, wherein the earlier plan of 100 megawatt came to be revised for 175 megawatts.
What action to be taken against this PDO, Mr. Kannur? Your PDOs are turning out to be the worst lot. ಎಲ್ಲದರಲ್ಲೂ ಇಂಟರ್ಫಿಯರ್ ಮಾಡ್ತಾರೆ. Election, development, tax. They have become a law unto themselves. State government approved project alli illegal andre artha ಏನು ಇವ್ರದು? Have they even issued a show cause notice or collected documents?
We have in fact paid the fee also, my lord, of about 4,80,000 rupees.
And AGA accepts notice for respond number 1. CEO Vijayanagara. Yarappa? Shivraj Iramat for respond number 2, 3, 4 and 5. The grievance of the petitioner is despite a government order having been issued authorizing the petitioner to set up a solar power plant, the Panchayat Development Officer has contended same to be illegal and directed the petitioner to stop work. it is rather shocking that the petitioner, that respondent number 4 has passed such an order without even verifying any documents from the petitioner. The operation of Annexure L, he stayed till the next date, L dated 2/1/2025. He stayed till the next date of hearing. Needless to say, the petitioner would be entitled to proceed with the works in terms of the government order dated 8/7/2024. The first respondent, Principal Secretary, Rural Development and Panchayat Raj Department, is directed to look into the matter and make a submission as to what is the authorization of the Panchayat Development Officer to have issued the directions as done in terms of Annexure L. And if he is not so authorized to do so, what is the action that the Principal Secretary proposes to take against the said PDO? Released on 11th February.
Great.
Petitioner, petition number 1 and 4 died during
During
pendency.
the pendency of the above matter, number 1 and 4 have expired, and a memo has been filed to treat petition number 2 and 3 as their legal heirs. Accepting the said memo, petition number 2 and 3 are treated as legal heirs of petition number 1 and 4. Counsel for the petitioner to carry out necessary endorsement in the cause list. What is IA 1 of 25?
An amendment,
Amendment has been
the
sought.
document already produced before the Sonplan at the time of filing writ petition.
Uh-huh.
But by oversight not challenge the annexure G. The only challenge the appellate court order.
Just place my formal objections on record because it is after filing of my statement of objections to the effect that it is not challenged.
Record your submission.
Only 2 days, not more than that.
IA
Because,
1 of 25 has been filed seeking for amendment to challenge the order of the third respondent at Annexure G, which had already been produced along with the petition. The submission of Sri H.M. Dharwad, learned counsel for the petitioner, is that by inadvertence such a relief could not be sought for. Sri Girish Yadwad, learned counsel for respondent number 1 and 2, seeks for a short accommodation to file his objection. On an inquiry as to what his objections could be, he submits that the objection is that the amendment application was filed after the statement of defense was filed.
and also the delay in challenging that, as on today.
The
it has
delay
to-
in challenging the said order. Having heard both the counsels, the order dated 25/7/2008 having been produced along with the petition, and the same also being subject matter of the list between the parties, the mere non-challenge of it, in my considered opinion, would not come in the way of allowing the above amendment application. In that view of the matter, the application IA number 1 of 25 is allowed. Counsel for the petitioner to carry out necessary amendment and file amended petition by 5th February 2025.
Please.
Additional statement of objections to be filed on or before 13th February, relist on 20th February.
Additional statement, if any, my lords, may say.
If any.
It may not be required, that's why I'm not. ಅದು it will be
ಇದಕ್ಕೆ
taken,
ಅಷ್ಟು objection ಮಾಡಿ ಅದಕ್ಕೇನು ಬೇಡ
it will be taken as an order to file. Next time office will
If
say,
any.
non-filing of statement of objection ಬಂದ್ಬಿಡುತ್ತೆ.
ಅವಾಗ ರೆಕಾರ್ಡ್ ಮಾಡಿ, doesn't
ಅದಕ್ಕೆ-
object to it.
To lessen their work, I made this submission.
And then we'll allow that prayer.
Obliged.
Appearing for responding.
What is IA 1 of 24?
Seeking direction note 17B wages.
Yeah,
This
burial
honorable
line.
court has granted absolute stay of reinstatement order. They contended that, my lord, the respondent is a trainee. He is not entitled for any relief at the hands of labor court. We have relied on the coordinate bench judgment, my lord, last state of hearing.
Where is Ms. Bentur? Pass over.
Please.
the area is coming less, all the three properties.
Hmm.
Mine, my lords, beside mine and my lords, the adjacent owner. My lords, the area is coming less, my lord, but the sale deed, my lords, and map is
Not
showing.
concerned with the area being less or not. You should have been concerned about it before constructing.
My lords, at the time
That
of
time you should have
construction-
taken action against whoever is encroached.
Please, my lords, now that
If you
is-
know that the size is this, whatever the setbacks has to be there, has to be there.
But as per the plan, my lords, construction was carried out. Later on, my lords, we got to know that after the show cause notice, there were some variations in setback. My lords, we applied for the revision plan, my lords, because as per the, my lords, our earlier engineer, my lords, he has committed some mistakes. So we changed the engineer, my lords, so we applied for the revision of the plan. My lords, that revision of permission, my lords, is actually rejected after, my lords, the deemed permission, my lords, after under section 5.
Deeming provision will only apply as long as it is in accordance with the building bylaws.
Yes, my lords.
Can't be contrary to that.
It cannot be contrary to
If
that.
there is setback violation,
Please.
even if we accept there's a deemed one,
But now, my lords, if my revision permission is accepted, my lords, deemed to be accepted, my lords, the only variation, there might be a little variations, my lord, as far as
that will be demolished.
that, my lord, because for more little less than 5%, my lord, that would be compoundable as such.
5% come area.
Innu ashtu kadme
Verify that because that application for
Where
revised
is the
plan.
where is the report?
My lords, I'll secure that. My lords, I'll put all that, my lords, in my spread of objections.
Learned
Because the
counsel for respond number 2, seeks fund is granted a week's time to
10
place
days.
on record,
10 days.
place on record the inspection report as regard the construction carried out by the petitioner, respond number 3 to 5. And if there is any violation of the, by the said construction of the building bylaws and or the plan sanction. Relist on
my lords, one submission, my lords, because in view of the revision permission, my lords, there was earlier building permission which was issued, my lords. Thereafter,
building bylaws and
that may be clarified, my lords, without
building bylaws and or.
The revised application was filed after we issued final notice for violation, after we got the report.
See, if there is a revision which can be made, which can save the building,
That, my lords.
that should be done. If despite revision, it cannot be saved, then we'll have to demolish it. If there is any particular violation which can be rectified by a rectified plan or a modified plan or a revision plan, yavadaru use ಮಾಡ್ಬೋದು.
That should be
permitted.
If cannot be, my lords, corrected, then the only,
No need to demolish something which can be rectified.
please.
If it cannot be rectified, yes. ಇಬ್ಬರದನ್ನು ಹೊಡೆದಾಕ್ಬಿಡಿ.
In fact, my lords, yes. Round of litigation.
My lords, ಈಗ
This
other
was
side-
my lords observation of this honorable court.
ಎಲ್ಲ ಬಿಲ್ಡಿಂಗ್ ಇದರಲ್ಲಿ ಇಟ್ಸ್ a neighbor or a family member who goes and complains. Until then they are sleeping. Everybody is happy. Once you do this fight, you wake them up and you wake the court up. ನಮ್ಮ ಮುಂದೆ ಬಂದ ಮೇಲೆ ನಾವು we can't do anything. We'll have to direct demolition.
In fact, my lords.
It is for you people to sort out in violations of whatever. We can't say. Property is valuable, hard-earned money has been put in.
21 flats, my lords.
If you fight,
In fact, that building, 21 flats may have been put up.
ಅಂದ್ರೆ ಎಲ್ಲರೂ ಸೇರಿ ಜಾಯಿಂಟ್ಲಿ ತಗೊಂಡು ಒಂದೇ ಪ್ರಾಪರ್ಟಿ ಜಾಸ್ತಿ ಕಟ್ಸಕ್ಕಾಗಲ್ಲ ಅಂತ ಎಲ್ಲರೂ ಸೇರಿ ತಗೊಂಡು ಕಟ್ಸಿದ್ರು.
ಇಲ್ಲಿಗೆ ಬಂದ ಮೇಲೆ ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ.
That's true, my lord.
There is no equity. 21 ಇರ್ಲಿ 300 ಇರ್ಲಿ 1000 ಇರ್ಲಿ, it doesn't matter. ಮರಡಿ ನೋಡಿದ್ರಿ, ನೋಯ್ಡಾನು ನೋಡಿದ್ರಿ ತಾನೆ. You can't do anything. Only you will have to rectify. So if you can rectify, rectify it. Relist on 12th.
Yes.
Your lordship, permission. I'm filing the statement of objection, your lordship. I have served the other side copy.
Yes.
Please.
Where is the consent?
Please, and your lordship, with respect of the last time submission I have made, as per the instruction of the authority, your lordship, I have made the submission that they have participated in the proceedings before the deputy commissioner.
Where is the consent?
Please, the notice I am producing, sorry, your lordship, today morning I have
We
got
are
the
not
notice. so
concerned
I-
with your notice, 100 notices are there. We'll record your Ms. So-and-so consents to the petitioner to be allowed, petition allowed.
Please, sorry, Your
You are
Lordship.
participating. You are here.
As per the instruction by the authority, I have made the same submission, Your Lordship.
Where is the
including-
consent? You show us the consent.
Even I have stated same before statement of the objection.
But there is no consent.
Please.
There is no consent
Even I
document.
have not filed the objection for the same also, Your Lordship. I have produced the notice just now.
Madam, please be very clear on this. We'll take very strict action against your officers if they are giving these kind of instructions. Very strict actions. And if you are going to be parroting out their submissions, we'll take action against you also. This is not the kind of submission which can be entertained. We are saying there's a consent, produce the consent. If not, there's no consent. We can't explain it to you better than saying that you consent and we are allowing the petition. Because you are participating. Artha ಮಾಡ್ಕೊಳ್ಳಿ.
Yes, and in the previous occasion, I have submitted the proceedings before the deputy commissioner, which petitioners also participate. In fact, the instruction which I have received in the parawise remark which they have sent me, on the basis of that, they have instructed me to make a submission that the proceedings were taken place before the deputy commissioner. But after that, immediately after the court, after the over of the case, I immediately called the officer to concerned department, and they said that they were there in the before the deputy commissioner. But what has happened is they said that initially they were orally they have agreed, but they did not sign to any of the documents. And they said after the meeting with the officials of the municipality, they said they'll see it in the court. It's what my respectful submission, because they only have stated me that the proceedings
Same
were taken.
repeat. ಕೇಳಿಸ್ಕೊಂಡ್ರಲ್ಲ ಅದೇ ನಿಮಗೂ repeat.
The
I
due
should not
res-
have I do understand.
If your officers are going to now say there's a oral consent without anything being in writing,
That should not.
and they have not taken it in writing, if they had consented, then they don't have any right to be discharging their duties as that particular post and be instructing now like this.
My respect.
What are the names of those officers and designations? Kodi?
with your
Who has
Lordship
instructed you
permission.
like this?
With your Lordship permission, with the due respect, your Lordship.
Yes.
Your Lordship, the proceedings which are held before Deputy Commissioner, after that, your Lordship, the Gazette notification has been made. The same is produced before this court.
Yes.
The annexure R1, your
That you have
Lordship.
argued all the-
Subsequent, please, I'm not arguing on the merits, your
You
Lord.
already
Subsequently,
argued
your Lordship, the work has been delegated to municipal corporation, that is to us, your Lordship. Before that, Deputy Commissioner has conducted the proceedings. The same has been communicated to us, your Lordship. The same we have placed before this honorable court. And I apologize
You
for the
are
statement.
appearing for whom?
Municipal corporation, your Lordship.
And you are appearing for?
Same.
Ibru Corporation.
Same.
She is my colleague. I was held up.
ಮತ್ತೆ ಇಬ್ರು ಏನಕ್ಕೆ ಆರ್ಗ್ಯೂ ಒಬ್ರು ಆರ್ಗ್ಯುಮೆಂಟ್
She'll make
The same, your Lordship. And one more submission, your Lordship. We are not denying for the granting compensation to the petitioner, your Lordship. Now they are relying on the section 14B subclause 6 of the Town Country Planning Act.
Yes.
Kindly see the section, your Lordship, what it says.
ಕೊಡಿ KDCP Act.
If with your Lordship permission, may I read it, your Lordship?
Yes, let us also get the book. KDCP Act.
Karnataka Town and Country Planning Act.
Town and country.
Yes, 14,
14B subclause 6, your Lordship.
6.
May I read it, your Lordship?
Yes.
Please. If the owner does not agree to surrender his area required by the public authority for any public purpose for the development right and demands for the money, your Lordship. Please be noted that demands for the money, monetary compensation. Then the public authority may acquire such area by providing compensation as per the provision of the Right to Fair Compensation and Transparency Act 2013.
Yes.
As on today, we have not denied anyway the compensation. They have not made the representation, minimum representation also for the compensatory benefits, your Lordship. There is no demands. Directly they have approached, your Lordship, 3 times we have gave the notice. The 2 notices I have produced in the statement of objection. Once,
Where is your acquisition notification, madam?
please, your Lordship, annexure R1, your Lordship. In that, your lordship clearly has stated by giving the TDR, we are going to acquire the land. R1, your lordship.
R1.
In my statement of objection, it starts from the page number 5, your lordship.
Yes.
In that, your lordship, including the owner name, your lordship, we have clearly stated that by giving the TDR at page number 10, your lordship, petitioner name lies, your lordship.
Serial number?
12, your lordship. Clear stated how much land is going to acquire and his name and which portion of the land is going to acquire it. He has not challenged the gazette notification as well as not given the objection.
Notification.
Please, your lordship.
Final notification.
Please, subsequently on the same, your lordship, we have given notice at annexure R, page number 20, your lordship. Page number 20, your lordship, we have given notice that 21/5/2022, the petitioner has signed in the first 2 columns, your lordship. He has received the notification to
Where
conduct
is
the survey.
The final notification.
Please, your lordship. The gazette notification itself is annexure R1, your lordship. The final notification. After that, the project has been delegated to municipal corporation. After conducting the proceedings before Deputy Commissioner, your lordship, the notification has been made and as per the annexure R1 and the project has been delegated to municipal corporation authority. Only with respect of issuing the TDR and receiving the DRC and to widen to construct the plan.
Issued under which provision?
Please, your lordship.
Annexure R1 is issued under which provision?
Says under section, that is section 14B of the Town and Country Planning Act.
14B is
14B.
only a benefit of development rights.
Please.
Where is the acquisition?
That's the same provision, your lordship, they have made it. As on today, they have not challenged that gazette notification. And they have received the notice. They have not filed objections. In fact, they have not made the minimum representation to seek compensatory benefit.
Pointing out,
Please.
from that time we have been telling you, where have you done your work and ಕೇಳ್ತಾ ಇದೀವಿ.
It is not we, your lordship, we are going to issue the notification or acquire the land.
Sit down. If you don't do anything, then you please sit down. Don't make your submission. Let the state say it. State ಮೇಲೆ allegation ಮಾಡ್ತೀರಾ, ಇವ್ರ ಮೇಲೆ allegation, ಇಬ್ಬರ ಮೇಲೂ allegation ಮಾಡ್ತಾ ಇರೋದು ನೀವು ಆವಾಗಿಂದ.
Since they have filed.
What have you done ಅಂತ ಕೇಳ್ತಾ ಇದ್ರೆ ಅದೇನು ಇಲ್ಲ. You just want to make allegation against everybody. Yes, Mr. Kannur, you are appearing in this. Have you acquired this land? ಎಲ್ಲ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಮಾಡಿದ್ದು ನಮ್ಗೆ ಬರೀ ಡೆಲಿಗೇಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತಾರೆ. ನೀವೇನ್ ಮಾಡಿದ್ದೀರಾ? ಯಾಕೆ? ಸರ್ ಮಾಡಿಲ್ವಾ?
Respondent 1 and 2 are the government.
They are saying you have handed over the land. If you have handed over the land, have you acquired the land? Without acquisition, you can't hand it over to them.
There should be acquisition, lordship. There should be acquisition.
No person's property can be taken over without acquisitions. Simple. He is not consented to TDR. He is not consented to the amount. So it has to be under the 2013 Act. Without that happening, you could not have handed over, they could not have done anything. Whatever they have done, we will demolish that. If they do it without acquisition, if you have done it without acquisition. Learned Counsel for Respond number 3 and 4 has filed a statement of objection. The same is taken on record. The contention now addressed, the argument now addressed is that everything has been done by the Deputy Commissioner and the property handed over to Respond number 3 and 4. And as such, Respond number 3 and 4 do not have any consent from the petitioner. Be that as it may, on inquiry as to whether acquisition of the land has taken place, the Counsel for Respond number 3 and 4 is not in a position to make any submission, except to state that it is the Deputy Commissioner who has handed over the possession. And the learned AGA is directed to secure instruction, make a submission as to whether the land of the petitioner has been acquired. If so, to place on record the preliminary and the final notification in relation thereto. Since the absence of any acquisition, any action taken by the deputy commissioner and consequently by respondent number 3 and 4 would have to be set at naught and the property restituted to the petitioner. Relist on 12th February.
Please.
Till then, the respondents are restrained from any manner carrying out any works.
They are completed. They are completed.
With respect to petitioner property, we have not touched anything. Your
Everything has
Lordship.
been done.
If you have not acquired, whatever you have constructed will be demolished. Whatever, then a railway track take
With respect to petitioner
we
property.
direct it to be removed. You have to follow the law.
Please.
If you don't follow it, it will go.
Please. Great.
Great.
See, number 28, 73 and 74 are identical, my lords, and covered by my lords. Are all three are identical matters.
How the identical? 28?
73 and 74, my lords. Where, my lords, pursuant to property acquisition of property by me under a registered sale deed, my name is not, my lords, mutated in the municipal records. Only on the ground that, my lords, there's a objection by, my lords, the police department saying that, my lords, they have the rights over the property. The endorsement impugned by me, my lords, is at annexure B, page number 17, my lords.
17.
17. This is after I, my lords, apply for change of khata in my name.
17 is the same.
18 months.
Sorry, bro.
Annexure B is page 18. Annexure
18, my lords. I had taken the other petition.
Patra.
Please.
That's not objection.
Himbara, my lords. Page number 20.
Annexure D, page number.
Annexure D. Page 22. ಅದರಂತೆ ನಿಮ್ಮ ಅರ್ಜಿಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಸದರಿ ಆಸ್ತಿಯು ಪೊಲೀಸ್ ಠಾಣೆಯ ಪ್ರದೇಶದಲ್ಲಿ ಬರುತ್ತಿದ್ದು ಪೊಲೀಸ್ ಇಲಾಖೆಯವರು ಈ ಆಸ್ತಿಯ ಬಗ್ಗೆ ಹಾಗೂ ಪೊಲೀಸ್ ಇಲಾಖೆಯ ಪಕ್ಕದಲ್ಲಿ ಇರುವ ಆಸ್ತಿಗಳ ಬಗ್ಗೆ ಘನ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ದಾವಾ ಹೂಡಿರುತ್ತಾರೆ ಎಂದು ತಿಳಿಸಿ ಇದನ್ನು ಘನ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಇತ್ಯರ್ಥಪಡಿಸಿದ ನಂತರ ನಮೂನೆ 3 ನೀಟ್ ನಂಬರ್ ದೇರ್ ಇಸ್ ನೋ ಸೂಟ್ ಮಾಡಲ್ಸ್
ಹೇಳಿದಾರಲ್ಲ
they have made oral allegation the department but there is no suit as such. There is no proceedings pending.
I am appealing for respondent number 1, my lords. Since the respondent number 2.
Respondent number 1. Who is respondent number 1?
The municipal council, my lords. Town Panchayat.
This endorsement has been issued by you.
Me, my lord.
Before issuing the endorsement, did you verify if there is a suit pending?
That's what happened in this case, my lords. The respondent number 2 has filed an objection, stating that, my lords, this property belongs to me. The survey number 90.
And they say that there is a suit pending.
Suit pending.
Did you ask them to furnish the suit papers?
No.
ಒಂದು ಕೆಲಸ ಮಾಡಿ ಯಾವ್ದಿದು
ಮರಿಯಮ್ಮನಹಳ್ಳಿ ಟೌನ್ ಪಂಚಾಯತ್ ಮರಿಯಮ್ಮನಹಳ್ಳಿ
ಅಲ್ಲೆಲ್ಲ ಒಂದು 4-5 ಎಕರೆ ಇರಬಹುದು.
ಇಲ್ಲ
ವಿಲ್ ಶ್ರೀರಾಮ್ ನಂದರ್ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಹೇಳ್ತಾರೆ, ಅವ್ರ ಹೆಸರು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿ ಕೊಟ್ಬಿಡ್ತೀರಾ?
As per the resolution and all submitted by the police authorities.
Police ಅಂತ ಹೇಳಿದ್ರೆ ಏನು ಡಿಫರೆನ್ಸ್ ಏನಿಲ್ಲ. Did you discharge your duties? You did not. ಎಲ್ಲಿ ಸೂಟ್ ಯಾವುದು ಮಿಸ್ಟರ್ ಕನೂರ್? ಹಾಕಿದಿರೋ ಇಲ್ವೋ? What is your instructions? All three properties same.
All three properties same, and my lords, there are earlier
28, 73 and 74 connect to each other.
Please.
The petitioner is aggrieved by the endorsement dated 12/6/24 annexure D issued by respondent number 1 on the basis of the objection submitted by respondent number 2 denying the transfer of khata in the name of the petitioner. In the said endorsement, it is stated that respondent number 2 has informed respondent number 1 about a suit being pending, and as such, there being a claim of the police department, the application of the petitioner cannot be considered. Learned counsel for respondent number 2, respondent number 1 submit that the papers relating to suit have not been furnished to the respondent number 1. If that be so, respondent number 1 ought not to have issued the endorsement without verifying the documents. However, in order to ascertain the veracity of the submission made by objections filed by respondent number 2, and AGI is directed to secure instruction and make a submission as to whether indeed a suit has been filed, and if such a suit has been filed, to place on record the plaint, the written statement, as also the status of the said suit. Released on 12th February.
Please, may request to be listed in preliminary hearing, my lords.
It will come in wherever.
Please, obliged.
It was exam day for yesterday. The respondent shorter time. Not shorter 13 and rule 1 and 2.
Sale deed.
Sale deed. No.
Where is it? Passover.
This notes I was the defendants are before my lords.
Notes, I has not been served to me. I for additional document has been filed.
Only photograph is not produced. I will serve the copy, my lords.
You will record one photo.
Adar jotene kottidru nam colleague. I will serve.
Counsel for the petitioner undertakes to serve copy of IA1 of 24 on the counsel for respondent number 1 to 5 by end of day today.
Please.
Released on 5th.
For the petitioner, my lords, respondent counsel has produced the documents today, my lords, additional documents.
You have produced today.
But I'm just showing, my lord, the photographs, my lord, regarding the construction.
Oh,
I have served the copy to them.
Yavaga?
Morning, I have given a copy.
Morning.
The same photograph, my lord. Inne kottidare nanage documents.
ನೀವು ಕೊಟ್ಟರೆ ನೀವೇ ಅದೇ ಹೇಳೋದು.
May I request tomorrow, my lord, because
counsel for the petitioner has filed certain additional documents today, which has been served on the counsel for the petitioner today morning. Counsel for the petitioner seeks for and is granted 2 days time to obtain instruction, make a submission. Released on 31st.
But I request, my lord, tomorrow, my lord, because construction has been stopped.
Instructions, but
the same photograph, my lord, I have produced the colored photograph.
If you are such a hurry, you should have given it to him yesterday.
My lords, interim order can be issued.
Interim order earlier.
Because my construction has been stopped, my lord, for that. 31st, my lord. Yes.
Now, this is regarding the.
Lord, in this matter, I was directed to, Lord, take notice. In this matter, I was directed to take notice. But I would file wakalat, Lord, next week, Lord.
2018 matter.
Please, 18 matters. Recently, Lord, I was
private respondent. Lord, counsel for respondent seeks for and is granted.
Lord,
next time.
Date may be given, my lord.
To obtain instruction, make his submission. Released on 11th February.
Lord, I am appearing for respondent number 5. Lord, I have been directed to take notice for respondent number 5. Lord, I have not been served a copy of writ petition. Lord,
I will, lords, maybe due to inadvertence, lords, I had instructed.
ನೀವು urgent ಅಂತೀರಾ ಬೇಗ ಕೊಟ್ರೆ ನೀವು.
I had instructed, lords, due to inadvertence. I will serve a copy today itself, my lords.
Counsel for the petitioner undertakes to furnish 2 sets of the petition along with annexures on the respective counsel for respondent who seek for and are granted 10 days time to obtain instruction, make the submission.
One more submission.
7th January.
One more submission. My grievances against the order passed by the tribunal. Lords, my friend appears for a formal party. On previous occasion, your lordships were pleased to direct, lords, the government to ascertain, my lords, as to the status, my lords, of the employees who would have been appointed prior to the grant in aid. but have crossed the
age of. Yes.
There's a note. Submission, my lords.
Your
It's a
call.
gazette notification. I appear for respondent number 1, my lords.
The employee.
Employee, my lords.
Yes.
There's a notification, my lords, which addresses the question, my lords, raised in the previous occasion. Lords, even this has been marked as exhibit P16, my lords, in the before the tribunal, my lords.
Copy ಕೊಟ್ಟಿದ್ದೀರಾ?
Copy, my lords. It's been marked as
ಕೊಡ್ತೀನಿ ಅಲ್ಲ
exhibit P16.
ಕೊಟ್ಬಿಡ್ಬೇಕು ನೀವು.
ಅಲ್ಲ, ಅದು exhibit mark ಆಗಿದೆ. So, impression, my lords, it is with the petitioner. Sorry, sir.
What do you want to rely on?
My lords, I want to rely, my lord, upon the page second, my lords. My lords, it starts, my lord, in the previous page. ಶೈಕ್ಷಣಿಕ ಸಾಲಿಗೆ ಸಹಾಯ ಅನುದಾನವನ್ನು ನೀಡಲು ಸರ್ಕಾರದ ತೀರ್ಮಾನ ಆಗುವ ಮೊದಲು ಅಂದರೆ ದಿನಾಂಕ 4/9/2008 ಪೂರ್ವದಲ್ಲಿ ಸಂಬಂಧಿಸಿದ ಶಾಲಾ ಕಾಲೇಜುಗಳ ಆಡಳಿತ ಮಂಡಳಿಯಿಂದ ನೇಮಕಗೊಂಡು ನಿರಂತರವಾಗಿ ಸೇವೆ ಸಲ್ಲಿಸುತ್ತಿರುವ ಶಿಕ್ಷಕರುಗಳಿಗೆ ಒಂದು ಮಾರಿಗೆ ಮೀಸಲಾತಿಯಲ್ಲಿ ವಿನಾಯಿತಿ ನೀಡಲು ತೀರ್ಮಾನಿಸಿದೆ. ಇಂಥ ಸಂಸ್ಥೆಗಳಲ್ಲಿ ಭವಿಷ್ಯದಲ್ಲಿ ಯಾವುದೇ ಕಾರಣದಿಂದ ಉದ್ಭವವಾಗುವ ಹುದ್ದೆಗಳನ್ನು ಮೀಸಲಾತಿ ಮಿತಿಯನ್ನು ಸಾಧಿಸುವವರೆಗೂ ಬ್ಯಾಕ್ಲಾಗ್ ಹುದ್ದೆಗಳೆಂದು ಕಡ್ಡಾಯವಾಗಿ ಪರಿಗಣಿಸಿ ನೇಮಕಾತಿ ಮಾಡಿಕೊಳ್ಳತಕ್ಕದ್ದು ಹಾಗೂ ಈಗಾಗಲೇ ಮಿಕ್ಕಂಡ ಅವಧಿಯಲ್ಲಿ ಖಾಸಗಿ ಆಡಳಿತ ಮಂಡಳಿಯವರು ಪರಿಶಿಷ್ಟ ಪಂಗಡವರು ನೇಮಕಾತಿ ಮಾಡಿಕೊಂಡಿದ್ದರೆ ಅವರುಗಳನ್ನೇ ಮುಂದುವರಿಸತಕ್ಕದ್ದು ಎಂಬ ನಿಬಂಧನೆಗಳೊಂದಿಗೆ ಮೇಲ್ಕಂಡ ವಿನಾಯಿತಿ ನೀಡಲು ಉದ್ದೇಶಿಸಿದೆ. This is a concession with respect to, my lord, who are serving, my lord, since continuously in the aided institution, my lords, since 1990 to 1993, my lords. This respondent number 1, my lords, appointed as the assistant teacher in the year 1992, was promoted as headmaster in.
38/2007 is the cutoff date.
Please, my lords.
ಪೂರ್ವದಲ್ಲಿ ಮತ್ತು 93-94 ಮತ್ತು 94-95 ನೇ ಶಿಕ್ಷಣಿಕ ಸಾಲಿಗೆ. Then why is this 93-94 coming there? ಪ್ರಸ್ತಾವನೆ ದಿನಾಂಕ 1/6/87 ರಿಂದ
Institution has been brought under the grant-in-aid scheme in 2007, my lords.
So the institution started between 87 to 92-93.
Please, my lords.
So from 93 to 2007.
Please, my lords. Considering cases in exceptional circumstances, my lord, they have given concession.
The fourth condition may kindly be perused, my lords. ಈ ಶಾಲಾ ಕಾಲೇಜುಗಳಲ್ಲಿ ನೇಮಕ ಆಗಿರುವ ಶಿಕ್ಷಕಗಳನ್ನು ನೇಮಕ ಆಗಿರುವ ಹುದ್ದೆಗೆ ಅರ್ಜಿ ಸ್ವೀಕರಿಸಲು ನಿಗದಿಪಡಿಸಿರುವ ಕೊನೆಯ ದಿನಾಂಕದಂದು ಜಾರಿಗೆ ಇದ್ದ ನಿಯಮಗಳ ಅನ್ವಯ ನಿಗದಿಪಡಿಸಿರುವ ವಿದ್ಯಾರ್ಥಿ ಮತ್ತು ವಯೋಮಿತಿಯನ್ನು ಹೊಂದಿರತಕ್ಕದ್ದು. Again, my lords, the age limit would come as a bar, my lords. For
Does they say 40 years for that?
That is as per the
superannuation. At the most, this can be read as superannuation.
No.
Not
My
40
lords.
years. Where do they say 40 years for this?
40 years is in another regulations, my lords. This says, as per condition 4 says,
40 years is for you to employ a new teacher.
Please.
Not be more than 40 years.
40 years.
That is for a new teacher after being admitted to grant-in-aid.
Please, my lords.
When you are admitted to grant-in-aid, after being admitted, you can't hire any teacher or
new teacher,
assistant teacher or headmaster who is more than 40 years.
Please.
This is not imposing any 40-year restriction because you are been in business of education from 1987.
Business service.
87 to 2008 andre,
please.
It is 20 years. Even if you hired a person at 23,
40.
it will be 43. That means if we accept your submission, all the teachers hired will have to be removed from service once you are admitted to grant-in-aid.
Right. I'll verify this aspect.
Acceptable.
I'll verify this aspect and address. I understand, I followed your lordships.
Logically and legally, it does not make any sense.
Correct.
It, only you, after 2008, you can't.
New hiree, my lords.
Automatically, whoever has been there with you.
Please.
They have to be admitted and be given the salary.
Granted. Please.
The conditions for new appointment are there.
Please. I followed.
Because admission is on the basis of all the details that you have furnished. Nammal students idare, ishtu pass percentage ide, ishtu teachers idare, ishtu non-teaching staff idare, ella would have been considered before
Admitting to granting it.
That those people cannot be deprived.
Please.
By your management taking advantage. Avrindane nim bandidadu. You can't take advantage of that.
Please.
Learned counsel for the petitioner has filed a memo enclosing a government order dated 2/6/2011. Based on the said government order, he submits that all employees, all teaching staff of an educational institution who had been engaged by the institution prior to granting aid would have to be given the benefits of the grant in aid. And I said the respondent number 1 in the present matter has also been correctly granted the relief sought for by the trial before the tribunal. And counsel for the petitioner once again reiterates by relying on condition number 4 of the said government order that the age limit which is imposed and if a person has crossed 40 years as on the date on which the education institution was admitted to grant in aid, such teaching staff who had crossed the age of 40 will not be entitled to the benefit of grant in aid. When pointed out that there is no such condition which can be read into, there is no such requirement which can be read into condition number 4. The same only could refer to superannuation of the teacher and not the age limit of continuation. He seeks for and is granted 4 days time to obtain instruction, make his submission. Released on 6th February.
Please.
Pleasure. A week's time.
Please.
Lord, the 34, my lord, point 34 matter, my lord, is entirely different from 34.1. 34, my lord, arising out of an order in the suit, my lord, allowing the application seeking impleadment, my lord. Lord, the proposed defendant number 7, he claims to be the devotee of a temple. The suit is filed saying that the property belongs to temple and the defendant number 3 has without right has sold the property and declared the sale deed as null and void. So in that, my lord, devotee claims to be the devotee of a temple. His application is, I am the devotee of a temple.
Come on record. Can a devotee come on record in a suit for what is where's the plaint?
Your lordship, pleased to see.
Annexure
This
is
the
the
trust
application.
property, my lord. Temple trust.
Where is the prayer?
Prayer in the plaint may please be seen at page number.
Plaint prayer, my lord, page 25, my lord.
Declared that the sale deed is null and void. This is a suit filed by
A property purchased by the trustee himself. Property of the trust. Purchased by the
suit
trustee
is
himself.
Filed by is not binding upon trust.
Yes, my lord.
Filed by 2 individuals.
Yes.
Not to individuals who are said to be the interested persons in the trust.
How can they say that it's not binding on the trust?
No, my lord, the trust property is purchased by the trustee.
The petitioner, the plaintiffs have bought it.
No, my lord, the plaintiffs have challenged that. The defendant number.
Defendant number 1 and 2 is the trust.
Naji Pagad
Yes, my lord.
and Vijay Krishna Rao Pagad.
Yes,
The relief sought for,
yes,
it be declared that the sale deed dated 4/5/94 is null and void
yes,
and not binding upon the trust.
yes.
The sale deed is,
Prayer is further, a decree for possession may also be passed directing defendant number 3 to hand over the possession of the suit property to the trust. A decree for consequent relief of injunction may also be passed against defendant number 3 to 6. And in favor of the plaintiff, restraining defendants or anybody acting on their behalf from disturbing the peaceful possession and enjoyment of the suit property by defendant number 1 committee of Kittur. Any other relief?
in this,
In
the
this
short
suit, my
point
lord,
involved in this writ petition is
Where
that
is the sale deed? Who has executed this 4/5
defendant number 3, my lord, has executed the sale deed.
in favor of?
Defendant number 4, my lord.
Of the property of the
A
trust.
trust, my lord. In that, my lord,
And
the
when he
proposed.
himself was a
one minute,
trustee.
In that, my lord, the proposed defendant number 7, he claims to be the devotee of a temple, wants to come on record.
the short point is, the suit is filed, suit is being tried. And it is a trust property that is being challenged.
Yes.
And in this case, one of the person interested in the trust, I filed application.
Are you a trustee?
I'm not a trustee, but it is a public trust, registered public trust.
So everybody, every
Any
devotee can come on record.
any devotee may not, the trustees themselves together, what they have done is, your lordship may please to see, trustees
Are you
themselves.
making any allegation against the trust?
No, my allegation is not against the trust.
Have you made any allegation defendant number 1?
Defend number 1, yes. Not against defend number 1. My allegation is that they are trying to collude and close the case. That is why I sought myself
Who
to,
is colluding?
the defendant number 1 trust who are now claiming themselves to be the chairman and other things, they have challenged this application. The lordship may please to see, the plaintiff has not challenged the application allowed. The defendant number 1 claiming that they are not chairman also, they claim themselves to be the chairman and office bearers of the trust.
So you have to initiate suitable proceedings.
And instead of multiplying proceedings, my lord, I sought myself to be included as one of the defendant.
Be granted
Now,
here.
how this is being affected by defendant number 1 and 2? This ought to have been challenged by plaintiffs. If they were aggrieved in their suit, I coming there, this is not the challenge before this court by the plaintiffs. This is the challenge by the one of the defendant.
If your contention is that Sri Krishna Tammaji Kotabagi is not the chairman of Vittal Devasthan Trust Committee Kittur, your relief is somewhere else, not by impleading yourself in these proceedings.
No, this proceedings, my lord, this is a public, order 1 rule 8 may please be seen. Public are interested in this.
This is not a representative suit. Is it a representative suit?
In the nature of representative suit, that's all.
Is it a
The
representative?
suit, because they are not, they are also devotees who have challenged that. The challenge made by the plaintiffs,
Who are the plaintiffs?
they are also devotees.
Only devotee. You are not trustee.
Pardon?
They are the members of the trustee, plaintiffs.
You are a trustee or a devotee?
Chairman and
Now
secretary.
the plaintiffs there, this is not the writ petition by the plaintiffs.
Petitioner is who? Vittal Devasthan Trust, Vittal Devasthan Trust, so and so. Represented by.
Your lordship may please to see.
One ನಿಮಿಷ ನಿಮ್ಮ ಫ್ಯಾಕ್ಟ್ಸ್ ಸರಿಯಾಗಿ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ ಇಲ್ಲಿ. President Sri Narasimha, Secretary Prahlad.
In my suit, they are not the secretary or the president. In plaintiff, your lordship is pleased to see.
Not a party to that proceeding.
Lord, they retired, defendant number 1 and 2, they retired from the post of president and secretary. A resolution was passed, my lord. And by virtue of resolution, we have been appointed as a president and secretary. Your lordship, I have produced the resolution after the wakalat, your lordship, may kindly. I have given a note in the cause title also.
And that application they have not filed in the trial court.
We have filed.
And their resignation or their becoming chairman or office bearers
He has no
has
locus.
not been accepted at all by the
Lord,
district
he
court.
being already not being a party to the suit, he cannot question my locus to challenge the petition, challenge the impugned order.
Where is the resolution appointing you?
Lord, after the wakalat I have produced.
Signed by the president and the secretary.
Yes, my lord. Illi
By yourself.
Illa,
You are the president and secretary.
yes.
Resolution is signed by you.
Yes.
Where is the minutes of the meeting? Where the
Minutes
resolution
I will submit. My lord.
signed by all the trustees?
Yes, my lord. Minutes I
It
will.
is self-certification. Is it?
It is only for the purpose to show that the locus standi to file the writ petition. That's all.
Self-certified document authorizing you.
Lord, now it contains a recital. Your lordship may kindly see. ಈ ಹಿಂದೆ ಸೆಕೆಂಡ್ ಲೈನ್ ಲೋಡ್ ಈ ಹಿಂದೆ ಕಾರ್ಯನಿರ್ವಹಿಸಿದ ಅಧ್ಯಕ್ಷರಾಗಿ ಶ್ರೀ ಸೋ ಅಂಡ್ ಸೋ ಹಾಗೂ ಕಾರ್ಯದರ್ಶಿಗಳಾದ ಸೋ ಅಂಡ್ ಸೋ ಜೋಶಿ ಈ ಮೊದಲೇ ಸ್ವ ಇಚ್ಛೆಯಿಂದ ನಿವೃತ್ತಿಯಾಗಿದ್ದು ಅವರ ಸ್ಥಾನಕ್ಕೆ ಶ್ರೀಯುತ ನರಸಿಂಹ ರಾಮಚಂದ್ರ ನಾಯಕ್ ಹಾಗೂ ಪ್ರಹ್ಲಾದ್ ನರಸಿಂಹ ಶಿಗ್ಗಾವಿ ಅವರನ್ನು ಅನುಕ್ರಮವಾಗಿ ಅಧ್ಯಕ್ಷರು ಹಾಗೂ ಕಾರ್ಯದರ್ಶಿಯಾಗಿ ಸರ್ವಾನುಮತದಿಂದ ಟರಾವಿಸಿ ನಿರ್ಣಯಿಸಿದ್ದಿರುತ್ತದೆ. I will produce the minutes.
Where is that minute?
I will produce the minute.
Counsel for the petitioner seeks for and is granted.
Please, weeks recommendation.
Weeks time to produce the minutes of the meetings of the trustees.
Yes.
Of Sri Vittal Devasthan Trust Committee Kittur, appointing Sri Narsimha son of Ramchandra Nayak as the president and Sri Prahlad son of Narsimha Shiggavi as secretary of Sri Vittal Devasthan Trust.
Please.
Released on 5th February.
With Lordship's permission, 3rd or 6th?
6th February.
6th, my lord. Sorry, my lord. 6th. I'm sorry, my lord. 6th.
7th, okay na?
6th and 7th.
All right, 5th, let it be posted on 5th, my lord. I will manage it.
5th, my lord.
5th, let it be posted on 5th.
You are causing inconvenience to Mr. K.L. Patil.
No, my lord. I am sorry, my lord. 7th ಆದ್ಮೇಲೆ any date.
Or 3rd, it may be posted.
ಅದು 3rd ಬೇಡ ನನಗೆ.
Bench may be not sitting.
After 7th, any date, my lord.
4th to 7th, any date or after 10th?
5th, it may be posted.
10th.
5th, yes.
Please.
ಇದ್ರಾಗ ಇನ್ನೊಂದು ಐತಿ. One more main matter is.
ಅದೇನದು separate matter.
That matter
erroneously clubbed with this petition.
That matter pertains to the same trust. This honorable.
She is not there in this.
Allah, it is no way concerned with this.
You are not there in this.
But the property and the trust is the same.
If you are not there in this, you cannot say anything.
Yes.
Kindly see the prayer of the petition, my lordship. A miscellaneous petition is filed before the district court.
Lord, my presence may be dispensed.
You are not present on.
Not Patil.
Who are you? ಅಂತ ಕೇಳಬೇಕಾಗತ್ತೆ.
Seeking approval of the manager.
23.
Yes, my lordship.
Filed by under.
Filed by
3 and 8.
Yes, my lordship.
That itself is not maintainable.
Yes, my lordship.
That is even this honorable court had passed such order. The coordinate bench also the division bench, my lord, recently reportable judgment, wherein they have made it absolutely clear that no such proceedings and no such can be entertained.
Yes.
The question is.
So if that proceeding itself is not maintainable, he really think.
And the first part of the prayer may be
Now
looked
that
into,
what
my
has
lordship.
happened is, I am please permitted to say, my lord, this is
Our
a
petition order.
this is a public trust. There is no committee, nobody. The person who has made allegation, myself, my lord, against the trustee who purchased the property of the trust, he is managing everything behind the back.
Go under section 92.
92 is correct, my lord. Now the persons who are managing there have neither they have got any authority.
Nimma prayer is mandamus directing 1 to 3. That is the state to take control of the affairs of respondent number Vittal Devasthan Trust, same. Till miscellaneous application number 242 of 23 is disposed.
They were claiming, because on the basis on that, they were claiming all those things.
So you have 242 ಏನಾಯ್ತು?
It is still pending
Pending.
disposal. There is no interim order, nothing is there. And we have made application there also, it is not maintainable, that is there. And now last
So
time,
242 is to be dismissed because the reliefs which are sought for are not maintainable. The question of interim order pending that disposal, this mandamus will not arise. We can only reserve liberty to it under 92 or
and one
applicable
more
law.
thing, urgency is that, my lord, now that the fair is there, last occasion, this honorable court made a interim,
24 in the itkondiddira idu.
last occasion, this court made a interim arrangement for that.
Huh.
And under the supervision of the Tahsildar, it was directed by this honorable court to conduct the fair and furnish the account to this court.
ನಮ್ಮ ಮುಂದೆನೆ ಶುರು ಆಗಿದೆ ಈಗ. Conduct jatra. That was on concession by the AG.
Yes, and then they approached in the writ appeal also it was confirmed saying, and then stated that the person who against whom we have made the allegations, he should not be taken part in this thing. And thereafter, again now, till now, the matter is pending before the district court. And in February 2012,
We had enough and more time to initiate appropriate procedure.
no,
We have not done it.
we will
We
appropriate.
can't continue this for another year, another jatra, another jatra.
Because of pendency of that miscellaneous petition before
is
the
not
district court, it
maintainable.
was. That is why, my lord, that because of this pendency, all this got, now that what I request is, immediately in the 12th of February, there is a fair. Now that the persons who are taking care is without any authority at all. This is a fit case wherein this honorable court may please to,
You did it, this time let them do it.
but last time now ಮಾಡಲಿಲ್ಲ sir.
Last time ಯಾರು conduct ಮಾಡಿದ್ರು?
ತಹಸೀಲ್ದಾರ್ಗೆ ಕೊಟ್ಟಿದ್ರು.
Tahsildar.
Tahsildar was supervising the
None
affairs.
of you will participate, only
No,
Tahsildar
no,
will conduct.
no. The managing committee, the present managing committee has assisted the Tahsildar in conducting the fair. And the Tahsildar, this court has directed the trust to deposit some amount with the Tahsildar. And Tahsildar has produced the accounts. And the contention of the Tahsildar is, the court has directed me to only receive the amount. He has not released any amount.
Good. At least that money is safe.
Every money, every single paisa is safe, my lordship. And as far as continuancy of management is concerned, in the Supreme Court, in the division bench judgment, it is held that only the petition before the district court is not maintainable. That does not invalidate the committee which has elected.
When is the fair?
12th, my lordship.
The same order as on
That is
9/1 will apply this year also.
no, my lordship.
And
When this honorable court has taken a view that the petition is not at all maintainable,
Now that the fair is there, we have to.
that fair is.
We'll list this on, we'll pass that order and list it on 17th and dismiss this petition. So that this issue will not arise next year.
On this itself, this court may pass such order. One moment, my lordship. One moment. Directing the trustees to produce the account on 17th. That we will do, my lordship.
Not there are no trustees
of
at all.
Tahsildar is also may be dispensed with. We undertake to produce all the accounts before this honorable court on 17th.
We can't change what has been already given on 9/1. Same order will apply now also. To change that is not possible.
No, my lordship. When this petition itself is
ಅದ್ ನೀವು ಲಿಸ್ಟ್ ಮಾಡ್ಬಿಟ್ಟು ಕ್ಲೋಸ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು. ಜಾತ್ರಾ ಇಟ್ಕೊಂಡು
today itself this honorable court may pass such order. We will undertake to produce all the accounts before this honorable court.
Then the vacuum and some issues should.
There is no vacuum at all, my lordship. This in division bench judgment also, the court has not held that the elected management is not invalid. Only the district court has no power to approve the management.
Yes.
The approval is not necessary. Yes. That does not invalidate the management.
And any dispute is under 92.
Yes, my lordship.
Where were you elected?
No, there is no, they are
That
not
resolution
of-
I have produced, my lordship.
Where are the minutes and where is the?
And they themselves, they say that 20% put together, they say that this is vacancy, you are chairman, you are on this. There is no such membership list is not there. There is no members, no meeting notice. They say that 22% signatures.
All this and the dispute, what we'll do is continue the 9-1 order. We list it on 17, dismiss, reserving liberty to both of you to go on.
In my, along with my
So
statement
next year,
of
both of you
objections.
don't raise this issue before another bench or same bench.
In my statement of objections, I have produced the minutes of the meeting which elected the managing committee.
Statement by 4 and 5, page number?
9.
R1. There are only 23.
Some 23 persons there, no notice, nothing.
Who are these 23 people?
No, nothing is there.
In annexure R9, my lordship.
R9.
At page number 27.
27. Yes.
Page number 27, the name of the trustees are mentioned.
This is your election so and so. Who are the people who elected?
If your lordship is
The
pleased
members
to-
who have signed in
page,
the
page
subsequent
25,
page number 31.
Page 25 may please be seen, my lord.
Where is the list of members?
No, that is what they mentioned in page number 25 in the first itself. Page number 25 may please be seen, my lord. Our R9 first
25 ಇದೆ.
Yes, I will. ವಿಠಲ್ ದೇವಸ್ಥಾನ ಕಿತ್ತೂರು ಬೆಳಗಾವಿ ಸರ್ವಸಾಧಾರಣ ಸಭೆಯನ್ನು 25/9/33 ನೋಟಿಸ್ ಪ್ರಕಾರ ಇಂದು 17/9/23 10 ಗಂಟೆಗೆ ಕಿತ್ತೂರು ಸರ್ವಸಾಧಾರಣ ಸಭೆ ಜರುಗಿದ್ದು ಸಭೆಯಲ್ಲಿ ಸಮಾಜದ ಮತ್ತು ಟ್ರಸ್ಟ್ ಸದ್ಭಕ್ತರು ಹೆಚ್ಚಿನ ಸಂಖ್ಯೆಯಲ್ಲಿ ಹಾಜರು ಸಭೆ ಕುರಿತು ಟ್ರಸ್ಟ್ನ ಗೋಪಾಲ್ ರಾಯ್ ಅವರು ಎಲ್ಲರನ್ನು ಸ್ವಾಗತಿಸುತ್ತಾ ಸಭೆ ಕರೆದ ಕುರಿತು ಪ್ರಾಸ್ತಾವಿಕ ವಿವರಿಸುತ್ತಾ ಈಗ ಸದ್ಯ ತುರ್ತಾಗಿ ಮಾಡಬೇಕಾದ ಕಾರ್ಯಗಳು ಹಾಗೂ ಹಿಂದೆ ದೇವಸ್ಥಾನ ಕೈಗೊಂಡ ವಿವರಿಸಿ ನಾವೆಲ್ಲರೂ ಸೇರಿ ಟ್ರಸ್ಟ್ಗೆ ದೇವಸ್ಥಾನಕ್ಕೆ ಮುಂದಿನ 5 ವರ್ಷ ಅವಧಿಗೆ ಒಂದು ಜವಾಬ್ದಾರಿಯುತ ಆಡಳಿತ ಮಂಡಳಿ ರಚಿಸುವ ಕುರಿತು ಹಾಗೂ ಬೈಲಾವನ್ನು ರಚಿಸುವ ಕುರಿತು ಹಾಗೂ ದಿನೇ ಬೆಳೆಯುತ್ತಿರುವ ದೇವಸ್ಥಾನದ ಮುಂದಿನ ಪ್ರಗತಿಯ ಕುರಿತು ವಿಚಾರಿಸುವ ಬಗ್ಗೆ ಹೇಳಿದರು. ನಂತರ ಸಭೆಯಲ್ಲಿ ಸೇರಿದರು. ದೇರ್ ಇಸ್ ನೋ ಬೈಲಾ ಅಟ್ ಆಲ್. ಬೈಲಾ ರಚಿಸುವ ಕುರಿತು ಇವರು ಯಾರೋ ಒಂದಿಷ್ಟು ಮಂದಿ ಕೂಡಿದ್ದಾರೆ. And they say that I become secretary, I become chairman.
Both of you have to advise your friends. You are fighting over.
There is absolutely there is no any fighting, my lordship. Kindly this honorable court may summon the Tahsildar who has conducted fair. One submission, my lordship.
One of you or both of you are wrong. When that deity in the temple will not.
One submission. The
We'll extend that order of same order of 9/1/2024 to this time and release this on 17. It is submitted that the Jatra this year is to be held on
12th, 13th and 14th, my lordship.
12th, 13th and
3 days.
14th of 2024. More than Mr. Patil?
But
yes, 12th, 13th, 14th.
12 to 14.
In that view of the matter, the order dated 9/1/2024 passed in respect of the Jatra held on 10/1/24 to and 11/1/24.
It is not on that day, my lordship. That is on subsequent date that Jatra.
ಅವಾಗ ಮಾಡ್ಲಿಲ್ವಾ?
ಇಲ್ಲ. Bharat Hundme, that in that petition also the days of Jatras are mentioned wrong, my lordship.
ಏನಾಯ್ತು?
New petition again Jatra date for the that is not.
Jatra held on 24th to 26th of February 2024.
ಅವಾಗಿನ ಸರ್ ನಾವು
would equally apply to the present Jatra. The respond number 3 shall conduct the Jatra to be held on 12/1/12/2/24, 25 to 14/2/2024. And the amounts collected from the public would be kept in a safe custody with respond number 3, subject to the result of the present writ petition. the said amounts to be deposited in an interest-bearing fixed deposit with a nationalized bank operating in and around the premises of respondent number 4. Needless to say, the said bank account shall not be operated by anybody else apart from respondent number 3.
ಆ ರಿಟ್ ಅಪೀಲ್ ಏನೋ ಆರ್ಡರ್ ಆಗಿತ್ತಲ್ಲ, ಅದು ರಿಟ್ ಅಪೀಲ್ನ ಮಾಡಿಫಿಕೇಶನ್ ಏನಾಗಿತ್ತಲ್ಲ, ಅದು ಕೊಟ್ಟರೆ ಅದು ಇದ್ರಾಗ್ಬೋದು. ಏನಾಗೈತೆ? The said order was
Still there.
There was some modification in.
Tahsildar can choose the person from
No,
the
my
group
lordship.
of the petitioner.
One
as also-
submission, my lordship. This order is modified before DB, my lordship.
That's good, yeah, whatever the order.
In terms of
A copy ಐತೆ
ಎಲ್ಲ ಹೊಡೆದಾಕ್ಬಿಡಿ ಅದನ್ನು. This court on 9/1/2024 had passed certain orders relating to the conduct of Jatra to be held on 10/1/24 and 11/1/24, which came to be modified on 2/2/2024 and subsequently explained in the order, subsequently further elaborated in the order dated 15/2/2024, which came to be challenged in WA number 10029 of 2024 and came to be modified by the order dated 16th February 2024, passed in the said writ appeal. The said orders would be equally applicable to the Jatra to be conducted for this year, now stated to be from 12th February
13th,
25
14th.
to 14th February
14th.
2025. Learned AGA is directed to instruct respondent number 3 accordingly.
And
Just on 17th February.
and kindly direct the Tahsildar to get accounts ready on that date. We will submit all the accounts.
On 20th February, by which date a statement of account to be filed by the respondent number 3.
Please, my lordship, please.
That amount will transfer to the suit to be filed.
before-
We won't give it to anybody.
Pardon?
ಸೂಟ್ ಯಾವ್ದು ಲಿಬರ್ಟಿ ಕೊಡ್ತೀವೋ ಆ ಸೂಟ್ಗೆ ಅಮೌಂಟ್ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿ. That will be subject to result of that suit until both of you fight.
Under 92, under section 92.
And this petition had to go.
And this,
Interim order ಆದ್ಮೇಲೆ ಹಂಗೆ ಇದೆ.
ಅಲ್ಲ ತಾವು ಪಾಠಡ್ ಅಂತ ಮಾಡಿ ಇಲ್ಲ ಇಡ್ಬೇಕು ಸರ್. ಬಿಕಾಸ್ ಅದಕ್ಕಲ್ಲ ಇದಾದ್ರೆ ದಿಸ್ ವಿಲ್ ಗೋ ಬಿಫೋರ್ ಅದರ್ ಬೆಂಚ್. ಹಂಗ ಡೇಟ್ ಅದ್ರ ರೋಸ್ಟರ್ ಇಸ್ because CPC was attached to this came before.
Then we can't pass any orders. It has to go there.
Because it was posted here.
ಡೀಲಿಂಗ್ ಮಾಡಿಲ್ವಲ್ಲ ಟೋಟಲ್
Yes.
ಹಂಗೆ ಓಟಿಗೆ ಬರುತ್ತೆ. ಅದು 5-2 ಜೊತೆನೆ ಬರುತ್ತೆ, 5-2 ಬರುತ್ತೆ, 17-2.
Is it parted? Parted.
Parted ಎಲ್ಲ ಬೇಡ. We'll be disposing them.
But that
Them will get disposed.
in that matter, some other date is given.
Parted ಅಂತ.
Not done. Filed a writ petition not seeking mandamus not directing to the trial court to not accept the commission report and proponing the not date of hearing. Fact of the case is not petitioner is the plaintiff filed a suit for partition separate position.
Preponing the date of hearing from 8/1/25. 8/1/25 ಆಗೋಯ್ತು.
Not the next not 12/3/2025 not again not trial court not adjourn the matter for objection.
ಎಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ.
Yes. Annexure A is not order sheet no.
Commissioner report filed on 24/4/24
20 yes no.
for orders.
3 again not 19/8/2024 no. There is no objection from the not respondent not there is no seeking any adjournment not for objection.
Petitioner is before this court seeking for the following reliefs. Notice to respondents is dispensed with in view of the proposed order to be passed. The grievance of the petitioner is that though the commissioner's report in the FDP proceeding had been filed way back on 24/4/2024, the same is yet to be accepted by the trial court, and final decree drawn up. The commissioner's report having been filed nearly a year ago is still pending before the trial court. As regards a suit,
Partition separate position. No.
suit ಏನು?
OS no. Partition
Suit of the year 2014. It would be required for the trial court to dispose of the FDP proceedings at the earliest. As such, the trial court is directed to pass necessary orders on the commissioner's report within 30 days of the receipt of a copy of this order.
He must be
Appear for the petitioner.
Yes.
Lord, the petitioner, my lord, is seeking mandamus in the nature that, my lord, for the data of the students who have been admitted, I need to upload it on the website. For that, login credentials are required. I'm seeking a mandamus to that effect. The dispute is this, my lord. Pursuant to orders of this honorable court, while Annexure A, page 18.
Yes.
I was permitted to admit students. The relevant portion, my lord, of the said order is at page number 41, internal page 24. Because there were certain inspections pending from the respondents that could not have been complied with, because of which, my lord, the counseling date was fixed. Agreed by which, my lord, I approached this honorable court. Pursuant to certain conditions, my lord, I was permitted to admit certain students.
Yes.
After participating in the counseling. Thereafter, my lord, after participating, students have been admitted in the said institute. That list of students, my lords, will find it at page number 55, Annexure C. This is the data which has been obtained from KEA, that is Karnataka Examinations Authority. Wherein over, my lord, 100 students have been admitted. When this factual circumstance has been taken note of, on Annexure H on 2/12/2024, there was a direction issued by NCISM that the student data have to be uploaded in the portal. Now, my lord, based on the interim order, I have admitted students. These students' data have to be uploaded onto the portal. I am seeking login credentials for uploading that data.
These were admitted. These students were admitted prior to the passing of the order.
No, my lord. Pursuant to the orders of the learned single judge of this honorable court, these students were admitted. I participated in
taking appropriate steps is done and so on. So, Appropriate steps in WP 200939. ಇಲ್ಲ ಇದೆ. What are the directions there?
There were certain conditions. There were certain conditions.
So what happened subsequent to the inspection?
Subsequent to that, my lord, subsequent to inspection has not happened. The order of the learned single judge is challenged by the other side. I am told, my lord, but we have filed caveat, no copy is served. Be that as it may, after this, my lord, I have participated in the counselling. In counselling, my lord, 100 students have been admitted. That is at Annexure
You
C.
challenge this order.
Please, my lord, still pending, my lord. My lord,
Then permit the students. to
my lord, one submission. Lord, the honorable, my lord, single judge has passed an order saying that, my lord, earlier, my lord, this very petitioner had challenged, my lord, the notification, my lord, the cancel denial of permission by the NCISA, my lord. My lord, that is of the year 2023-24. And we had rejected, my lord, because the basic criteria, my lord, is that, my lord, prior to the starting of a new college.
Learned, my lord, not read
One
the
minute,
order of the
my lord, I have
learned
kept
single
quiet,
judge.
my lord, when he was
Before the
arguing.
court, let
My lord, I have kept quiet when he was arguing.
No, he has
My
to
lord,
keep quiet because it is my petition. It is not that he's doing a great favor that he has kept quiet.
Let us hear what he says. Yes.
But he's
My lord, the basic criteria for establishing of a new college is that, my lord, even they do admit that there has to be, my lord, new building earlier to.
Mr. Angdi, you were directed to inspect.
My lord,
and point out the deficiency.
after filing of an application, my lord, even assuming, my lord, accepting for a moment, my lord, there is a judgment of the learned single judge saying that we'll have to conduct a, my lord, inspection. My lord, here, after passing of this judgment, my lord, they have to file an application along with the requisite fees. My lord, they have never submitted an application after the judgment. And, my lord, we never know.
Does the judgment say that they have to submit an application with fees?
My lord, my humble submission is that, my lord, one minute.
Point number 2.
Point
number 2.
1 minute. I will convince your lordship. My lord.
Yes.
My lord, the earlier rejection order, my lord. Earlier rejection order is at page number 16, my lord. This was challenged before the earlier, my lord, writ petition, whatever that they are showing before this court. 1/8/2024. My lord, last paragraph, my lord. Last paragraph, seventh paragraph of the page number 24, my lord. Further, the matter was meeting so and so held on so and so. The board discussed the matter and decided not to consider the representation of the trust for considering their application for establishing a new Ayurvedic college academic year 24-25 and to return the document submitted along with the representation. My lord, here, my lord, when this court sets aside this particular order, my lord, after passing of a judgment, my lord, it is a duty of the college to submit a new application along with the new fees, my lord. We have returned the DD also.
That's 16/4/24. This is now 12th August 24.
They have never submitted an application, my
12th
lord.
August 24 does not ask them to submit any application.
No, my lord.
It only asks you to issue a notice, prior notice fixing the date for carrying out the inspection.
My lord,
You don't do that.
My lord,
Is there a stay of this order?
No, my lord, no stay.
Then you follow this order.
My lord, kindly, my lord, these people have never come up before the NCISA, my lord, after passing of the judgment, my lord.
You have to implement that order. If it gets set aside.
My lord, kindly, my lord, even the order passed by this learned single judge, my lord.
Just pass this order, we'll have to implement.
My lord, kindly the observations made in that judgment, my lord, kindly, my lord.
Not the observation. What is the operative portion? This is what you have to do.
My lord, ultimately, my lord, kindly look at the observation, my lord, the final order.
Sorry, Mr. Angadi, you can't do that.
My lord, repeatedly, my lord, this is the thrice time that they are before this court without there being no permission from the NCISA, my lord.
The inspection report ಕೊಡ್ರಿ ಏನ್ ತಪ್ಪಿದೆ ಅಂತ ನೀವು ಮಾಡ್ತಾ ಇಲ್ಲ.
My lord, repeatedly we have inspected, my lord. After this judgment, my lord, my humble submission is that when we have, my lord, reverted back all the records to the other side, my lord, after this judgment.
Have you inspected after 12th August 24?
No, my lord, after this judgment, my lord, we have not conducted any inspection. Lord, but here, my lord.
You show us an inspection report which has deficiencies after this. We will not allow them. We will come down very hard on them. But if there is an order passed by a coordinate bench, you have to follow it.
My lord, page number 32.
On your own ground, say I am not going to follow High Court bench.
No, my lord, that is not my lord. Here, page number 32, my lord.
That is what it is.
My lord, page number 32, my lord. May I?
We won't look at those things.
My lord, page number 32. My lord, last submission, my lord, page number 32 is the order. Page number 32, my lord, of the petition, my lord, of the petition.
Now we'll have to make observations. Clearly.
My lord, page number 32, my lord, my lord, they were relied upon before this court, saying that, my lord, there was a judgment of the honorable, my lord, the judgment of this court, saying that the counseling was allowed in that case. My lord, para 8. The first condition, my lord, the petitioner shall undertake to comply any or all deficiencies that may be pointed out by the respondent to. It would take all necessary steps to obtain permission. My lord, after this judgment, my lord, they have never appeared before the NCASM and sought for saying that, yes, this is a judgment. My lord, kindly, my lord, appreciate this, my lord, because, please, my lord.
That is to rectify the defects after you pointed out. You are not even carrying out the inspection. So there seems to be something fishy in this.
My lord, this is not, my lord, we have already carried out an inspection earlier to this, my lord, rejected their application. Repeatedly, they are on the same application, my lord.
It has been repeatedly, it is the same thing, and there's a direction issued by the court which you are not following.
We have followed, my lord. Earlier, we have all followed, my
We will
lord.
observe that.
My lord, kindly, my lord, look at the conduct.
Only your conduct is worse.
No, my lord, that is, my lord, I am bringing out all the notices before this, my lord, court, my lord. That is my submission.
5, 6, ella ಆಗಿದೆಯಾ? Petitioner is before
My lord, at
this
least,
court.
my lord, 1 week time may be given, my lord. I will inform the officers, my lord, because they have a time, my lord. There is no hurry, my lord.
Before this court seeking for the following reliefs. This court earlier, in the list between the petitioner and the respondent, while its order dated 12th August 24, in WP number 104631 of 2024, had passed the following order. Page 41, Roman 1 to Roman 5, 41 and 42. The contention of the grievance of the petitioner now is that despite the directions issued in Roman 5 of the aforesaid order, and the students have been admitted, they are now not being permitted. They cannot take up examination.
It's not examination, my lord. My lord, this is the first year admission, my lord, they have taken, not examination, my lord. That is why, my lord, one
Admission process cannot be completed in view of the letter dated 2/12/2024 issued by respondent number 1. The submission of Shri Shiv Prasad Shantangowda, learned counsel appearing for the petitioner, is that the respondents have not carried out the inspection of the petitioner's institution and brought to light any deficiencies in pursuance of the order at Roman 2 of the order dated 12th August 2024. And as such, the petitioners are unable to comply with any such deficiencies. The students have been admitted, their interest as suffering. Shri Avinash Angdi, learned counsel for respondent number 1 to 3, submit that post the order dated 12th August 2024, it was required of the petitioner to submit an application
along with fees, my lord,
and make payment of fees.
Please, as per the rules, my lord.
And it is only thereafter that inspection would be carried out by respondent number 1 and 2.
Because as we had returned all the records to them.
To whom have we returned?
The very same petitioner, my lord. Before the passing of this order, my lord.
Now, have you called upon them to make payment of the application fees?
My lord, they only...
Have you called upon them?
No, my lord, we did not say.
This court, by order dated 12th August 2024, had directed respondent number 3 and 4 to inform the petitioner in advance and cause inspection of the petitioner institution for verification of the deficiencies. It was therefore required of respondent number 1 and 2, respondent number 3 and 4 to cause the said inspection. If at all there was a requirement for submitting any further application or making payment of any fees, it was required of respondent number 3 and 4 to inform the petitioner about the same, which also the respondent number 3 and 4 have not done. Therefore, in my considered opinion, that the respondent number 3 and 4 have not complied with the order of the coordinate bench dated 12th August 2024 in WP number 104631 of 2024, and without compliance thereof cannot now contend that an application is not being filed by the petitioner to carry out the inspection. The said contention on part of the respondents is completely malified. Even if there are any deficiencies on part of the petitioner college, the interest of the students cannot be put at jeopardy in the manner in which the respondent number 1 and 2, in the respondents 1 to 4, have sought to treat this present list as an adversarial litigation. If at all, respondent number 1 to 4 are authorities who are required to act in accordance with law. And if there were any application to be submitted by the petitioner, they could have always called upon the petitioner to submit the said application. Instead of doing so, from 12th August 2024 till now, the respondents have not taken any action. In that view of the matter, I pass the following order. Writ petitions allowed, a mandamus is issued, directing respondent number 1, 2, 3 to issue login credentials to the petition number 2 college for uploading the data of the admitted students to petition number 2 college for the academic year 2024-2025. As also, now we can't say comply with this.
Lord, because
it is left to the
Lord,
number 1 to 4
Allah,
to comply with the order dated 12th of 24.
My Lord, last observation passed by this court, my Lord. Last para of the judgment of the earlier, my Lord, court.
ನೀವು ಇನ್ಸ್ಪೆಕ್ಷನ್ ಮಾಡಿದ್ಮೇಲಪ್ಪ ಅದು ಬರೋದು.
ಅಲ್ಲ my Lord, I do, my Lord, I accept, my Lord, but with permission, my Lord, with permission, my Lord. I am not going beyond this.
Categorically said, you carry out the inspection, point out the deficiencies, then they will have to comply with the deficiencies. You are.
But that is 1 week time may be given, my Lord.
Third round,
Lord, one, my Lord, third time that is before this court, my Lord, on the very same issue, my Lord.
Carry out the inspection.
Lord, 1 week time may be given, my Lord. I will inform the authorities to do that. Lord, because there is no, my Lord, there is no detrimental to the interest of the, my Lord, the students, my Lord.
To the respondents to comply with the
Lord,
order dated 12th August 24.
Lord, we will.
In WP number 104631 of 20.
Lord, at least, my Lord, it may be kept pending, my Lord, because Lord, their interest will not be, my Lord, taken away, my Lord.
The login credentials for not only for students.
Yes.
Login credentials not only for students, for also uploading the data for faculty also. How many teachers I have?
And faculty.
Yes.
One submission, my Lord. Otherly, there is no malified intention, my Lord. That is, because, my Lord, repeatedly there before this court, my Lord. That is why, my Lord, I made submission, my Lord. Otherwise, I have no.
As I said on the previous occasion, if it was given to Mr. Angadi, he would have granted permission.
If you go back beyond the order, it is dishonest. Yes. As simple as that. Yes. Whichever bench of this court passes an order, it has to be implemented. Yes. We will not hear any argument contrary to an order passed by this court.
Please, I oblige. Oblige.
You have to writ petition appeal hodra, stay aita, okay.
Oblige.
You have to comply.
I oblige.
You can't say before that this.
Please,
First time, second time, illa. Third time, admel ide order.
Your Lordship's class.
Great, great.
43 other 2010 matter. ನೀವು ಕಣ್ಣು ನೋಡಿದ್ಬಿಟ್ರೆ 40 ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಾ?
With your Lordship's kind permission, serial number 4, my lords, I am respondent number 7. It is passed over to carry out an amendment for the petitioner. He carried it out, my lords. May I see tomorrow, my lords? I have informed him.
Counsel for the petitioner has carried out amendment. Relist on tomorrow. Relist on 31st.
Lord, honorable submission. My lords were pleased to dispose of a petition yesterday, election matter. Tomorrow is the election. The deputy commissioner and the election officer are demanding for a certified copy of the final order. If I may request for hand delivery.
What is the name of the deputy commissioner?
Name I don't know, my lord.
Get the name of the deputy. We'll ask him to be present tomorrow. He is asking for certified copy. Inform Madi. These kind of things will not be entertained. Madle, we have made observation against both of them. If they are going to do like this, then that means in a type they have to inform. Inform illa andre illa.
Serial number 46, my lord. Serial number 46, from the petitioner. We had engaged senior counsel for this matter.
Have you informed the other side?
I'll inform.
ಎಷ್ಟು 36 ಮಂಡ ಆಯ್ತಲ್ಲ. ಅಲ್ಲ ಈಗ ಎಷ್ಟು ಮಟ್ಟ ಆಯ್ತು ಈಗ 36 ಗೊತ್ತು ಈಗ ತೋತ್ರ ಮತ್ತ ಪಾಸ್ ಆನಂದ ಆಮ್ಯಾಗ ಇಲ್ಲೇ ಕೂಡ್ತೀವಿ ಮತ್ತೆ ಮಾಡೋದು.
ತೋರಿಸಿಲ್ಲ.
Dharwad bench matter. 37, Mallikarjun Swamy.
The petitioner millets who had purchased 3 items of the agricultural lands had made an application seeking conversion from agriculture to non-agriculture without assigning any, though the land comes within the corporation limits and well within the master plan, which is reserved for residential. The application is rejected without assigning any reasons. You will also kindly see page number 66.
Who is for respond?
Government Deputy Commissioner. In fact, it comes within the municipal limits.
And AGA accepts notice for respond number 1 and 2. He seeks for and is granted 10 days time to obtain
Lordship said,
and make his submission.
Last time it was listed.
ಆಗಿದೆಯಾ? Notice
ಆಗಿದೆ.
ಆಗಿದೆಯಾ?
To seek instructions.
Annexure H, your lordship, it was rejected, your lordship, Annexure H.
Already ಆಗಿ ಸೇಮ್ ಆರ್ಡರ್ ಆಗಿತ್ತು.
ಆಗಿದೆ.
Annexure H and H1, your lordship, already rejected, your lordship, their application.
ಏನ್ ರೀಸನ್ ಏನು?
In reason, in fact, convert the, though it is not required, permission is not required to divert the land.
Your reconversion application is rejected. Your reconversion
It
ಏನಂತ?
is not reconversion, it is conversion.
Reconversion ಹೊಸ ಪದ ಏನಾದ್ರು ಇದೆಯಾ ಆಕ್ಟ್ ಅಲ್ಲಿ? What is the reason?
Just endorsement issued, your lordship.
Endorsement ಅಲ್ಲಿ we have already directed another matter where the reasons have to be uploaded. Reasons upload ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರಿಗೆ ಏನ್ ಗೊತ್ತಾಗ್ಬೇಕು? ನಾವು ಇನ್ಮೇಲೆ ಬರೀ petition allowed, petition dismissed ಅಂತ ಆಗ್ತದೆ.
Next week, your lordship.
Produce this one. So it will issue further direction on this.
In fact, if I can persuade your
And
lordship.
AGA is directed to secure the file pertaining to application number 624059 as indicated and 624053 as indicated in annexure H and H1 released on 6th February.
It comes within the municipal limits. Please.
Let us see what
Yes.
you are saying for that reason, but we are not seeing
No, I
that
produced
reason.
a master plan also to show the survey number coming.
Or
Yes,
rejection
very
ಏನು
well.
reason ಇಲ್ಲ, ನೀವು ಬೇರೆ ಏನೋ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ, ಬಟ್ ಅಲ್ಲಿ ಏನು ಇಲ್ಲ.
ಆಯ್ತು.
38, Santosh Malligwad.
Appear for petitioner, my lord. Petitioner is challenging the compromise decree, my lord. Petitioner is a co-partner, my lord. He has been left out. He is not made as a party. Page 3 is the order sheet, my lord. It's very
Not
suspicious.
been made a party.
He's not made a party, my lord. In fact, I have to make an application before the very court, my lord. It is not by the local adalat, it is by this very civil court. Order sheet has page 3, annexure B. Compromise is recorded by.
Why are you filing this is here? You filed an application.
No, my lord, I have not filed an application. Now I have to file. A writ petition is.
How can you file a writ petition directly?
My remedy is after the recent judgment. My remedy is with that observation.
Notice to respondents is dispensed with in view of the order proposed to be passed. Petitioner is before this court seeking for the following relief. The grievance of the petitioner is that a compromise has been entered into in OS number
739 of 23.
39 of 2023 on the file of the senior civil judge Gokak without making the petitioner a party. And in that background that the aforesaid reliefs are sought for. The petitioner has an alternative efficacious remedy and the said relief cannot be sought for in the present petition. The judgment.
Order 23, rule 3. Judgment I will produce.
Reserving liberty to the petitioner to
application order 20.
Agitate his rights in terms of the decision in so and so.
Please.
The petition stands disposed.
Please.
Highly detail agide, so you can.
Please. Please. Highly obliged.
39, SG Solar Gupta.
Please, my lord.
Yes.
I'm appearing on behalf of petitioner.
Yes.
Petitioner challenged the garnishing order passed by the respondent under section 45G of the ES Act 1948. So by passing the garnish order, the bank, all banks of the petitioner is attached. So it has become very difficult to for a day-to-day transaction.
What is the amount due?
Around 8 lakh, including interest.
ಎಷ್ಟಿದೆ?
8,48,171.
ಅಕೌಂಟ್ ಅಲ್ಲಿ ಎಷ್ಟು ದುಡ್ಡಿದೆ?
ಅದ್ರೊಳಗೆ ಇದ್ದಿದ್ದೆಲ್ಲ ತಗೊಂಡೋಗಿದ್ದಾರೆ. ಗೊತ್ತು ಕೇಳಿದೆ.
8,41,000 ಏನ್ ಸೆಕ್ಯೂರಿಟಿ ಕೊಡ್ತೀರಾ?
Either out of this amount, only liability is around 1 lakh, some interest, sir. ಯಾಕಂದ್ರೆ ಇದರೊಳಗೆ ಕವರೇಜ್ ಎಂಪ್ಲಾಯ್, ನಾನ್ ಕವರೇಜ್ ಎಂಪ್ಲಾಯ್ ಅಂತ ಎಲ್ಲ ಇದಾವೆ, ಎಲ್ಲ ಸೇರಿ ಇವರು ಅಡೋಕ್ ಬೇಸಿಸ್ ಮೇಲೆ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ.
ಇವಾಗ the order has attained finality.
ಹಾ ಸರ್.
After that, garnishee order has been passed.
ಹಾ ಸರ್.
Now the amount indicated earlier was 5,38,000.
ಹಾ ಸರ್.
ಅದಾದ್ಮೇಲೆ ಇಂಟ್ರೆಸ್ಟ್ ಎಲ್ಲ ಸೇರಿ ಇವಾಗ
8,48,000.
ಹಾ 8,08,000. ಆಮೇಲೆ ನೋಟಿಸ್ ಕೊಡೋ 8,48,171 ಆಗಿತ್ತು.
Please, my lord.
That is as on 23/2/24.
Please, ma'am.
All these are attained finality. ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ.
ಮಾಡಿದ್ದೀವಿ ಸರ್, 8,40,000 ಎರಡು ಸೇರಿ ಮಾಡಿದೆ. ಅಪ್ ಟು ಇದು ಆರ್ಡರ್ದೊಳಗೆ ಏನಿದೆ ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದೆ.
ಇವಾಗ ಗಾರ್ನಿಶಿ ಆರ್ಡರ್ ಮಾತ್ರ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ?
ಹೌದು ಸರ್.
ಪೇರೆಂಟ್ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ.
ಈ ಗಾರ್ನಿಶಿ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಅದನ್ನು ಪಾರ್ಟ್ ಆಫ್ ದಿ ಆರ್ಡರ್.
Garnishee order is only a consequence. Main order ಇರೋವರೆಗೂ is only implementation. Decree ಇರೋವರೆಗೂ ಇದು execution. Decree set aside ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ execution ಮುಂದೆ ಹೋಗುತ್ತಲ್ಲ, ಹಂಗೆ ಇದು.
ಅದಕ್ಕೆ petitioner humble prayer is so one more opportunity provide ಮಾಡಿದ್ರೆ so will comply and
ನೀವೇನಾದ್ರು ಅಮೌಂಟ್ ಕೊಡಂಗಿದ್ರೆ will stay that. Otherwise security ಕೊಡಬೇಕು.
ಕೊಡ್ತೀನಿ ಸರ್.
ಎಷ್ಟು ಕೊಡ್ತೀರಾ security?
20% of that amount.
ನಿಮ್ಮ ಅಕೌಂಟ್ ಅಲ್ಲಿ ಎಷ್ಟು ದುಡ್ಡು ಇತ್ತು ಅಂತ ತಿಳ್ಕೊಂಡು ಹೇಳಿ.
Please.
ESI ಯಾರು ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್?
ನೋಟಿಸ್ ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ ಪೆನಲ್ ಮೆಂಬರ್ಗೆ. ಸೀಲ್ವಂತ್.
Shri Vinay Kojogi is directed to accept notice for respondent 1 and 2. Counsel for the petitioner seeks for and is granted a week's time to obtain instruction, make a submission as to what is the amounts which are available in the bank accounts of the petitioner. Released on 6th.
ಇಂಟಿದೆಮೋ ಪ್ರಿಯರ್
ಎತ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ ಅಂತೀರ.
Please.
Let it be there. You tell us how much. If it is more than 8,48,000, we'll restrict the attachment to 8,48,000. ಇಲ್ಲಾಂದ್ರೆ ಸೆಕ್ಯೂರಿಟಿ ಕೊಡ್ಬೇಕು ನೀವು.
ಅದು ಸೆಕ್ಯೂರಿಟಿ ಅಮೌಂಟ್ ಒಂದು 20% ಆಫ್ ದಟ್ ಅಮೌಂಟ್ ಕೊಡ್ತೀನಿ ಸರ್.
20% is not security, the entire amount. It's a garnishee order. ಬ್ಯಾಂಕ್ ಹಂಗೆ 20% ಕೊಡಕ್ಕಾಗಲ್ಲ, ಫುಲ್ ಅಮೌಂಟ್ ಸೆಕ್ಯೂರಿಟಿ ಕೊಡ್ಬೇಕು.
ಫುಲ್ ಅಮೌಂಟ್ ಅಂದ್ರೆ ಅಷ್ಟು ಎಜುಕೇಶನಲ್ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಸರ್, ಸೊ ಇಟ್ಸ್ ಬಿಕಮ್ ವೆರಿ ಪ್ರಾಬ್ಲಮ್.
ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಅಂದ್ರೆ ದುಡ್ಡು ಇರುತ್ತೆ ನೋಡಿ ಹೇಳಿ.
40.
Please sir. Thank you.
Sir Hegde.
My lord, the petitioner's clubbing application came to rejected, my lord.
Clubbing
application. Not the first suit, which is filed by the present petitioner in OS number 196 of 2020 with respect to the residential shop, my lord.
196 page number?
Page number, my lord, 30. Plain at page number 30. Next study.
I appear for the respondent in this matter, my lord.
And study, my lord.
Yes. Versus Shashikala, Nutana, Chetan, Murugesh, Neha, Mallika. They are all not parties here.
My lord, another suit which is filed by this.
Shashikala is not a party to this petition.
My lord, I have made the LRs of the these plaintiffs in the OS number 142 of 2022, my lord. They are the legal heirs.
You have to make parties in both the suits party to this petition.
ಹೌದು.
ನಿಮ್ದು 196 ಅಲ್ಲಿ different number 1 is Shashikala.
ಹೌದು.
Shashikala is not a party here.
In the petition, my lord. Because I have filed this application in the OS number 142 of 2022. In that suit, my lord, she is not a party. In that suit.
Nutana is not a party.
Nutana is party, my lord.
Elli?
Nutana is a party.
Nutan, idu Nutana. Okay.
Same is.
Chetan. Murugesh is dead, written by Neha, Mallika. Who is Shashikala?
Shashikala is the wife of Kalyanappa, my lord. And these plaintiffs are the children of Kalyanappa. I have made all the legal heirs of Kalyanappa as the party to my proceeding, my lord. They are the plaintiffs in the later suit, my lord. The children themselves have filed this.
196 was filed for?
Filed for injunction, my lord. Permanent injunction.
And what is the next suit?
Next suit is for the position, my lord.
OS number?
OS number 142 of 2022, annexure A.
Page, print.
Page number 9.
They have filed it.
Yeah, my lord. It's the counter suit.
Eviction suit, my lord.
Possession suit, my lord. Eviction suit. With respect to the same property.
Same scheduled property.
My lord,
Yes.
I
Your
appear
appeal.
for, I appear for the respondent in this matter, my lord.
Yes.
My lord, it's a suit and a counter suit, my lord, with regard to one is for the, they have said, sought for injunction from evicting them from the property. Second
More
suit
the
is-
reason that it has to be clubbed, Mr. Anish.
Please, my lord. The property which is in question is 100 years old property, my lord. When we wanted to demolish the property, they are filing this suit and seeking for injunction. And both the suits, they are not cooperating to move forward with the suit, my lord.
That will direct. But
Short,
142 of 22 is only 2-year-old suit.
please, my lord.
In
It's an eviction suit.
100-year-old property, the suit is 2 years old.
They have filed the eviction suit, my lord, where they have injunction suit where they are not coming forward to lead evidence, my lord. Direction may be given for a 6 months time to be disposed of.
No, it's a 2-year-old. You are very
suit is
fresh in
20.
the line. Petitioner is before this court seeking for the following reliefs. The petitioner had filed a suit in OS number 196 of 2020, seeking for injunction restraining the defendants therein from interfering with the peaceful possession of the from dispossessing the petitioner. In the said suit, respondent number 1 was defendant number 2, respondent number 2 was defendant number 3, respondent number 3 and 4 were defendant number 4A and 4B. Respondent 1, 2, 3 and 4 had also filed another suit in OS number 142 of 2022 against the petitioner, seeking for possession of the suit scheduled property therein. Pertinent to observe that the suit scheduled property in both the suits are one and the same, and the parties to both the suits are one and the same, except one, Ms. Shashikala,
Shashikala is no more, my lord.
being a party in OS number 96,
196 of 2020,
and not being a party in OS number 142 of 2022. However, the same would not make any difference since Mr. Shashikala has also expired, and her legal representatives are the plaintiffs in OS number 142 of 2022 and the surviving defendants in OS number 196. In OS number 142, which is a subsequent suit, the petitioner, who is the defendant therein, had filed an application seeking for clubbing of both the matters on the ground that the relief sought for that the suit properties in both the suits are one and the same. The said application, having been objected to by the plaintiffs in OS number 142, came to be dismissed by order dated 11/9/2024. It is challenging the same the petitioner is before this court. That counsel for the petitioner would submit that the parties to both the suits being one and the same, the properties forming the schedule in both the properties being one and the same, the relief sought for by the petitioner being for an injunction restraining disposition as regards the said property, relief sought for by respondent being one for possession of the said property, the trial court ought to have allowed the clubbing application so as to avoid duplication of trial. What is your submission, Mr. Anish?
My lord, the document which they are relying as a part of the evidence, my lord, that is a forged document, rent agreement.
Counsel for the respondent would however submit that the documents which have been relied upon by the petitioner are forged documents. The cause of action in both the suits being different, there was no requirement to club the suits, and as such the trial court has rightly rejected the application. Heard so and so peruse papers. the parties to both the suit being one and the same is not in dispute, so also the schedule, property schedule is not in dispute. Yeah, being the same is not in dispute. Whether the claim of the petitioner is based on fabricated and forged documents or otherwise, the fact remains that the same also relates to the very same scheduled property between the same parties. The relief sought for in one suit being for permanent injunction against disposition, and in the other suit, the relief sought for being one of possession. The issue involved is as regards possession and who would be entitled to. Thus, even the aspect of whether a document is forged or not would have to be considered while considering the said relief. In that view of the matter, I am of the considered opinion that the trial court has misapplied itself by referring to the cause of action to be different in both the matters and that there will be no overlapping evidence. In fact, the issues raised and subject matter being such as is, there being a suit and a counter suit, there would be overlapping evidence, which if permitted to be taken up separately would be a waste of judicial time and also may cause delay in disposal of the matter. In that view of the matter, I pass the following order. Writ petition is allowed, a certiorari is issued. A writ petition is allowed. You certiorari ಆಗ್ತೀರಾ ನಮಗೂ ಅದೇ ಮಿಸ್ಟೇಕ್ ಮಾಡಿಸ್ತೀರಾ. Writ petition allowed. The order dated 11/9/2024 passed by the civil judge in JMC Badgi in OS number 141 of 2022 on IA number 3 is set aside. Consequently, IA number 3 filed under section 151 in the aforesaid suit is allowed. The suits in OS number 142 of 2022 and 196 of 2020 are clubbed. The trial court is directed to proceed with recordal of evidence in a common manner in both the suits.
Direction may be made, my lord, with regard to a timeline to be specified, my lord, with regard to disposal of the suit.
Mr. Ranish, they won't fix any.
In the suit which is filed by on 2020, my lord, the plaintiff evidence is still on.
Yes.
They have not even not coming forward to lead the evidence.
The trial court knows how to conduct itself. Sri Prashant Matpati, who has appeared for respond number 2, accepts notice for respond number 1, 3 and 4.
Much obliged.
230, yeah? 230.
230 matter, 82, Prashant F. Gowda.
My lord, 82 to 80.8. In all these writ petitions, my lord, I have challenged the legality of the order of reference made by the appropriate government, my lord. But your lordship may kindly permit me to address common arguments.
Yes.
In respect of 7 matters, my lord, except 82.2 and 82.4, the facts are different in those cases, my lord. The remain 82.2 and 82.4, they are terminated cases. The remaining 7 cases are resignation cases where the resignation had been accepted and set, their terminal dues were also paid, my lord. My lord,
The two are different. Who is appearing for the respondent?
My lord,
Let's I appear for respond number 2 in the first matter, my lords.
Agde is
Abhishek, you are appearing.
for first matter.
Ravi Agde,
Is there, my lord?
Vinay Kumar Bhatt,
Yes, ma'am. My lord,
ಎಲ್ಲ ಇದ್ದೀರಾ?
in all the remaining cases, Mr. Agde is
ಯಾರು ಇದ್ದಾರಾ ಅಂತ ನೋಡ್ಬೇಕು.
My lord, the common question that would arise for consideration by this honorable court are whether the appropriate government is justified, whether the appropriate government is justified in referring the matter for adjudication without forming prima facie opinion as to whether the industrial dispute exists or is apprehended. Number 2, my lord, whether the appropriate government is justified in referring the matter for adjudication without forming a prima facie opinion as to the person concerned is a workman within the meaning of Section 2S of ID Act. Number 3, whether the appropriate government is justified in referring the cases of persons who are holding the managerial cadre position for adjudication. Then 4, whether the appropriate government is justified in referring the matter for adjudication in respect of the persons who have tendered resignation and settled all their benefits in accordance with law. 5, whether the appropriate government is justified in referring the matter after dual relationship of employer and employee came to an end by virtue of voluntary resignation. Last, whether it is permissible to invoke statutory provisions of the ID Act when the dual relationship of employer and employee comes to an end by virtue of resignation. My lord,
5 and 6 are basically the same.
yes.
Yes.
Now, my lord, the brief background of the case, my lord, facts are identical in respect of 7 matters. My lord, all the second respondents, they were holding managerial posts. I will, a chart is also there. I will furnish, my lord. Within 2 minutes, I will narrate the back. My lord, all the second respondents were holding the managerial post, my lord. My lord, between July 2020 and September 2020, they had tendered resignation, my lord. My lord, I had accepted their resignations between September 2020 and October 2020, my lord. My lord, immediately thereafter, they have taken gratuity by furnishing application as stipulated under the statute. And they have also settled their provident fund amount, my lord, after submitting the applications as required under the statute.
So gratuity,
Yes.
PF,
Settled.
settled.
Immediately after, within 1 month after accepting the resignation,
And they have
all
received the
their
amounts.
all their benefits, including statutory benefits like PF, gratuity, it has been settled. That is not in dispute at all. Documents are there. They are not. My lord, after about 1 year of settling the benefits, my lord, there is the dispute. They raised the dispute before the concerned conciliation authorities, saying that they have been forced to tender resignation. Well, I took up the contention before the conciliation officer. See, they are all holding managerial posts. Their salary was between 1 lakh, between 1 lakh and 2 lakh per month. They are not workmen under ID Act. That was the first limb of argument. Number 2, my lord, I have also said they have voluntarily tendered the resignation. I have settled all their benefits. After nearly 1 year, they had approached. They have approached for saying that they have been forced to tender resignation. My lord. The appropriate government, without application of mind, my lord, in the first in the preamble, my lord, preamble, therefore. I will take your lordship to second disposition, my lord. Your lordship as a recorded maintained record sheet in this case 101114 of 2022. Annex T. Second. Annex T. Page 56 is the order of reference. Annex T, page 56 is the order of reference which is impugned in this petition. Your lordship may kindly see.
Yes.
Your lordship may kindly see in the preamble. Preamble, the appropriate government arrives at a prima facie satisfaction that the dispute exists in the preamble.
Yes. Next,
Coming to the points, number 1, it is contrary to the preamble. Whether so and so is a workman under ID Act, whether so and so is a workman under ID Act, they have left to the labor court for decision. Then, number 2, if that is so, whether the management is justified in forcing them to tender resignation. On the face of it, my lord, first preamble shows that prima facie there exists a dispute. To form the opinion as to whether the dispute is in existence or is apprehended, 2 preconditions are necessary. Number 1, there must be an industry. The prima facie, the appropriate government has to form, it is an industry. Number 2, prima facie, the government has to form is a workman under idea act. Though they are discharging administrative duties, my lord, prima facie opinion is very much required. That prima facie opinion, according to preamble, dispute exists. Here,
Even as regards that.
Yes,
relationship.
contradictory.
See, if there's a dispute as regard relationship, it cannot be referred on the submission.
So, on the face of it, my lord, now I have prepared the brief chart, my lord. I think brief chart, because instead of referring all the files, my lord.
Chart we have the copy.
Yes. ಅಲ್ಲ ಇವತ್ತು ಇನ್ನೊಂದು ಕೊಟ್ಟಿದ್ದಾರೆ ಇವತ್ತು ಕೊಡಿ ಸರ್
ಇನ್ನೊಂದು ಈ ಚಾರ್ಟ್ಗೆ is it different from this chart?
ಅದಲ್ಲದೆ ಇನ್ನೊಂದು
chart.
ಇವತ್ತು ಕೊಡ್ತಾ ಇದ್ವಿ ಅದು ಇದು ಫಸ್ಟ್ ತಗೋ
ಇದು 4 ಪೇಜ್ ಚಾರ್ಟ್ ಇದೆ ಒಂದು.
ಅದು ಅದೇ ಐ ವಿಲ್ ರೆಫರ್ ಟು ದಟ್ ಆಲ್ಸೋ.
ಇದು ಅದೇ.
ಎಸ್ ಇದು ಡಿಫರೆಂಟ್. All the 9 the case list ಆಗಿರೋದು 82 serial number 82. My lord, he tendered resignation. He was the manager operation service is designation, and he tendered resignation on 6/8/2020. I did not accept resignation immediately. I accepted resignation 30/9/2020. My lord, I have settled this gratuity on 21/9/2020. My lord, then date of payment of PF 28/12/2020. Order of reference 5/6/2023. After nearly 3 years of settling all the benefits. Then second matter, my lord, 82.1. My lord, the second respondent was assistant manager. He tendered resignation on 28/7/2020. I have accepted on 27/10/2020. And I have paid gratuity on the same day. I have settled this provident fund on 15/11/2020, and order of reference 7/1/2022. And in respect of 82.5, my lord, he was the deputy manager operation, and he tendered resignation on 22/9/2020. I have accepted on 30/9/2020. His gratuity was settled on 26/10/2020, and his provident fund was settled on 17/11/2020, and date of reference 7/1/2020.
Right.
Yes, this is the factual scenario of the case. Then, my lord, the other chart, which 5 pages ಇದೆ ನೋಡಿ.
Yes.
ಅದರಲ್ಲಿ second column, third column, date of separation I have already indicated, and his gross salary at the time of resignation 2,01,897 gross salary, my lord, and details of service benefits. Gratuity to the extent of 6,91,449. It was paid on 21/9/2020. Then PF accumulation to the tune of 19 lakhs 47,378 was paid on 28/12/2020. Then, my lord, the order of reference is on 5/6/2023, and a declaration made by them in composite remarks declared in the composite forum that he has left the organization. They have obtained the clearance certificate also. That is with regard to first case. With regard to second case, my lord, and as I have already said, he was the assistant manager, and his gratuity was settled on 27/10/2020. PF accumulation was settled on 15/11/2020, my lord. And this is the order of reference. Now coming to the third case, my lord, he was a deputy manager, and his gratuity was settled on 26/10/2020.
These are all only the.
Yes. All these benefits were settled, my lord. Now, my lord, I will take only one writ petition for your lordship's reference. Second writ petition, that is 103114 of 2022.
Yes.
Your lordship may kindly come to Your lordship may kindly come to ink page 28, annexed D. This is the resignation letter given by the second respondent on 28/7/2020. This is the resignation letter. He gave resignation letter on his own. Resignation letter was dated 25/7/2020. Next, my lord, ink page 29. His resignation was accepted on 30/9/2020. I have intimated earlier itself. While the letter dated 31/7/2020, I have informed that his resignation letter would come into effect from 30/9/2020.
Yes.
Then, my lord, page 30, last column, that is his gross salary. Gross salary which he was drawing, annexed F last 1,15,533, last column.
Monthly CTC.
Yes, yes, gross salary.
Yes.
Kindly come to Annex G, page 32. This is the claim, composite claim of for the non-other, that's the Provident Fund claim. Kindly come to item 8, my lord. He declared that he has left the organization on 4/9/2020. Item 8. 4/8/2020. Then, my lord, your lordship may kindly come to page 33, last column. The member declares that he has not been employed for 2 months, certified that particulars are true to the best of my knowledge. In case the amount is used for any other purpose other than the stated so and so, I am liable to return the entire amount with the penal interest. He says that he declares in the forum prescribed under statute, saying that all the information furnished is correct.
Yes.
Then, my lord, I take your lordship to ink page 34. This is also declaration with regard to claiming PF pension, last column. In case my declaration is found to be false, I undertake to return the pension in full with interest as declared by EPF organization, and I am liable for any action that may be initiated by EPFO in this regard.
Yes.
Your lordship may kindly come to ink page 36. This is the claim for gratuity under Payment of Gratuity Act 1972. Column 8, my lord. Date and cause of termination of service. Resigned. Column 8. Resigned. And he also declared that all the information furnished by him is correct. Page 37, my lord. Page 30. Kindly come to 38, page 38. This is the amount paid towards gratuity. gratuity. Your Lordship may kindly come to page 43. Page 43, 19 lakhs 2,524 is the amount paid towards Provident Fund.
Yes.
And Annexure Q, page 47. This is the reply we have submitted to the Deputy Labor Commissioner. I have indicated designation of all the people who raised the dispute. My specific contention was that they were holding a managerial post. They are not workmen under ID Act, my lord. And I have also said that they have resigned and all their benefits have been settled.
Yes.
Kindly come to Annexure R, page 49. Page 14. Again, I had sent detailed reply to the Deputy Labor Commissioner on 26/6/2021. Para 3, my lord. The nature of duties and powers conferred on so and so in nature of a manager or supervisor, and he cannot be considered as workman, and he does not come within the ambit of industrial dispute. Without prejudice to our above contention, additionally, it is submitted that so and so on tendering resignation was relieved from services on the company and he has taken the full and final settlement from the company and settled the gratuity and PF. Next, Annexure, yes, my lord. Page 51. This is the factual report sent by the conciliation officer to the government. My lord, in para 2, the allegation was last 3 lines. Allegation was the resignation was accepted, was a forced one. Then in last para, my lord, I have contended that they tendered resignation, all their benefits have been settled. This is the factual report sent to the appropriate government.
Yes.
Well, all entire material was there before the government. The material was there without considering anything, my lord. The order of reference made by the government itself is defective. My lord, there I am not saying that they have to adjudicate the matter. They cannot mechanically refer the matter for adjudication. Here, there was a material to show that they were all holding managerial posts, drawing hefty salary between 1,50,000 and 2 lakh. My lord, the reference itself contradictory. As I submitted earlier, their initial observation is prima facie industrial dispute exists. To exist industrial dispute, 2 preconditions are necessary, whether the industry is in existing or whether is a workman under. They cannot leave it to the discretion of only after forming prima facie opinion, the reference has to be made.
Yes.
Therefore, my lord, the entire reference is without jurisdiction and contrary to the settled legal position, my lord. In this connection, my lord, I would like to rely upon few. The facts are same in all the 7 cases. I need not repeat it.
Except
No,
2
my lord,
where you dismissed them. You
yes,
terminated.
citation, sir.
Like, except 2 where you terminated the services.
My lord?
Third matter you terminate ಮಾಡಿದ್ರೆ services ನ.
Yes, yes.
ಬಾಕಿ ಎಲ್ಲ ರೆಸಿಗ್ನೇಷನ್.
Yes, yes. Termination separate ಆಗಿ argue ಮಾಡ್ತೀನಿ.
ಎಲ್ಲರ ಹತ್ರ ರೆಸಿಗ್ನೇಷನ್ ತಗೊಂಡಿದ್ದೀರಾ?
Yes, yes, yes. Now, my lord, I have filed this list of authorities.
ಯಾವ್ದ್ರಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ?
ಇದು ಕೊಟ್ಟಿದ್ದೀನಿ ನೋಡಿ.
ಯಾವ ನಂಬರ್ ಏನಂತ ಹಾಕಿದ್ದೀರಾ ಅದ್ರ ಮೇಲೆ?
101907 of 2022.
01907 ಅಲ್ಲಿ ಹಾಕಿ.
ನಿನ್ನೆ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ.
01907 ಇಲ್ಲ ಸರ್ ಇದು.
ಎಲ್ಲ ಇದು ಒಂದರಲ್ಲಿ ಹಾಕಿ 10 111 of 2020. ILR 1985 Karnataka 248. ILR 1985 Karnataka 248. Yes. ಇದು ಯಾರ್ದಿದು?
ನಾನು ಕೊಡಿ ಸದ್ಯಕ್ಕೆ.
ನಮ್ಮ ಕೋರ್ಟ್ ಫೈಲ್ ಯಾರ್ದಿದು?
ಅವ್ರದ್ದು
ಅವ್ರದ್ದು
ಕೋರ್ಟಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದಾರೆ ನನ್ ತಗೊಂಡು.
ಅವ್ರದ್ದು ಯಾಕೆ ಕೊಡ್ತೀರ? ಇದು ಯಾರ್ದಿದು?
But judgment.
ನಿಮ್ಗೆ ವಾಪಸ್ ಕೊಡಲ್ಲ ನಾವು.
ಇಲ್ಲ ಇದ್ರಲ್ಲಿದೆ ಅವ್ರು ಹುಡ್ಕೋಬರಿಗೆ ತಾವು.
ಅಲ್ಲ ನಂದು ಕೊಡ್ತೀನಿ ಅವ್ರಿಗೆ. ಇಲ್ಲೇ ಇದೆ.
ಅವ್ರದ್ದೇ ಇಸ್ಕೊಂಡು ನಾವು ಕೂಡ
ರೆಫರ್ ಮಾಡ್ಬಿಟ್ಟು ನಾನೇ ಕೊಡ್ತೀನಿ.
ಎಸ್.
First judgment. First identical reference was made in this case. Your lordship may first come to page 3. Page 3. Order. Identical reference. Whereas the government of Karnataka are of the opinion that industrial dispute exists between the workmen and the management of so and so on the points noted. And whereas the government of Karnataka considers it desirable to refer the dispute. First point, whether so and so comes under the definition of workmen under the industrial dispute right. If so, the action taken by the management is justified in terminating so and so. Now, my lord, kindly come to para 6, my lord. Para 6. Fifth line from the top. Fifth line, para 6. In page 4. Sixth line from the top.
Yes.
The validity of the said order was questioned before the court on the ground that unless the government formed an opinion that the said association was an industry without which there could be no industrial dispute, the government had no competence under section 10(1) of the Act to make a reference as formation of an opinion that an industrial dispute existed was a condition precedent to make a reference in exercise of power under section 10(1) of the Act. The said contention was accepted by this court, and it was held that even though the government notification began by saying that in its opinion an industrial dispute existed, same as in our case, the first point of reference itself contradicted the said statement, for the question as to whether the association was an industry or not was not at all decided by the government and was left to be decided by the labor court. The ratio of the said judgment fully applies to the present case also, but nevertheless the labor court lightly brushed aside the judgment of this court and held that the first point was rightly referred by the government, stating that the first point referred in that case was whether the association of the physically handicapped was an industry, whereas the question referred in this case was whether the respondents 2 and 3 were workmen. The existence of an industry and workmen both are essential to bring into an existence of an industrial dispute. If the state government cannot refer the question as to whether a particular establishment was an industry for industrial adjudication, equally the government cannot also refer the question as to whether the persons concerned workmen or not. It may be that in a given case, if substantial number of workmen or a trade union raises an industrial dispute concerning the dismissal from service of one or more employees of an industry, and the employer raises an objection that the dismissed employees were not workmen, the government could refer the question as to whether the dismissed employees were workmen, for in each such a case, notwithstanding the fact that the dismissed employees are not workmen, the dispute still would be between the employer and the trade union or substantial number of workmen. But this is not the position here. The dispute raised by 2 individuals in view of section 2A, and the government could refer the dispute if only it was of the view that they were workmen. Therefore, on this ground alone, the impugned order of reference is liable to be settled. In the instant case, my lord, the dispute raised by each individual officer of the company in the instant case.
Yes.
Coming to the next judgment, my lord, ink page 6, Supreme Court judgment. I will take your lordship to para 25, page 19, ink page 19. Under what circumstances the Honorable High Court exercising its jurisdiction under Article 226 could entertain this petition? It will thus be seen that the High Court has jurisdiction to entertain the writ petition when there is allegation that there is no industrial dispute and none apprehended, which could be subject matter of reference for adjudication to the industrial dispute under Section 10 of the Act. Hence, it is a question of jurisdiction of the industrial tribunal, which could be examined by the High Court in its writ jurisdiction. It is the existence of the industrial tribunal which could clothe the appropriate government with the power to make reference and industrial tribunal to adjudicate it. If there is no industrial dispute in existence or apprehended, appropriate government lacks power to make any reference. A settlement of dispute between the parties themselves is to be preferred, whether it could be arrived at to industrial adjudication, as the settlement is likely to lead a more lasting peace than an award. So under what circumstances this Honorable Court could entertain? Here, absolutely there is no dispute. The resignation tendered by them is not in dispute. The settlement taken by them is not in dispute. The dual relationship of employer and employee came to an end.
What was the claim raised? What was the claim raised by them to the
Claim,
government?
they wanted reinstatement now. Their contention was, we have been forced to tender resignation. That is their contention. Admittedly, they have not withdrawn the resignation. The settled legal position is, my lord, before accepting the resignation, they have to withdraw the resignation. In this case, even after 1 month, I have waited for 20 days or 1 month to accept the resignation. Even till today, there is no whisper that there was an intention for them to withdraw the resignation. Even till today. Then, my lord, para 28. Para 28 in question.
Yes.
20. Industrial tribunal is the creature of a creature statute, and it gets jurisdiction only on the basis of a reference. It cannot go into the question on validity of the reference. Question before the High Court was one of the jurisdiction which it failed to consider. A tripartite settlement has been arrived at among the management, the labor union, and the staff union. When such a settlement is arrived at, it is a package deal. In such a deal, some demands may be left out. It is not that the demands which are left out should be specifically mentioned in the settlement. Now, my lord, it is a well settled legal position. The tribunal and labor courts.
Tripartite settlement.
Only this. I am relaying the judgment only for the proposition that the matter is now referred to labor court for adjudication. Labor court cannot go into the validity or legality of the reference. Whatever that is referred, they have to adjudicate. Because they will get jurisdiction. Labor court and tribunal court get only by the order of reference. They don't have inherent jurisdiction. Unlike Section 151 CPC, which is
beyond, and they are restricted to.
Yes. Therefore, my lord, this honorable court, while exercising the judicial review power, would certainly examine whether there is industrial dispute exists or not. Next judgment, my lord. Ink page 25. Supreme Court, ANZ Grainless Bank. Para 13, my lord. Para 13. Ink page 31. Mr. Burt, learned counsel for the second respondent, has submitted that this court should not interfere with the order of the central government, making a reference under Section 10 of the Act, as the appellant can ventilate its grievances before the industrial tribunal itself, and if the decision of the tribunal goes against the appellant, the same may be challenged in accordance with law. According to learned counsel, the writ petition is premature as the appellant has got a remedy before the tribunal to show that the reference is neither bad in law nor is uncalled for. We are unable to accept the submission made. It is true that normally a writ petition under Article 226 of the Constitution should not be entertained against an order of the appropriate government, making a reference under Section 10 of the Act, as the parties would get opportunity to lead evidence before the labor court or industrial tribunal, and to show that the claim made is neither unfounded or there was no occasion for making reference. However, this is not a case where the infirmity in the reference can be shown only after evidence has been adduced. In the present case, the futility of the reference made by the central government can be demonstrated from a bare reading of the terms of reference and admitted facts. In such circumstances, the validity of the reference made by the central government can be examined in proceedings under Article 226 of the Constitution, as no evidence is required to be considered for examining the issue raised. Here also, my lord, there is absolutely there is no reason for adjudication. All the documents, undisputed documents.
Yes.
My lord, the next case, instead of placing a Supreme Court decision, my lord, this went to Supreme Court. Supreme Court has partly modified the order, my lord. I skip that, my lord, the need space I'm placing.
Yes.
My lord, I will take your lordship to para 12. Para 12. From the order of the state government, we find that while deciding the question as to whether respondent number 1 was a workman, it took into consideration the salary and allowances of the respondent. Respondent drawn at the relevant time and also the nature of work. Respondent 1 who has appeared in person did not dispute the salary and allowances as indicated in the order of the government, but urged that his responsibilities were neither supervisory nor managerial in nature. Mr. Gupta, learned senior counsel for the appellant, has drawn our attention to the circular dated issued by the Appellant Association. The circular indicates the duties of respondent 1 who was functioning as joint secretary at the relevant time, and we find that his duties were to deal with all legal matters and court proceedings, labor and land laws and publications, etc. etc. Respondent 1 had power to sanction expenses incurred in the litigation by the appellant. On the above matters, materials on record, the state government rightly formed the opinion that the respondent was not a workman. Power is there for the government to refuse to refer the matter for adjudication, prima facie if it is found that he is not a workman. Then, my lord, I will skip this judgment, my lord. Then, in page 42, my lord. In page 42, Supreme Court decision, para 3. Para 3. Para 4, my lord, sorry. We find force in the submission made by the learned counsel in the scheme of Industrial Disputes Act 1947. It is not as if the government has to act as a post office by referring each and every petition received by them. The government is well within its jurisdiction to see whether there exists a dispute worth referring for adjudication. No doubt the government is not entitled to enter a finding on the merits of the case and decline reference. The government has to satisfy itself after applying its mind to the relevant factors and satisfy itself to the existence of dispute before taking a decision to refer the same for adjudication. Only in case on a judicial scrutiny, the court finds that refusal of the government to make a reference of the dispute is unjustified and irrelevant factors, the court may issue a direction to the government to make a reference. My lord. Then ink page 46, my lord. Ink page 46. I'll take your lordship to para 8, ink page 48. In order to be a workman, a person should be one who satisfies the following conditions. He should be a person employed in an industry for hire or reward. He should be engaged in a skilled or unskilled manual, supervisory, technical, or clerical work. He should not be a person falling under any of the 4 classes. I'll take your lordship to ink page 51, Steel Authority of India case, para 18, my lord. Para 18. It is thus evident that by taking recourse to an amendment made in the pleadings, the party cannot be permitted to go beyond its admission. The principle would be applied in an industrial adjudication having regard to the nature of the reference made by the appropriate government, as also in view of the fact that an industrial adjudicator derives his jurisdiction from the reference only. There is another aspect of the matter which should also not be lost sight of. For the purpose of exercising jurisdiction under Section 10 of the 1970 Act, the appropriate government is required to apply its mind. Its order may be administrative one, but the same would not be beyond the pale of judicial review. It must therefore apply its mind before making a reference on the basis of materials placed before it by the workman and or the management, as the case may be. While doing so, it may be inappropriate for the same authority on the basis of the materials that a notification under Section 10(1)(d) of the 1947 Act be issued, although it stands judicially determined that workmen are employed by the contractor. The state exercises administrative power.
All the same proposition, so many
Yes,
different.
yes, yes.
One proposition, one
Then, my
judgment.
lord, yes, same promotion. Next is different proposition, my lord. Ink page 59.
Yes.
So when once the jural relationship comes to an end, my lord, he is not a workman. Even assuming he is a workman, he will not fit into the workman definition, my lord. That is the proposition laid down in this case. Kindly come to para 9, my lord.
Yes.
Para 9. I will not read the definition of workman, my lord. Next, last, the definition of workman in Section 2S in connection with persons employed in an industry falls in 3 parts. The first part of the definition gives the statutory meaning of the workman. The second part is designed to include something more in what the term primarily connotes. By this part of the definition, persons who have been dismissed, discharged, or retrenched in connection with an industrial dispute, or whose dismissal, discharge, or retrenchment has led to the industrial dispute. This part specifically excludes the categories of persons specified in clauses 1 to 4 of Section 2S. The third part connotes that even if a person satisfies the requirements of any of the first 2 parts, if he fails in any of the 4 categories in the third part, he shall be excluded from the definition of workman. In our opinion, the appellant, having voluntarily tendered a resignation pursuant to a scheme for voluntary retirement, the resignation having been accepted by the management and all the benefits arising out of such resignation has been paid by the management and received by the appellant, he cannot be treated as workman coming under section 2S of the IDA. So he is not assuming he is a workman, still he cannot come under the definition. My lord, only in the case of dismissal, discharge, retrenchment, they are deemed to be workmen only for the purpose of raising dispute.
Voluntary to involuntary.
Yes, yes. It is a termination at the instance of the employer for misconduct or for excess manpower. Or
But
here
one of the
it is a voluntary act.
One of the contention they urge, as what you said, is that it's a forced resignation.
Yes.
So whether it's forced or not,
Mm.
would have to be considered. Who will consider if it is forced or not?
Yes.
If ನೀವು ಹೇಳೋದು ಇಲ್ವೇ ಇಲ್ಲ resignation ಕೊಟ್ಟರು ಮುಗ್ದೋಯ್ತು ಅಂದ್ರೆ, if the allegation is that the resignation was obtained under duress, coercion, undue influence.
No, that is required to be examined with the available material.
So that will have to be adjudicated by the tribunal.
No. Here he has received all the benefits. They have received all the benefits.
ಅದಕ್ಕೆ claim petition.
They have received all the benefits. They have received all the benefits. They have not withdrawn the resignation. I will come to that again, my lord.
It's an afterthought ಅಂತ ನೀವು ಹೇಳೋದು.
Yes, it is an afterthought. After
So 1 year.
if such claims are allowed, my lord, then no, I cannot accept any resignation.
Because for 1 year he did not come to
Yes,
your office.
yes. Now, my lord, page 64, this is same thing is reiterated by this honorable court also.
Yes.
When the dual relationships comes to an end, there cannot be any employer and employee relationship. And with regard to resignation, my lord, kindly come to page 79.
79.
79. Paragraphs 22 and 23. In page 87. Paragraphs 22 and 23. Recent judgment.
22 and 23. Na?
Yes. This court in so and so judgment has held that the resignation would be effective on its acceptance, even if the acceptance is not communicated, as long as the rules or guidelines governing the resignation do not mandate such acceptance of the resignation is to be communicated. In the instant case, my lord, the resignation was accepted, it was communicated, benefits were settled. Therefore, and even today it is not his case that he was intending to withdraw the resignation. Next, my lord, lastly, I rely upon two more judgments.
Yes.
Two more judgments. Para 23, my lord. Para 23. As noticed above, in the present case of resignation is dated 18/11/1988 and the same was found by us is accepted on 18/11/1988 itself. The communication was on 1/12/1988, about 13 days thereafter, which delay in our opinion is not an undue delay, so as to make us draw an inference that there has been no acceptance of the resignation. Even the fact that in the meantime the respondent has either attended the work or signed the attendance register will be of no assistance to claim his resignation had not been taken effect. Even otherwise, the appellant has urged that because there was no responsible officer in the headquarters from 18/12/1988, the respondent's resignation was accepted till 1/12/1988, and the respondent took advantage of the same and marked his attendance, and such attendance cannot be treated as lawful attendance in view of the acceptance of resignation on 18/11/88. We agree with this contention of the appellant. In last judgment, in page 6, whereas 9 and 11. In page 11, para 9. The general principle is that a government servant or functionary who cannot, under the conditions of his service or office, by his own unilateral act of tendering resignation, gives up his service or office, normally the tender of resignation becomes effective and his service or office tenure gets terminated when it is accepted by the competent authority. Thus, having regard to the letter of resignation, in the present case, there can be no doubt that this is so and so had in his letter dated 6/9/1993 indicated his unequivocal intention to resign in the clearest possible terms with immediate effect. The resignation was tendered by so and so voluntarily without any pressure or coercion from the principal of the college, as recorded by all the inquiry officers in their respective fact-finding reports. So, therefore,
yes.
Therefore, my respectful submissions to your lordship is
Resignation has been accepted, all the amounts being received voluntarily, applications have been filed to the authorities, they
Yes,
cannot
yes.
withdraw it after 1 year. Yes.
Lords, if I may.
Yes, who wants to start amongst you?
Just 1 minute, your lordship. It is our order.
ನಿಮ್ದೇನ್ ನೀವೇನ್ ಹೇಳಂಗಿಲ್ಲ.
Just one submission, Lord. Section 10, your lordship, make a list. Ten one.
Yes.
Where the appropriate government is of the opinion that any industrial dispute exists or is apprehended. So, lordship, on that basis, your lordship, we are referred. Because, your lordship, it is the annexure H, your lordship, order in question. That your lordship, point number 1, ವಿವಾದಾಂಶಗಳು. ಆಡಳಿತ ವರ್ಗದವರಾದ ಜಂಟಿ ವ್ಯವಸ್ಥಾಪಕ ನಿರ್ದೇಶಕರು, in that para, your lordship, last lines, ಇವರು ತಾವು ಕೈಗಾರಿಕಾ ವಿವಾದ ಕಾಯ್ದೆ 1947 ಕಲಂ 2SD ಕಾರ್ಮಿಕ ಪದದ ವ್ಯಾಖ್ಯಾನದಲ್ಲಿ ಬರುತ್ತಾರೆ ಎಂಬುದು ಸಾಬೀತುಪಡಿಸುವರೆ. It's a matter of evidence, your lordship. At this juncture, your lordship cannot come say that your lordship order is illegal. The learned friend argued, your lordship, is a mixed question of fact and law. It is not. When it is, your lordship, it is the issue frame. It is this for this referred. So, your lordship, the impunity is just and proper. So, your lordship, the petitioner is not having any grievance, your lordship. When it is, if the government is given a fine, it is a workman, I can understand. Only, your lordship, was ಸಾಬೀತುಪಡಿಸುವರೆ, it is the referred. Government is not given a finding, it is a workman.
The government is not given a finding, but
Yes.
if the, before the government were to refer the matter, is it that the government will refer all the matters or does it
All
have
the,
to
your
take
lordship,
into consideration?
all the facts, your lordship, has to prove, your lordship, in the.
Is it a matter of course that notice is ordered in everything? Or reference is made in everything? Or orders are passed in everything? Should not the government apply its mind?
It is
Or does the government has no mind?
not like. And annexure A 2K, your lordship, 2S, your lordship, and that, your lordship, workman and the dispute.
Government is a independent player protecting both the interest of the employer and the
That basically,
employee.
now we have filed objection, the objection may be considered.
Yes. Abhishek, Ravi, who is going to start?
My lord, I will only take 2 minutes of your lordship's time.
Yes, please, Eli.
My lord, my question, the question of law with respect to the scope of section 10 and the prima facie nature, as well as the designation of the employee here is concerned. My lord, on the factual aspects, on 6/8/2020, my resignation was received. On 8/8/2020, I have withdrawn my resignation through an email. My lords, I have produced all those documentary material before the government.
They are
And
appearing in which matter?
The first matter, my lords.
In the first matter.
106038.
106038.
Please, my lords.
You have withdrawn your resignation on?
8/8/2020, my lords. That is 2 days after my date of resignation.
Then why did you accept all the amounts? If you have withdrawn, where's your withdrawal?
Lord, that has not been produced, my lord. So my apologies. I will produce
If
it.
you not produced, it's not there.
Lord, it is there. I will produce it, my lords. I will undertake to produce it.
And
However, my lord,
confidently you are saying I withdrew it 2 days later, but it's not there.
please, my lords. I will
Answer two questions. Even if you withdrew it,
please, my lords.
it was accepted on 39.
Please, my lords.
And thereafter you received the amounts.
Lords,
You've been holding on to the amounts from that date, that is
Lord,
21/9/2020, 28/12/2020.
They are not disputed, my lord.
However, as pointed out by your lordships, these resignations were under duress and coercion. That is our contention. That is the dispute raised, which
Did
needs
you
to be.
take 3 years to realize that it was duress and coercion? We'll ask there also, we'll ask you also.
Lord, certainly not, my lords.
Why did it take 3 years for you? 3 years you did not go to, did you attend to work in the factory or the office of the petitioner?
No, lords, it could not be done because of the COVID situation at that time, during that time. This because it was prevalent at that point.
COVID was somewhere earlier. We are now speaking of 2023 when you sought for reference.
Please, my lords, but our contention is that all these resignations were
not
under.
there during that time, Mr. Patil.
It was under coercion, my lords. That is the dispute raised. That is the dispute which needs to be adjudicated. My lords, and in
3 years. And what is the reason? What is the reason given by you to explain 3 years? Any
Lord,
reason given?
Lord, the reasons I've assigned it in my application before the Labour Commissioner, my lords. I will produce all those documents. But however, my lords, with respect to the scope of
when the matter is set down for arguments today, specifically at 2:30.
I had raised my preliminary objections with respect to the maintainability of these petitions on 2 aspects. If I may rely only upon one judgment of the Honorable Supreme Court on this question.
Yes.
Lord, the list of authorities which I have produced.
ಯಾವಾಗ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಾ?
On 23/10/2024, my lords.
23/10/2024. ನಿಮ್ದು ಯಾವ್ದು ಸೈಟೇಷನ್ ನೀವಲ್ಲ ಇಲ್ಲಿ?
Lord, it is shown. My colleague had cross-checked it. They said it was there.
Who is your colleague?
In this petition, kindly refer to Annexure H, page 56, my lord.
Let him make a submission. 106,
case.
and then you can reply. 106038 alla?
Please, my lords.
Who is your colleague?
But Shekhar Gowda, he was there.
Nobody is here.
I am appearing in this case
He
also.
checked with the court officer.
You are appearing for him?
This case also.
For the petitioner you are appearing?
Yes, my lord.
Our citation ಅವರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
Our citation.
ಇದು petitioner ಅಪ್ಪ ಇದು. Respondent ಬೇಕು. Nobody is here, we don't have it on the file. ಒಂದರಲ್ಲೇ ಅಪೇರ್ ಆಗ್ತಾ ಇದ್ರಾ ಇನ್ನೊಂದರಲ್ಲೂ ಅಪೇರ್ ಆಗ್ತಾ ಇದ್ರಾ?
Only the first matter.
ಇದರಲ್ಲೇ ಇರಬೇಕು ಅದು.
Citation ಯಾವುದು ಕೊಟ್ಟಿಲ್ಲ.
ನಿಮಗೇನು ಕೊಟ್ಟಿಲ್ವಾ?
Lords, I had served it on the advocate on record, Mr. Prasad Gowda.
ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ, ರೆಕಾರ್ಡ್ ಅಲ್ಲೂ ಇಲ್ಲ.
ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇಲ್ಲ, ಅಡ್ವೊಕೇಟ್ ಹತ್ರನೂ ಇಲ್ಲ. ನೋಡ್ಬಿಟ್ಟು ಕೊಡಿ.
Page 56 ಸ್ವಲ್ಪ ನೋಡಿ ಫಸ್ಟ್ ಕೇಸ್.
Just call your colleague and find out where it is.
Please, lords.
Page 56. Order of reference.
Yes.
It was made nearly after 2 years, 15/6/2023, date of
Yes.
reference. Bere Castle to the 15/6/2023.
Either even later than everything. Yes, Mr. Ravi.
Lord, the first case, my lord, kindly take 10114
1114.
Yes.
My learned friend has pointed out, basically, my lord, he has canvassed 3 points, basically, as I understand. One is, there was no application of mine by the government before referring the matter to the competent labor court for adjudication.
Yes.
According to him, my lord, there was not even an industrial dispute which could be referable as on the date of the reference which the
No
government has.
relationship, consequently, there was no.
Yes.
industrial dispute.
Then, my lord, he has fundamentally argued one point, that is, before reference, before the government, when the matter was at the conciliation stage, there were abundant materials which we have placed before the conciliation officer and in effect before the government when the matter was being under conciliation to show that prima facie even they do not fall under the category of the workman. Therefore, government has erred in referring the matter. That is what is submission. My lord, kindly take, my lord, the very first document which was produced, the so-called resignation according to us, which was taken by us.
Taken from you.
Yes.
Taken by you.
Taken
now?
by, my lord, because I am representing.
No, from you. now.
No, there are other workmen also, you know. On page 45, my lord, immediately I brought to the, I have sent an email intimating the matter of resignation, which was under deceit, which was taken. It is not that, my lord, I am not agitating the matter. My lord, during the COVID period, the management wanted to reduce the workforce. Then, my lord, they have operated, my lord, so many methods in reduction of manpower. Then, my lord, the first step what they have taken in the case on hand is they have blocked my punching card, which I have stated in my counter statement. Then, my lord, I had to wait at the gate of the company for quite some time. I have stated in my objection statement. Then, my lord, at the way, immediately I have retorted, you have taken my resignation deceitfully, therefore it is not correct.
Where is
Then,
the
my lord, my
correspondence?
terminal benefits have been remitted to my bank account.
Where have you said that?
My lord, I have filed the statement of objections.
Torsi, document Torsi. That
My
you
lord,
are
document
prevented
is
from entry, all those things you show us.
the very same, my lord, petition itself, my lord, they have produced. The mail which has been sent, page 45. Grievance description ಅಲ್ಲಿ ಹೇಳಿದೆ.
ನೀವೇನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ. Petition ಅಲ್ಲಿ ಯಾವ್ದು page number?
Page number 45, 45. Annexure N. Then, my lord, the issue went up to the deputy commissioner also. Deputy commissioner has, my lord, said there are various other machinery, you can invoke it, you don't come here. Then, my lord, it has come in newspaper. Then we approached the commissioner of labor by representing my giving a conciliation petition before him.
This letter you sent on 28/2020.
Yes.
But all the benefits you received on 28/12/2020, 21/9/2020.
Subsequently, my lord,
So did you return the benefit and say, don't give it to me, I am still working?
it was remitted to my bank account, my lord. It was remitted.
Assuming it's been remitted to your bank account, which is contrary because you have signed the application. You signed the applications here for return of the money to the application which you submitted to the gratuity authority and.
My lord, they are all statutory amount, my lord, which even.
You have signed.
Yes,
which you would not have been entitled to if you are continuing in employment.
Yes, ultimately, my lord, even if reinstatement is granted, I may have to shell back, my lord, or else I may not be entitled for the amount which has been now settled.
The question is whether your resignation is voluntary or not.
Yes.
To determine that, we'll have to see whether they forced you to do it.
Yes.
Ex facie on that. But now ex facie, when we see that you have signed all the forms, even post this 28/2020, received the monies, kept quiet till 2022. And thereafter raised this issue.
No, my lord, it was raised in 21, my lord, the conciliation notice was issued on 1/3/2021, Annexure P.
Annexure?
Annexure P, page 46. The conciliation notice will be issued, my lord, after the workman complaints of this forceful resignation.
So where is your complaint?
Then, my lord, it is,
In complaint only, what documents have you produced?
Lord, conciliation petition was filed before the conciliation officer.
Where is the conciliation petition?
My lord, conciliation petition I don't have, my lord. I don't.
ಇಲ್ಲ ಅಂತೀರಲ್ರಿ ಇಬ್ರುನು.
The government ಕಡೆ ಇರುತ್ತೆ, my lord.
Resignation letter, revocation ಇಲ್ಲ ಅಂತೀರಾ.
Resignation letter they have produced and grievance they have also produced.
What were the grounds that you raised there? Did you say that it is involuntary, it was forced? ಏನ್ ಹೇಳಿದೀರಾ ಅಂತ ನೋಡ್ಬೇಕಲ್ವಾ? ಅದಕ್ಕೆ ಅವ್ರು ಸಿಂಪಲ್ ಆಗಿ ಎಲ್ಲ ರೆಸಿಗ್ನೇಷನ್ ಆಗೋಯ್ತು ಇದಾಯ್ತು ಅಂತ ಮುಗಿಸ್ತಾ ಇದ್ದಾರೆ.
That I will, my lord, place it on record, my lord. I thought government maybe having the original file.
Who is going to get affected, Mr. Hegde? You or the government? Yes. And you want the government to do your work?
No, they don't
do their own work. You want them to do your work?
That is, my lord. Yes, I will place it on record.
When?
Lord, within a week, my lord, I will place it on record.
Yes.
My lord, after that they have given a declaration. Kindly come to.
Let them produce it and we'll deal with those documents on the basis of your submission because ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡೋಣ. What they have given.
ಅಲ್ಲ ನಾನು ಹೇಳೋದು page 36 ಒಂದ್ಸಲ.
That opportunity has to be given for them to produce. Heard Shri Subramanian learned counsel appearing for the petitioners in all the matters.
Except 2, my lord. 7 matters. These 2 matters I will argue separately. Termination cases.
ಎರಡು ಮಾಡಿಲ್ಲ ನೀವು. Insofar as WP 101/905 of 22 and 101/909 of 2022 is concerned, he submits that he would make his submission after the respondents make the submission in the other matters. Shri Ravi Hegde and Shri Abhishek Patel seek for and are granted a week's time to produce certain documents which they claim, the respondents claim to have submitted during the course of their arguments.
Yes.
Released on 6th February.
2:30 my lord.
Subramania and Mr. M.M. Kannur, learned AG, appearing for the state.
7th or 8th
For the hearing.
For further hearing, my lord.
ಬಟ್ ಅವ್ದು ಮುಗಿಸ್ಬೇಕು. ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಹಾಕೊಂಡ್ಬಿಟ್ರೆ ಪ್ರಾಬ್ಲಮ್ ಇದು. ಬೆಂಗಳೂರಲ್ಲೂ ಫರ್ದರ್ ಮುಗಿಸ್ತೀವಿ ಅಂತ ಹಾಕೊಂತಾರೆ.
Your lordship has spent considerable amount of time.
ಬಟ್ ಅವತ್ತು ಮುಗಿಸ್ಬೇಕು ಅಂತ. We'll try to finish Dharwad matters in Dharwad, Bangalore matters in Dharwad, in Bangalore.
May I request it on 10th, my lord.
10th ಬೇಡ 7.
ನಾನು ಫರ್ದರ್ ಮಸ್ಟ್ ಟೈಮ್ ಕೇಳಬಾರ್ದು ಮತ್ತೆ.
ಇಲ್ಲ 10th ಯಾವತ್ತು?
10th ಮಂಡೇ ಬರುತ್ತೆ.
ಮಂಡೇ ಬೇಡ ಸ್ವಾಮಿ. ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ ಲೇಬರ್ ಮ್ಯಾಟರ್ಸ್ ಇದೆ.
ಆಯ್ತು, ವೆಡ್ನೆಸ್ಡೇ ಹಾಕೋಣ.
ವೆಡ್ನೆಸ್ಡೇ ಹಾಕೋಣ.
12th February at 2:30 p.m.
Yes. Yeah, see them. Nam judgment.
83 Suresh Gundi.
This is a case the other day was submitted, lordship, where retail outlet was given to the petitioner's son as well as respondent number 4 son. In the
Mr. Rajendra C. Osmat.
not
ಇವತ್ತೇ ಇಲ್ವಾ? Reserve the matter. Your address arguments, we have made note of it.
Yes. Two more submission. Annexure, yes, last time ಕೇಳಿದ್ರು sir. Annexure P was the order without my appearance. An order came to be passed. So then we filed a review. Review the annexure, yes, the order came to be passed as per annexure, yes. review order. May I request Lordship to peruse the 5th page of that. Last time ಓದಿದ್ರು, but still,
Yes.
ಅದರಲ್ಲಿ second paragraph,
Hmm.
survey number 132A3.
Hmm.
Now, A3 is not in dispute, Lordship. Now, he has gone through all in respect of A3 and he has passed this order.
Is not referred to the other survey numbers? Survey number 133 ಇರುತ್ತದೆ.
A3 ಅಂತ ಹೇಳಿ ತಿಳ್ಕೊಂಡೆ, ಅದ್ರ ಬಗ್ಗೆ ಪ್ರಾಪರ್ಟೀಸ್ ನೋಡಿ, ಅದರ ಬೌಂಡ್ರೀಸ್ ನೋಡಿ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ್ದಾರೆ ಸಾಹೇಬ್. ಬಟ್ ಆಕ್ಚುಲಿ ಪ್ರಾಪರ್ಟಿ ಇಸ್ 132/3B, which is actually involved in this case. May I take Lordship to my petition, page number 19, annexure C. Annexure C, Lordship, there are two properties. One is 132/3B, right hand side, 5 gunta 6 annas. That is converted into non-agriculture. But whereas the 133/3A, 2 acres 9 guntas 10 annas is still an agriculture land. Agriculture land papers nodibittu, the officer says that they don't tally. Yes, that is definitely an agriculture land. We don't dispute that. Non-agriculture is this very 5 guntas, sahib.
A3 and 3 are the same. The way of writing it is different.
A3 and 3A are both same.
I'm representing R1 and R2 in only WP number 109435/2017. I'm not a party in his writ petition, my lord. There are two cases, my lord.
Therefore, annexure Q and ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ ಸಾಹೇಬ್ರೆ, that is correct.
None appears for respond number 3 in WP 116434 of 2019 today also. Arguments of the other councils having been heard, reserved for judgment.
'84, Suraj Mudhol.
My lords, I appear for respondent number 10, my lords. Client has engaged senior counsel for this matter. He will be appearing on 11th February.
The matter is listed today.
Yes, sir.
You are not concerned with senior counsel appearing on 11th. You have been given extended benefit. You are the chairman who has taken away the money and run away.
Apologies.
We won't be giving you any adjournment. Last time also we have told you. Please don't make this kind of submission to embarrass the senior counsel.
I apologize.
No adjournment. What happened to the money? Where is it? When are you going to get it back?
My senior is held up in another court.
Bad luck. ಕರ್ಕೊಂಡು ಬನ್ನಿ ನಿಮ್ಮ ಸೀನಿಯರ್
ಪ್ಲೀಸ್.
ಪಾಸು ಯಾವತ್ತು ದುಡ್ಡು ವಾಪಸ್ ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀರಾ ಹೇಳ್ಬೇಕು.
'230 mood matter. 1, Vidyashankar Dharwad.
ಪಾಸು
2, SB Habballi.
Rise out of the execution petition, Lord. Lord, I suffered a decree of possession. Lord, EP was filed. Lord, application under 26 Rule 9. Lord, appointment of commissioner, which is meant for local investigation.
Yes.
Lord, that on that application, Lord, the almost, Lord, the trial court proceeds to dispose of issuing a delivery warrant. without hearing the case on merits, my lord. Though we have filed objections at page 78, 76, my lord, it starts. My lord, on that application, 26 rule 9, my lord,
Where is the 26 rule 9 application?
my lord?
Application is the page number?
Page 32.
Yes.
Page?
32.
Yes.
That was the application. I filed my objections. My lord,
Yaವಾಗ ಕೊಡ್ಸ್ತೀರಾ, Mr. Bulli?
pardon, my lord.
When will you hand over possession? Give us a reasonable time, we'll ask Mr. Sabil to wait till then.
2 years, my lord. 2 years, my lord.
Execution 9 ವರ್ಷ ಮಾಡಿದೀರಾ. 9 ವರ್ಷ
ಅಲ್ಲ,
ಮಾಡೋ
residential
capacity ಇದೆ ನಿಮ್ಮ
premises, my
client ಗೆ.
lord.
Suit is
Without
of the year.
hearing on merits, my
1989.
lord. Well, I was required to hear on merits, my lord. And my lord, nothing
Delivery
remains.
warrant, they should not have been held up for 9 years. It was one simple order to be passed, issued delivery warrant by appointing commissioner or through the commissioner. Could have been done in 2000.
16.
ಯಾವತ್ತಪ್ಪ ಆಗಿರೋದು? 16.
16 ಹಾಕಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಕೇಸ್.
9 ವರ್ಷ ಎಳೆದಿದ್ದೀರಾ. ಏನ್ ಹೆಂಗ ಗೊತ್ತಿಲ್ಲ, ನೋಡಲ್ಲ, ಬೇಡ. ನೋಡಿದ್ರೆ ಕಷ್ಟ ಆಗತ್ತೆ.
ಅಲ್ಲ, ರೆಸಿಡೆನ್ಷಿಯಲ್
Suit is of the year?
1989, sorry.
1989.
Please.
For possession.
Yes, please, your lordship. 2000, in the year 2000, decree was passed.
Relationship ಏನ?
ಇಲ್ಲ, ಇದು ಟೆನೆಂಟ್ ಅಂತ ಹೇಳ್ಕೊತಾರೆ, ಕ್ಲೇಮ್.
ಯಾವಾಗ ಹೇಳಿ?
They are not related.
ಎಷ್ಟು ತಿಂಗಳು?
2 years.
We are not interfering. If you make a reasonable time, we'll extend that time. Otherwise, immediately it will be dispossessed.
No, whatever your lordship.
ನೀವು ಹೇಳಿ, ನೀವು ಕೇಳ್ಕೊಂಡು ಹೇಳಿ. ಅವಾಗ ಅಂಡರ್ಟೇಕಿಂಗ್ ಅಫಿಡವಿಟ್ ಹಾಕ್ಬೇಕು. We'll have it next week. You file a affidavit. On that basis, we'll have.
Very well.
89 ಇಂದ ಅದರಿಂದ ಇನ್ನ ಯಾವತ್ತಿಂದ possession ಇದ್ದಾರೆ ಅಂತ ಕೇಳೋದು ಬೇಡ.
Residential premises, since my lord, they are staying
You are
there.
not the owner. You have to give that the property to the owner. You accept notice for all.
No, my lord, only the plaintiff.
My lord,
Other are JDRs.
R2 to R29, my lord,
Dispense, my lord. I'm the only contesting party.
Judgment
Notice to respond number 2 to 29 is dispensed with in view of there being the
co-judgment debtors.
co-judgment debtors. Shri SB Aballi seeks for and is granted 3 days time to obtain his instructions
3 days
from the petitioner.
Tuesday,
petitioners
next Tuesday.
And file an affidavit as to by when the petitioners would vacate the subject premises. The counsel for respondent number 1 submit that until then they would not precipitate the matter. Relist on 4th February.
Please, your lordship.
Sachin Angadi.
petitioner filed application in IA number
I number 7.
7
Yeah.
and order 6 rule 17 read with
At the
section
time of
1 of the CPC for amendment of the written statement on 2/4/2024. By way of the said amendment, the defendant wanted to introduce para 1A in the written statement to contend that the defendant has not taken any loan from the plaintiff bank, and when the loan itself is not availed from the plaintiff bank, the plaintiff has no right to file the suit. And the documents relied upon the plaintiffs are all concocted documents. The said application having been objected to came to be dismissed by the trial court. On the ground, firstly, that the amendment sought for is a post-trial amendment and amounts to withdrawal of the admission made by the defendant. And as such, the same cannot be allowed. It's challenging the same, the petitioner is before this court seeking for the opposite relief. In ground.
Lord, the ground, my lord, the petitioner is not taken the loan, my lord.
Learned counsel for the petitioner reiterates that the petitioner has not taken any loan, and as such the suit filed is without any basis. This averments could not be made in the written statement originally filed.
Yes.
The same having come to the knowledge of the defendant when matter was posted for argument, the application was filed. Heard so and so perused papers. In the written statement filed, originally the defendant has categorically stated that there is a make-believe story made by a false story made by the plaintiff. The loan amount, the loan has not been granted as per the requirement of the defendant. The loan sanction was not sufficient for the business, and as such the defendant was forced to avail loan from private financiers, due to which heavy loss has been caused. It's further stated in the written statement that defendant has repeatedly requested for grant of some time for repayment of the amount by way of easy installments. And that the defendant was ready to avail one-time settlement. Such being the pleadings filed in the written statement, the pleading now sought to be inserted by way of amendment that no loan has ever been taken and the documents are concocted would be contradictory, as also amount to withdrawal of the admission by way of such contradiction, though the other admissions are not withdrawn. In that view of the matter, I am of the considered opinion that the trial court has rightly rejected the application. No fault can be found with the trial court's order. The petition not making out any grounds stands dismissed.
4, Susai M. Patil.
This is a defendant writ petition by plaintiff filed application for amendment only after the.
You are the defendant. Suit for
permanent injunction. My lord, what has happened? Annexure F may kindly be seen for a minute, my lord.
F. Page?
At page 64, my lord. Per contra, the counsel appearing para number 6, my lord. Respondent would contend that both the courts have taken note of the registered document as well as income certificate, and also documents came into existence since the year 1966 and 67, and prior to that in the year 1941 to 65. He would further contend document established defendants are the owners of the property. Same has been considered by trial court and also appellate court. It doesn't require interference. So earlier the MA was filed by the plaintiff and it came to be dismissed. Against that this WP was filed and this WP came to be dismissed. After this they filed the amendment application. At 2017 they have filed chief examination, my lord.
And 2021, this amendment application has come to
An
effect.
amendment application ಎಲ್ಲಿದೆ?
At
Page
D,
number?
annexure D, my lord.
Page number
45.
45.
And it is not one para or two paras. It is running to 2-3 pages. And my only submission is that to fill up the lacuna, all these amendments have been proposed. And now after this amendment,
Where is the plaint? Yes. Issue notice to the respondent, returnable by 10th March. The further proceeding in OS number 280 of 2016 pending on the file of the civil judge and JMFC Hangal is stayed till the next date of hearing. Process fee and copies to be furnished by end of day 31st January. Acknowledgement of service on the counsel appearing for the respondent before the trial court to be filed with the registry of this court on or before 6th February.
Please.
Failing either of which, the interim order will stand automatically vacated.
Please.
One petition to Dharwad.
Please.
Mr. Dalwai.
Please. My lords, my land was acquired, my lords, by the National Highway Authority. My lords, and compensation was not paid, my lords. So I made an application before respondent number 2, my lords. My lords, at annexure S is the order of the respondent number 2, my lords, where the relevant para, my lords, it is at page number 50, my lords. Second para, my lords. Page number 50. Second para, my lords.
Yes.
ಕಾರಣ ಮಾನ್ಯ ಪ್ರಿನ್ಸಿಪಲ್ ಸಿವಿಲ್ ಜಡ್ಜ್ ಮತ್ತು ಜೆಎಂಎಫ್ಸಿ ಹೊಸಪೇಟ್ ಇವರು ತಮ್ಮ ಆದೇಶ ಸಂಖ್ಯೆ ಓಎಸ್ ನಂಬರ್ 2/16 ದಿನಾಂಕ 1/9/16 ರಲ್ಲಿ ಕ್ರಯ ಪತ್ರಿಕೆ ಸಂಖ್ಯೆ 2787 ದಿನಾಂಕ 25/9 ಮೂಲಕ ಕರ್ನಾಟಕ ಸರ್ಕಾರಕ್ಕೆ ಸೇರಿದ ಜಮೀನ್ ಪೈಕಿ ಖರೀದಿಸಿದ ನಿವೇಶದಲ್ಲಿ ಮಾಲೀಕರು ಅಬ್ಸಲ್ಯೂಟ್ ಓನರ್ ಎಂದು ಘೋಷಿಸಿ ಇರುವುದನ್ನು ತಳ್ಳಿ ಹಾಕಿ ಗಾದಿನೂರು ಗ್ರಾಮದ ಸಂಖ್ಯೆ 21 ವಿಸ್ತರಣೆ 2.71 ಎಕರೆ ಭೂಮಿಯ ಪಹಣಿ ಪತ್ರಿಕೆ ಪ್ರಕಾರ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಬೋರ್ಡ್ ಗ್ರಾಮದಂತೆ ಪುನರ್ ಘೋಷಿಸಿ ಆದೇಶಿಸುತ್ತದೆ. Respondent number 2, my lords, set aside the civil court judgment, my lords, where declaration stating that I am the absolute owner.
Where is OS 2 of the judgment?
My lords, that is at page number, my lords, annexure E, my lords, page number 24, my lords.
This suit had been filed by you against...
Yes, my lords. When this regarding the amount, they didn't release the amount, my lords. So I filed the declaration suit where it has been stated that the plaintiffs are the absolute owner of the suit scheduled property, my lords.
Copy ಕೊಟ್ಟಿಲ್ವಾ?
ಕೆಲಸ ಮಾಡ್ತಾರೆ ಬಟ್ ಇಲ್ಲಿ 230 ಅನ್ಕೊಳ್ಳಿ.
ಇಲ್ಲೇ ಕೊಡಬೇಕು.
Sorry,
230 ಅವ್ರು ನೋಡಿ. And AG accepts notice for respond number 1 and 2. NHA again?
Millers, Rakesh Bilki, Millers.
Rakesh Bilki, the director accept notice for respond number 4. The operation of the order dated 25/9/24 passed and so and so at annexure H insofar as the petitioner is concerned, he stated till the next date of hearing. Counsel for the petitioner furnished 2 sets of the petition along with annexures on the aforesaid counsel.
Yes, annexure J also I am seeking stay, my lords, where based on that order, my lords, a notice is issued to me, my lords, by respondent 3 to refund the amount, my lords.
Annexure H and consequently annexure J.
Please.
Acknowledgement to be filed on or before 5th February.
Please.
Pass over matter. Serial number 7, Shant Kardevar.
Bandhi application. IA1 of 25 has been filed for discharge of the guardian since the minor respond number since respond number 4 has attained majority. Accepting the amendments made in the said application, considering that respond number 4 now be attained majority, the minor is discharged from the matter. Respond number 4 can well contest the matter by himself in order to enable respondent number 4 to appoint a counsel to represent him, released on 18th February.
PR Bentur.
Nodadra, madam?
I've gone through the. My only submission is
17B Kodi.
maybe disposed of my, because maybe
Disposed of.
My only submission is the order of the division bench prevails over the single bench. That is my only submission.
The petitioner, Road Transport Corporation, is before this court seeking for the following reliefs. It is contended respondent was appointed as a trainee conductor cum driver on 12/2/2007 and on account of his unauthorized absence was dismissed from service by the corporation on 29/2/2012. Respondent trainee having raised a dispute in KD number 36 of 2012, the labor court set aside the dismissal and directed the petitioner to reinstate the respondent to service at the original post with continuity of service, as also consequential benefits in notional terms without back wages within 2 months. It is challenging the same, the petitioner is before this court. The submission of Ms. Bentur, learned counsel appearing for the petitioner, is that the respondent being a trainee, the petitioner corporation could dismiss the said trainee at any time. The said trainee cannot be considered to be a workman. And further, that until confirmation and appointment, such conductor cum driver could not raise a dispute under the ID Act. This she submit has not been taken into consideration in a proper perspective, and in this regard she relies upon the judgment of the division bench of this court dated 19th February 2024 in WA number 100654 of 2017. Sri Ravi Egde, learned counsel appearing for the respondent workman, would rely upon the decision of a coordinate bench of this court dated 25th April 2024 in WP number 100878 of 2017, and submits that the judgment in WA number 100654 of 2017 was rendered on the basis of the judgment in WP number 100556 of 2015, which was in turn rendered on the basis of the judgment in WA number 100383 of 2015. All the three judgments have been considered by a coordinate bench of this court in judgment dated 25th April 2020 in WA number 100878 of 2017. And the coordinate bench has come to a conclusion that in all those judgments, the aspect and definition of workman has not been considered. And it is on the basis of submission made by the Road Transport Corporation that the workman is a trainee that orders were passed. The coordinate bench in WP, while dealing with WP 100878 of 2017, has passed a detailed judgment of nearly 90 pages, considering all these aspects, negating the contention of the Road Transport Corporation that a trainee could be appointed, and has also categorically come to a conclusion that the appointment in rules are the
C and R rules.
The cadre and recruitment rules of the RTC do not provide for recruitment of trainee conductor, driver cum conductor any such recruitment would have to be only on a permanent basis. Thus, once respondent was appointed, he was appointed as a driver cum conductor and could not be said to be a trainee driver cum conductor. On that ground, he submits that the decision of the labor court is proper and correct. So and so peruse papers. Though the labor court did not have the benefit of the order of the coordinate bench dated 25th April 2024 in WP number 100878 of 2017, the labor court has considered the matter and come to a conclusion that the workman was discharging the duties as that of any other workman, and there was no difference in the work discharged by this workman and any other workman, and come to a conclusion that he cannot be said to be a trainee. Be that as it may, in view of the judgment dated 25th April 2024 in WP number 100878 of 2017, this aspect having been considered in detail and a coordinate bench having come to a categorical conclusion that there could be no appointment of a trainee driver cum conductor, and training during the course of employment would not make that person a trainee driver cum conductor, the same would be applicable to the present case also. As such, I do not find any grounds in the above petition. The petition stands dismissed.
Least, my lord, let them reinstate. I did not have the benefit. No 17B.
The time, in time fix ಮಾಡಿದ್ರು labor court.
Lord, from the date of publication, my lord.
The time fixed by labor court is extended by a period of 1 month from today, by which time the Road Transport Corporation would have to comply with the order of the labor court.
29.
Pending stands disposed. 20.
Nice.
I was directed to not produce a sale lists, my lord. So since sale lists, my lord, are the old sale lists, 1956 and other, my lord, 30 to 40 years. I have applied, online application has been given yesterday. However, I have obtained, lord, the diary, my lord, mutation entry, which shows survey number 160/1 has been sold in the year 1956 by the father and grandfather of the petitioner. Third last page, notation entry 1186.
It was sold when?
1956, my lord.
That cannot be a ground today to raise.
No, the other survey number survey number 160/2 also not I have applied. Some time may be granted. I will.
So one submission.
I will produce.
1956 andre.
No, that is subsequently sold. Subsequently sold.
One submission. I'm not taking much more notes. I will take my notes to the page number 82 for a moment. Look, this is a sketch.
We'll permit him to take out the sugar cane.
There is no road at all from the petition.
Each ದಿನ ಹೆಂಗ್ ತಗೊಂಡು ಹೋಗ್ತಾ ಇದ್ರು?
ಅವ್ರದ್ದು ಬೇರೆ ರೋಡ್ ಇದೆ.
ನೀವು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಕ್ ರೆಡಿ ಇಲ್ಲ. ಸುಮ್ಮನೆ ಗಲಾಟೆ ಮಾಡ್ಬೇಕು ಅಂತ ಕಾಯ್ತಾ ಇದ್ದೀರಾ?
No, commissioner report ಅಲ್ಲಿ they have clearly stated that there is.
How will you take out the sugar cane, Mr. Teli?
Page number 35. This is the way. Photograph. This is the road. I am only required to get a 5 feet. I was passing my. This is the road, my lords, where I was passing my sugarcane. Now, my lords, after vacate stay was not extended, they have blocked this road. Lords, I will take my lords to the court commissioner report.
In what manner do we pass an order?
Lords, sir, only to pass no notes at the.
Where and the ಹೆಂಗ್ ಐಡೆಂಟಿಫೈ ಮಾಡೋದು?
In their
I had request notes. I will take my lords to the plane.
Commissioner report ಎಲ್ಲಿ ತೋರಿಸಿ?
Hello, commissioner report is at my lords. Page number 82 is a sketch for a moment.
Yes, but that won't allow you to.
Notes, that 81 page number 81 I will take my notes. Notes, RISA number notes from RISA number 161/1 ಇವುಗಳು ಪಶ್ಚಿಮಕ್ಕೆ ಇವು ಅಂತ ತೋರಿಸಿದ ಕುಲ್ಲಾ ಜಮೀನು ಇರುತ್ತದೆ. ದಿಸ್ ಇಸ್ ಓಪನ್ ಸ್ಪೇಸ್ ಆಫ್ ದಿ ಡಿಫೆಂಡೆಂಟ್ಸ್ ನೋಟ್ಸ್. ಸದರಿ ಜಮೀನಲ್ಲಿ ಸುಮಾರು 7 ಫೂಟು ಉದ್ದು 5 ಫೂಟು ಅಗಲು ಕುಲ್ಲಾ ಜಮೀನು ಇರುತ್ತದೆ. ಸದರಿ ಜಮೀನಿನಲ್ಲಿ ಯಾವುದೇ ರೀತಿ ಬೆಳೆ ವಗೈರೆ ಇರುವುದಿಲ್ಲ ಮತ್ತು ಸರ್ವೆ ನಂಬರ್ 160/1 ದಕ್ಷಿಣ ಬಾಜುಕ್ಕೆ ಸೀಮೆಯಿಂದ ರಿಸಾ ನಂಬರ್ 161 160.
When will you remove the sugar cane?
Please.
ಯಾವ ದಿನ ತೆಗಿತೀರಾ ನೀವು?
Cutting, my lords.
Transport, cutting and
Transporting, my lords, by the next month 10, the factors are going to close.
date fix ಮಾಡಿ, time fix ಮಾಡಿ. Avag will permit you.
Please.
ಬರೀ ಆ ಟೈಮ್ ನೀವು ಅದನ್ನ ಬೇರೆ ಟೈಮ್ ಯೂಸ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಇಲ್ಲ, only for the purpose of service. You should get an order from a sugarcane factory. By that time I will take.
ಮತ್ತೆ ಇನ್ನು ಅರ್ಜೆನ್ಸಿ ಪ್ರೊಡ್ಯೂಸ್ ನೀವು ಅಷ್ಟು ಅರ್ಜೆಂಟ್ ಅಂತ ಹೇಳಿದ್ರಿ.
Wherever there is a road access, 151 also not, they have road access, they are property also they have sold.
They will cut sugarcane. From Monday onwards they will cut the sugarcane. From Monday onwards they will cut the sugarcane. That is on the 3rd.
Nobody is coming in the way of you cutting the sugar. When are you going to transport the sugarcane?
They from 3rd onwards will transport.
3rd ಎಷ್ಟು ಎಕರೆ ಇದೆ?
6 ಎಕರೆ ಇದೆ.
ಎಷ್ಟು ದಿನ ಬೇಕಾಗುತ್ತೆ?
12 days. Earlier also this was the lords. Even if my lords, I will take my lords. That is earlier this court has directed them to provide.
Counsel for the respondent submit that he has filed an application for obtaining the certified copies of the sale deeds for RS number 161/1 and 161/2.
Please, 160 my lord.
160/2.
My lord.
160.
60 my lord. 60/1 and 60/2 my lord.
160/1 and 160/2.
Please.
And he submit that it will take about a week's time for him to obtain the same and furnish it. Shri Vithal Legal and counsel for the petitioner submits that the sugarcane being ripe for harvesting, if there is any delay in harvesting and transport, the valuable sugarcane would be lost.
And even more sugar factories are going to be closed from 15th or 10th or 15th of this.
And the crushing season coming to an end.
By the next month, 15th.
15th of February, the petitioner would not be able to make use of the said sugarcane for any purposes. In that view of the matter, the dispute in the above proceedings being restricted as regard the access road, and the considered opinion that considering land of the respondents being empty without any construction, it would be in the interest of justice to permit the petitioner to remove the harvested sugarcane through the property in 161/1 and 161/2.
And 160/3. All together they had came at a single point.
160/3 ನಿಮ್ದಲ್ಲಪ್ಪ.
ಅಲ್ಲ ನಮ್ದಲ್ಲ ಅವ್ರದ್ರಲ್ಲೇ. 161 and 161 they are there.
160 ನಿಮ್ದು.
ಒಂದು ಅಷ್ಟೇ 160/3 is mine.
Through 161
please
ನಿಮ್ದ್ರಲ್ಲೇ ರಿಮೂವ್ ಮಾಡ್ತೀರಾ ಮಾಡ್ಕೊಳ್ಳಿ.
ಇಲ್ಲ ಪಾಠ ಅವ್ರದ್ದು.
ಬೇಡ ಅನ್ನಲ್ಲ ಅವರು. Through 161/1 and 161/1, 161/2 and 161/3 in the place denoted by the alphabet C
please
in the commissioner's report filed in OS number 337 of 2023.
And
the plying of the vehicle is permitted only between 5th February to 8th February.
3 days it.
ಎಲ್ಲ ಎಷ್ಟು ಟ್ರಕ್ ತಗೊಂಡು ಹೋಗ್ತೀರಾ ತಗೊಂಡು ಒಂದೇ ದಿನ ತೆಗೆದುಬಿಡಿ.
I'm not saying, my lords, I'll get 3 days, my lords. Subsequently, I'll get an extension if I could not pass.
6th February to 5th February to 9th February. Released on 10th February.
Please, lords, one submission. Earlier this court directed me to permit, but they did not allow. Even I filed a complaint, they are not accepting the complaint. Earlier, my lords.
They want to put the stone sign mud lay the road.
ಬರೀ ಆ ಸಿ ಎಲ್ಲಿದೆಯೋ ಅಲ್ಲಿ ಮಾತ್ರ.
ಅಲ್ಲ ಅವರು ರೋಡ್ ಮಾಡ್ಕೊಂಡು ಹೋಯ್ತೀವಿ ಅಂತ ಅಂತಾರೆ. ಅಲ್ಲಿ ಕಲ್ಲು ಮಣ್ಣು ಹಾಕಿ ಅದಕ್ಕೆ ಬೇಡ ಅಂತ ಹೇಳ್ತಿದ್ರು. ಹೇಗಿದೆ ಹಂಗೆ ಹೋದ್ರೆ
you will use it as it is at the place to see.
Please, lords, as it is I will use, but anyhow, my lords, pass that.
If you try doing anything, then
no, sir, no, I'm not. Even if my lords I make any, my lords, I will redo. What is the stage?
You can't do that.
Lords, earlier this court directed. They were not permitted me. Only
earlier ಗೊತ್ತಿಲ್ಲ ಇವಾಗ ಇಷ್ಟೇ.
My lords, my moment order. Earlier order, this court has passed a similar order, but they did not allow.
That was before you lost in the trial court.
No, my lords,
Now
before
you
this,
lost.
before this court, my lords, granted an interim.
Yes.
But it's only I direct, my lords, let there be police protection. If that is, I will not change any nature of their property.
84.
84. Yes.
Lord, I request the matter to be taken up on 11th, my lord. Senior counsel, he has
When
said.
are you depositing? Otherwise, we'll pass an order of attachment of all your properties.
My lord,
We have already indicated that.
since he has,
You have been taking time twice. This is not the way to do it.
please, my lord. Or on first, my lord.
The
Kindly have it tomorrow, my lords. I wouldn't even.
state of Karnataka idara party. Deputy Commissioner idara. Respond number 6. He is directed to cause inquiry into the properties owned by respond number 10 and attach the same to the extent of 26 crores. Yes, sir.
Yes, ma'am. Look, kindly have it tomorrow. my lord.
You are taking it for granted.
26
The
crore,
amount.
26.
Where is Mr. Mudod? Mr. Reddy, you are here. Yes, to amount.
26.
3 items, my lord.
In report ಎಲ್ಲಪ್ಪ ಅದು.
$20 crores, 93 lakhs, 3 That is the total amount out of the sale of the sugar.
ಅಲ್ಲ, after the payment to the
After that,
cane growers ಎಷ್ಟು ಉಳಿತು?
the farmers,
ರಿಪೋರ್ಟ್ ಇರ್ಬೇಕು ನೋಡಿ, ಸ್ಪೈಲ್ ಬಾಂಡ್ ಇರ್ಬೇಕು.
78 crores, 9,224 is paid to the farmers. Is 17 of the report.
So 120 minus 78.
Yes.
So 42 crores has gone out. We unaccounted. Cause the inquiry into the properties belonging to respond number 10. Ascertain the valuation thereof and attach the properties of respond number 10 to an extent of 42 crores.
Yes. Just because there was not status quo to be maintained.
Yes.
We did not.
No, we thought they will come forward and pay, but they are not, they are taking advantage.
Immediately we do the yes.
Very adjournment but ಇನ್ನೇನು ಕೇಳ್ತಾ ಇಲ್ಲ ಅವರು.
Oh, Lord.
Relist on 17th February.
The request.
For the Deputy Commissioner to place his report as regards the inquiry made and attachment effected.
Sorry, my lord.
You have done your best. ಅವ್ರು ಮಾಡಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? ತಗೊಳ್ಳಿ. 230 ಆಗಬೇಕಲ್ಲ. ಬಿ ಗ್ರೂಪ್ ಶುರು ಮಾಡಬೇಕಾ? 2006 ಯಾವಾಗ ರಿಪೀಟ್ ಆಗುತ್ತೆ? ಇದು SC/ST ಎಲ್ಲ ಮಾರ್ಚ್ ಮೇಲೆ 41 to 81. Some of them will repeat on 17th. Some will repeat on 18th and 19th.
Serial number 72, my lord.
Interim orders will be.
Serial number 72, my lord. It's
Ah.
covered by judgment, my lord. It's only mandamus. It is
Mandamus.
Yes, my lord.
70.
5 ಗಂಟೆ.
72, my lord.
Who is for respondent?
Survey Kulkarni, my lord.
Yes, madam. Allowed. Allow ಮಾಡ್ಬೋದಾ? 72.
Milords, in that, direction may be issued, milords, to consider. However, milords,
Representation,
liberty may
ma'am.
be reserved to,
I'm seeking
Liberty may be reserved to do what?
milords, urge contentions before the deputy commissioner. They're seeking for damages, my lords, for the period between date of taking possession and 4-1 notification, my lords. As per the award, my lords, it was not taken.
You are lucky they are going there. They are not here.
No.
Petitioner is before this court seeking for the following leaves. The petitioners claim to be the owners of the land in survey number Yavadappa land
Survey number mentioned prayer man. Page number 11.
of various land.
What is passed on, my lord?
Granting certain compensation, which compensation was enhanced by the reference court.
7/4/2011.
The petitioner claims that for lands which are similarly situated, the compensation granted has been enhanced much more than that granted to the petitioner. And as such, a representation had been submitted by the petitioner on 7/8/2018
Yes, sir.
for the enhancement which has not been considered.
This point number 1 is.
It is in that background that the petitioner
That's-
is before this court. As held by this court in MSA number,
Repeat.
MSA number. So whenever any compensation is enhanced, it would be the duty of the state to provide the enhanced compensation to all the land losers who are similarly situated.
One submission. They're not seeking for enhancement of compensation, my lords. It
Damages,
has
my
already
lord.
been enhanced in LAC before the reference court. Now they're seeking for damages, my lords. They say that prior to the issuance of 4-1 notification, land was taken possession of. And for that period, they're seeking damages.
The
And my lords, as per the award,
last two paras were that. The petitioner claimed that even before the acquisition proceedings were completed, possession of the lands of the petitioner was taken by respondents, depriving the petitioner of income from the said property.
it is, my lords, as per the award at para 22, the possession was not taken. Therefore, my lords, I'm seeking for liberty to urge contentions before the.
And as such, a representation was submitted on 7/8/2018 for grant of damages stroke awards. Ms. Surbai Kulkarni, learned counsel for the respondent, would however contend that the possession was not taken over prior
Before
to the acquisition
4-1.
being completed. And as such, no damages or award of similar amounts would have to be made in favor of the petitioner. A representation having been submitted by the petitioner on 7/8/2018, the fact remains that no order has been passed thereon. Even if the respondents have a good ground on merits, it was for the respondents to have passed an order on the said representation, either accepting or rejecting the representation.
Respond number 1.
One, my lords.
Respond
Number 1. Needless to say, if the representation was rejected, the same would have to be accompanied by reasons. In that view of the matter, reserving liberty to the petitioner and the respondent to agitate all the issues before respond number 1, the petition stands disposed. Respond number 1 shall pass necessary orders within a period of 30 days, 60 days,
That's government has.
4 weeks.
60 days from the date of receipt of a copy of this order.
Please, ma'am.
Let's one submission in serial number 44.
44.
Please, my lords, it is adjourned to 17th. My request on 18th, my lords. I appear for respondent.
44/18.
Serial number 81. May I request my lord to kindly have it on 13th of February.
81/13.
Great.
My lord, serial
With the
number.
trustee permission.
Second list. Serial number 15 in second list, my lord.
ಅದೆಲ್ಲ ಆಗೋಗಿದೆ ಬೆಳಗ್ಗೆ.
My lord,
Second list has been completed in the morning.
my lord, serial number 64.
ನೋಡಿ date. Yes.
My lord,
With your
serial number
lordship.
64, matter is infactious, ma'am.
64. Petitioner is before this court seeking for the following. And counsel for the petitioner submits that during the pendency of the above matter, petition has been rendered infractious. Accepting a submission, petition is dismissed as infractious. Yes, madam.
Yes, serial number 51, my lord. Your lordship kindly have it on day after tomorrow, my lord. This is the acquisition in the year 1989, my lord.
ಎಲ್ಲ ಅದೇ ಇದಾವೆ ಏನ್ ಮಾಡೋದು?
But it's a 2017 matter, my lord. Therefore, I am requesting your lordship kindly have it day after tomorrow, my lord. More.
ಬೆಳಗ್ಗೆ ಏನು ಗುರುದೇವ್ ಗಚ್ಚನ್ ಮಾಡಿ ಸಾರ್ಟ್ ಫಾರ್ ಟೈಮ್.
Please,
By
my
1
lord.
week.
Last week also they have took time, my lord.
51 at the request of Shri Gurudev Gachanmat relist on 6th February. It is made clear that no further adjournment would be granted. If arguments are not advanced by respondent number 4, the petition would be taken up for consideration and orders passed on the basis of submission made by the counsel for the petitioner.
Instead of 6th, my lord, it is on 3rd, my lord. 6th also personal inconvenience is there, my lord.
ಯಾವತ್ತು ಹೇಳಿ?
3rd, my lord.
ಥರ್ಡ್ ಎಲ್ಲ ಆಗಲ್ಲ. 6th ಇಲ್ಲ 7th ಹೇಳಿ. ಇಲ್ಲ ಅದಾದ್ಮೇಲೆ.
Monday, next Monday, my lord.
10th.
Please, please.
Serial number 57. Grateful, my lord.
57.
57, my lord. My argument is over in this case.
ಇದರದು ಇದು ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಬರ್ಬೇಕಾಗಿತ್ತಲ್ಲ ಯಾಕೆ?
It is for the respondents to argue the matter, my lord.
57.
Some of the documents are to produce. Next date I will produce documents. So I have collected documents only. Layout plan I got.
57
Allotment
at the
details only.
request of counsel for respondent number 4. Relist on 6th February for further
Yes,
hearing.
please.
Submitting certain judgment in support of that.
ಅವತ್ತು ಕೊಡಿ, ಇವತ್ತು ಬೇಡ. ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಟ್ಬಿಡಿ.
Please.
Number 65. It was dismissed for non-prosecution, recalled, and today date is fixed. I am for the respondent. Some short date may be given. Proceedings.
22. Date ಕೊಟ್ಟಿದ್ದು.
Short. That's why requesting for a short date.
Sir, second list notary ಯಾವಾಗ ಹೋಗಿದೆ? Second list.
ಒಂದು ನಿಮಿಷ.